Good morning, ladies and gentlemen, members of the public. We are here for meeting the standards panel for a hearing this morning. The first item of business on the agenda is the election of chairman. Is there a nomination from amongst the panel?
Do propose Councillor Goodridge.
Thank you. Is that agreed by the panel?
I would second that.
Councillor Goodridge, if you'd like to continue.
Thank you very much. Item 2 on the agenda is declaration of interests. Has anybody got an interest to declare?
Nothing to declare, Chairman.
I haven't. Yes, Councillor Hyman?
Yes, obviously I've got an extreme interest and could make a big difference to my future, and so I would think, but do I have to declare that? Do you have to declare that obviously there's enormous interest for the Conservative Party and your members? Do we have an option of the choice of chairman? Because I would have thought that as a matter of natural justice, Mr. Chairman, if we have a member of the opposition party controlling the meeting, as well as having a majority, then that might provide, in the eyes of the public, and this is a matter of public perception, and standards is a matter of public perception, isn't it? What I'm saying is, if, for instance, Mr. Ward were the chairman, then he might be more open to ensuring that the whole truth is heard, but you'd still have, obviously, the majority on there, but you would still have control over the decision as politically. I had mentioned it a couple of days ago to the monitoring officer that I would be concerned in relation to your position with the Conservatives and your whether you've got an interest there, and whether perhaps we should have an independent chairman. Thank you.
Firstly, I think it's up to the panel to choose its chairman. Whoever chairs the meeting will be ensuring that justice is done and seen to be done, and that's what will happen. If you're referring to the fact, I think in an email to the monitoring officer, that as I'm the chief whip of the Conservative Party, that bars me from chairing this meeting. It doesn't, it's not, I've taken advice, it is not a registrable interest, and so far as I am concerned and the panel, we are happy with the way we're constituted. The next item on the agenda is the publication of non-exempt agenda papers to the press and public. And before I come to that, I understand through an error in the Democratic Services, these papers were published and then withdrawn, and the Chief Executive and the Monitoring Officer have unreservedly apologised for that. Lessons have been learnt, and I apologise to Councillor Hyman for the fact that that happened. So the item, therefore, is there any reason, Councillor Hyman, why we shouldn't publish this so that it's open to the press and public?
No, Chairman, I didn't know I was going to be asked. No, not at all.
Excellent. Well, we'll now, do we resolve to deal with the matter in open? Is that agreed?
Agreed.
Right, if we can turn on the webcast. And if the public want papers they haven't got, we will ensure they have them.
So, Chairman, may I just clarify that I think I was advised this morning by the monitoring officer that one of the documents that I put in should be considered personal and should be an exempt, so if we need to refer to it, we will need to, and that is the Annex 2, isn't it, of my submission?
Yes, indeed.
Thank you, Chairman.
We now go on to my opening remarks, and I wish to make it clear we're here to deal with two complaints brought against Waverley Borough Councillor, Councillor Hyman. The complaints brought by Councillor Isherwood of Waverley Borough Council and the Borough Solicitor. We are here for one reason and one reason only, and that is to decide if protocols, officer member protocol and member protocol, have been breached. That is the only reason for us to be here. We are not going to deal with, and I underline not, dealing with any legal issues in planning or any other legal matters that there may be a disagreement about. We have evidence already in writing from Councillor Isherwood in Annexes 1 and 2 on pages 13 to 15, alleging a breach of the member protocol. We have evidence from the Borough Solicitor, Mr. Bainbridge, contained in Annex 3, pages 17 to 22, which refers to an alleged breach of officer-member protocol. We have statements of the investigating officer, Mr. Oram, and on pages 53 to 77 on Annexes 8 and 9. The independent person's report, Vivian Cameron, pages 79 to 81 in Annex 10. And we now have evidence from Mr. Hyman, which has been added to it. Before I go any further, I should introduce everybody, and I should have done that at the beginning, and apologies. I'm Councillor, for the benefit of those that are not aware, I'm Councillor Michael Goodridge, a member of the Waverley Borough Council and Chairman of the Standards Committee. And on my right is Councillor Band, and on my left is Councillor John Ward. The complainants on my left, Daniel Bainbridge and Councillor Isherwood. Next to him is Officer Robin Taylor, the monitoring officer. Next to him is Paul Hodgson, who is an independent legal advisor. He's the Deputy Head of Legal Services at Hampshire County Council. Because our legal department is one of the complainants, we felt we needed legal advice from a totally independent area. In front of me is Mr. Alex Oram, the external investigator, and next to him is the independent person, Vivian Cameron, and Councillor Hyman, who is the person complained about. What is going to happen is that all the written evidence, including Councillor Hyman's evidence that was received yesterday and this morning, has been read by the panel and will be taken as read. All witnesses will be asked if they wish to add anything today, and then Councillor Hyman will be able to ask questions of each witness if he wishes to do so, as will the panel. After Councillor Hyman has given his evidence with any witnesses, Mr. Oram can ask him questions, as can the panel. The independent person will then give her evidence, which again is written, and Mr. Oram and Mr. Hyam and the panel can ask her questions. Then there will be summing up, firstly by Mr. Oram, and secondly by Mr. Hyman, who will have the last say. We will then, as a panel, retire to decide if there has been a failure to comply with the codes of conduct. And depending on what happens, we will then tell you what goes on after that. So before the evidence is called, I would ask the monitoring officer, Mr. Robin Taylor, who has produced his report in paragraph 5, just to do an introduction, please.
Thank you, Chairman. As you've mentioned, today's hearing relates to two complaints about Waverley Borough Councillor Jerry Hyman, submitted in April 2017 by Mr. Daniel Bainbridge and Waverley Borough Councillor Peter Isherwood. My report at agenda item 5 sets out the full details of the process I followed, as well as the relevant documentation submitted to me in the course of this process. I won't go through all of that detail, Chairman, but I will just briefly alight on a few key points. The Council has a published set of arrangements for dealing with complaints related to the conduct of elected members. My approach has been guided by that document, which you can find at Annex 7 within your papers. Those arrangements encourage informal resolution where this is appropriate and achievable. My view from the outset has been that both of the complaints under consideration today could and should have been resolved fairly easily on an informal basis. Both complainants confirmed at an early stage that they were open to an informal resolution. I clarified this to Councillor Hyman early on and focused my initial efforts between April and July 2017 on trying to bring this matter to a satisfactory informal resolution. I would like to clarify my view that in this case, informal resolution did not rely upon any apology from Councillor Hyman, but rather upon two things. Firstly, a recognition on his part that he had not abided by the obligation within his code of conduct to treat others with respect, and secondly, a commitment to doing things differently in the future. Having not resolved this complaint informally between April and July 2017, I then consulted Ms Vivian Cameron as one of their council's appointed independent persons, and I considered her view prior to making my decision to refer this matter to an external investigator. As set out within the timeline in my report, I procured Mr Alex Oram of CH&I Associates via Hoey and Ainsker Associates, who are specialists in UK standard matters such as these. Mr Oram completed his investigation between the end of September 2017 and the beginning of February 2018. As I say within my report, I was satisfied, and I remain satisfied, that Mr Oram has completed an independent, comprehensive and fair investigation. He has concluded in his report at paragraph 1.6 that Councillor Hyman did fail to treat the two legal officers with respect, but judges this to have been a finely balanced decision, and that Councillor Hyman's conduct should be viewed at the lesser end of seriousness. Mr Oram's report makes it clear that councillors have the right to challenge officers, but must be respectful in doing so. As set out within my report, I accepted these and all of Mr Oram's findings and recommendations in full, without any change, and advised Councillor Hyman, the independent person, Mr Oram and the complainants that this was the case. Mr Oram recommended that Councillor Hyman be given a further opportunity to informally resolve the complaints against him by attending a face-to-face meeting with me and the independent person, and that meeting took place on the 13th of July. In it, I confirmed to Councillor Hyman that an informal resolution relied not upon an apology, so much as a recognition of the impact of his approach on others and a commitment to take a different approach, as I noted a moment ago. I carefully considered the independent person's account of that meeting submitted to me, which is included in your papers at Annex 11, within the context of Mr Oram's report, which had been clear that if Councillor Hyman did not engage with the process in a manner that I considered to be sufficient, that he believed there was no option but for this matter to be referred to a formal hearing. Having taken everything into account, I wrote to Councillor Hyman on the 6th of November 2018 confirming my decision to bring the investigator's report to the hearings panel. All parties, including Councillor Hyman, were invited to submit any further written statements to be included in the papers for today. Councillor Hyman did not choose to submit a written statement in advance, however, he has submitted a statement and a number of other documents within the past 24 hours. In my 6th of November email, and in subsequent emails to Councillor Hyman, I've made it very clear there was still an ongoing opportunity to resolve this matter informally if he felt able to work with me positively and constructively to reach a satisfactory informal conclusion prior to today's hearing. As set out on page 12 of your agenda, I recommend that, having considered all the evidence and heard from Councillor Hyman and from the independent person and everybody else listed in your agenda, that the panel considers whether or not Councillor Hyman has failed to comply with the Waverley Code of Conduct. If the panel concludes that he has, I recommend the panel considers what further action should be taken, if any, and the powers and limitations of the panel in that respect are set out in the Council's arrangements and replicated on page 11 of your papers. Finally, Chairman, as set out within the arrangements, after today's hearing I will prepare a formal decision notice in consultation with the Chair of the Hearings Panel and send a copy of that to Councillor Hyman, Councillor Isherwood, Mr Bainbridge and the independent person Vivian Cameron. I will make that decision notice available for public inspection. If the panel concludes that Councillor Hyman has breached his code, that decision notice will also be placed on the Council's website. If the panel concludes Councillor Hyman hasn't breached his code, I will ask Councillor Hyman whether or not he wishes the decision to be placed on the website. Thank you, Chairman.
Thank you very much. Can I just clarify one thing with you? In some of the annexes, particularly the annexes near the end, there are sort of black markings of keeping information out. I think it is mentioned at the beginning of the agenda, but could you just confirm why there has been those detractions?
Thank you, Chairman. Yeah, so the agenda papers include redacted material for two reasons. The first reason is that there was, in addition to these two complaints being considered today, a third complaint that was investigated at the same time. That third complaint was not upheld by the external investigator, and so it was closed by me as the monitoring officer on the 29th of May 2018. The content related to that complaint is not relevant to today, so it's been redacted. The second reason is that there is a small amount of material relating to individuals within the paper. Again, that's not relevant to the complaints, and so it has been redacted.
Thank you very much. Right, are you happy? Is everyone happy with the procedure and where we're at now? Shall we get on with the evidence? Councillor Hyman.
Thank you very much, Chairman. I have spoken to the monitoring officer and written and put in a few questions about the procedures and spoke to him this morning as well about it. I'm still unclear. I was told a few days ago that I could call witnesses, and I gave a list of people that I would like to ask questions of, and the response that I obtained was that have I asked those? I need to ask those people if they would be witnesses. Now, I'm still completely into the dark as to whether I will be able to ask questions of yourselves, the panel members, the claimants, or any particular people. You did say at the beginning that I would be able to question witnesses. I don't know whether that means question any witnesses which I've called, and I don't know whether I've called any, because I don't know whether the list that I put to the monitoring officer is actually a list of witnesses I wish to speak, I would wish to question. I haven't prepared for it because I thought I wasn't going to be able to. Effectively, if I don't call a witness, I've got no right, and I was told that the complainants did not have to be at this meeting, and if the complainants don't have to be here, obviously I've got no right to question them. I'm very pleased to see that they are here, but I've no idea. I mean, you can appreciate it makes it very, very difficult to, if you don't know what the procedures are until afterwards, it's very difficult to know how to prepare for such a thing, Chairman. Thank you.
Can I make it clear? Well, firstly, I would refer you to page 49 of the papers, which sets out the procedure for local hearing. And broadly speaking, if you wish to call a witness, you get them here. It's not our job to do so with the greatest respect. But Mr. Taylor, would you like to deal with this question?
Only to confirm that Councillor Hyman was advised that he was free to call witnesses and make those arrangements himself.
Chairman, may I have an answer to the question as to whether I will be able to question the people who are present here? Would I be able to question the monitoring officer? Would I be able to question the complainants? Or would I not? It's one of those questions I don't think there's an answer to, Chairman.
Well, it's up to Mr. Oram. I think if you look at the agenda on page 10, top paragraph, it says statement of Mr. Oram, who will present his report and statement and call any witnesses which may include either or both of the complainants. So I'm sure the complainants would be happy to answer questions if required to do so. But it's up to Mr. Oram to present his case so far as the external investigation is concerned. So far as Mr. Taylor is concerned, if there are any questions of Mr. Taylor, now would be the right time to ask them.
Okay, I'm trying to understand. I think what you're telling me there is, having referred to the top of page 10, that if Mr. Oram calls the complainants as witnesses, then I would be able to question them, but if he doesn't, then I won't. Am I correct in that, please? Because obviously, if I'm going to broach matters, I want to know when or where I'm going to get the opportunity. It's a little bit difficult to wing this, Chairman. Thank you.
Well, I want to ensure that justice is done, and I'm quite happy to ask Mr. Oram if he's happy that they be called so that they can give their evidence. They don't need to give any more evidence. In Chief, we've got their statements already, as I've mentioned at the beginning. But have you any objection to, because it seems to be under your control, as to whether the two complainants are going to be giving evidence?
I was not intending on calling any witnesses, Chair, but the two complainants are here.
and I don't think it's unreasonable to ask them whether they'd be willing to take questions from Councillor Hyman. I personally have no further questions for them at the moment, but obviously that may change if they agree to be questioned by Councillor Hyman. Thank you.
Thanks very much. I would suggest, subject to the panel's agreement, that the complainants actually bat first and then you bat second. It would make more logical sequence. So I think what we'll do is...
Begging your pardon, Chairman, I'm just thinking if that happens first, obviously, from what I've said, I think you can assume that I haven't prepared on the basis that I will be able to question the complainants, because it effectively been, it looked as though I wouldn't. I didn't ask them to whether they would be witnesses, because obviously they're the complainants and they're not going to say yes to political opposition. So you know, I assumed that, as it had been said to me, that they didn't have to be here. I wouldn't be, that I wasn't going to get the opportunity, so I haven't prepared for it. But I raised it this morning. I'm pleased. Thank you very much indeed, and I do support, obviously, provided they're willing to, that I will be able to question. But if we could leave it till after Mr. Orham's done his introduction and the rest, then I would have a little bit of time to think about it, so I can prepare, perhaps. Would that be okay? Rather
I'm quite happy to do it.
Yeah, thank you, Chairman.
You know, it's a pity everything's been left to the last minute, because certainly the procedure for arrangements for dealing with standards allegations is a public document that you could have seen months ago. The papers were sent to you a week ago, with pages 49 to read, which you could have done. You could have rung Mr. Taylor a week ago or 2 weeks ago or a month ago and asked him, taken his advice as to what you're allowed to do. Therefore, I'm afraid the fact that you have left it to the last minute and therefore aren't prepared for this hearing, which was arranged prior to Christmas, so far as I'm aware, is I'm afraid, your problem, not the panel's. But the Monitoring Officer, Mr. Taylor, wants to add.
Simply, Chairman, to say that point little 2 at the top of page 10, questions from or through the Chair put to the investigating officer and any witnesses, which may include either or both complainants. I think that gives you the place in the agenda that Councillor Hyman is looking for to raise any questions for either of the complainants. The complainants were not required to attend. They were invited to attend, but they didn't have to attend. And that is why the wording is what it is within the agenda. But there is sufficient scope within this agenda for you to put forward questions via the Chair to the complainants.
Right, let's get moving. We will deal with Mr. Orham first to give you more time to think about questions you may want to ask the two complainants.
Thank you, Chairman. May I just put out, because I do think I'm allowed to respond, that I received these on Saturday, so that's 6 days ago, these documents, and I was entirely unaware of all of the annexes and stuff that was at the end of those. Obviously, I'd seen the report of Mr. Orham, the investigating officer. I was fully aware of that, and I'd put in a considerable amount of effort in responding to that. But it's a massive job if you're obviously unaware of how the system worked. And I was completely unaware of, who the chairman was going to be and that sort of thing, what constraints, as to whether it was simply worth doing anything about this. And, I'm learning, aren't I? First time for everything, Chairman, thank you. But,
well, you presumably received, just for clarity's sake, you have received the bundle of papers that I received, no doubt, with all the pink papers, including page 49 in it.
Yes, no, just clarifying that I didn't have the information months ago, Chairman. I mean, it's not as though that, I know this process has taken a long time, but that's, I haven't had the information for months. I've had the information since Saturday. And I didn't realise that there was no indication whatsoever in advance that these documents, which have been around a long time, were going to turn up. I didn't know they existed. Thank you, Chairman.
The Council has policies, procedures, all in the public domain for you to look at if you wish to. Anyway, let's get on so that we get things moving. Mr. Orham.
Thank you, Chair. As you've already stated, everybody present has had the opportunity to go through the papers, so it's not my intention to sit here and talk you blow by blow through my report, which can be found at Annex 8, page 53. but I think it would be useful just to touch on a couple of elements. Obviously, the scope and focus of my investigation were complaints submitted by Mr Daniel Bainbridge, the Council's Borough Solicitor, and by Councillor Peter Isherwood, Chair of the Council's Western Area Planning Committee. The complaint from Daniel Bainbridge related to Councillor Hyman's conduct at the Council's Joint Planning Committee on the 16th of November 2016, and a meeting of the Council's Western Area Planning Committee on the 29th of March 2017, and Councillor Isherwood's complaint also related to the conduct from the 29th of March 2017. Both related to his conduct towards officers in that he failed to treat them with respect and undermined them when being critical of them during the meeting. The relevant legislation is covered for you on pages 57. And then I've set out my evidence as I found it from pages 59 through to 68. I don't intend to go through it in any more detail at this point, but it may be obviously the elements of it come up during later questioning.
Thank you very much. And also, you've got also an extra statement, I think, on Annex 9.
I have. I mean, just to touch briefly on why we're here. In considering whether Councillor Hyman's conduct was a breach of the code, in the first instance, I'd like to make clear that it was not within the remit of my investigation to ascertain the veracity of Councillor Hyman's comments about the legal advice that was offered. Indeed, I don't have the necessary expertise to do that. What was important to me was whether Councillor Hyman's challenges to those officers were made in good faith, or whether he was just being deliberately malicious in an effort to undermine them. My own view, having met with Councillor Hyman, is that he's clearly passionate about this issue. He's clearly knowledgeable about this issue. And as such, I felt that his questioning and challenges at the meetings were questions and challenges made in good faith. And that was important to me from an ethical perspective. Having said that, while ideas, policies, recommendations and advice may be challenged and criticised, individuals should not be subject to unreasonable or excessive personal attack. The investigation established that Councillor Hyman went slightly further than challenging the advice offered, in that he publicly accused 2 officers of providing incorrect legal advice and one of misquoting the law and trying to portray an inappropriate assessment as an appropriate assessment. In my view, the forum and the manner in which Councillor Hyman did this was unacceptable. As you can see in my report, my suggestion to Councillor Hyman was that these concerns and queries be raised privately with the officers outside of this public forum, so that the matter could be discussed properly. I got the impression that Councillor Hyman felt that that was an example of the council not wishing to wash their dirty laundry in public, and he felt that his belief that unlawful decisions were being made superseded his responsibilities to treat officers with respect. Again, while stressing that I haven't considered the veracity of his concerns, I would argue that the two are not mutually exclusive. I would draw the panel and Councillor Hyman's attention to the probity and planning advice offered by the Local Government Association and the Planning Advisory Service. And if I can just give that advice now for the panel. Councillors and officers have different but complementary roles. Both serve the public, but councillors are responsible to the electorate, while officers are responsible to the council as a whole. Officers advise councillors and the council and carry out the council's work. They are employed by the council, not by individual councillors. A successful relationship between councillors and officers will be based on mutual trust, understanding and respect of each other's positions. I think that's slightly lacking from Councillor Hyman in relation to the matters relevant to this investigation. I would further point out that the guidance states, If a councillor is concerned about an officer recommendation or aspects of their advice, they should discuss these areas of difference and reasons for it with the officers in advance of the committee meeting. Again, I think that Councillor Hyman has demonstrated by his conduct a reluctance to do that, and instead a preference to make these challenges publicly and in a manner that risked humiliating officers that are there to provide their professional advice to the committee. And I will conclude there. Thank you.
Right, Councillor Hyman, do you want to ask any questions of Mr Oram?
Thank you, Chairman. Yes, if that's okay, if you don't mind. I have to face you, don't I think, rather than make it which is probably easy because my paper's here and I'm looking that way. So if I'm not looking at you, yeah, I'll have wonky eyes by the end of this. Thank you very much for the part that you played in this. I've read through your report. I didn't bother making, I mean, there were an awful lot of things I could have commented on after you put the submission in, but you'll appreciate this when you've got a large document like that. And I have actually, I mean, I have been through and put notes on the end of each of them, and I did this in November, but I wasn't given a lot of time to get a report in. You appreciate that if I'm opening myself up in the chamber here to questioning from, you know, which could be from anyone, I'm totally unaware of I haven't spent all my hours searching Waverley's website for everything that I ought to know in life. I apologise for that. There are other things in life to do. But as far as I'm concerned, I think you appreciate from the beginning that, you know, I do consider this to be, I think the word that is used in the Code of Conduct is vexatious. I did tell the monitoring officer when I was elected that as the leader of the Farnham Residents Group, then I was going to get picked on. I was expecting vexatious, we have plenty of vexatious.
Councillor Hyman, could we get to questions rather than a statement? You'll give your evidence in a minute. Can you just concentrate on asking questions?
Yes, thanks. You are aware that the first place, I'm concerned I'm being told all the way along by people that I've held this matter up and I'm being evil, or I'm trying to avoid the thing. Well, I was given options in the first place of submit or, you know, basically been told all along, submit or that we'll exert control over you. I don't like being bullied. I know there are a lot of residents and a number of other members of this council who feel exactly the same way and do have the same difficulty I have in getting information. But you have to rely on the information you're given by the council. You have to assume that to be true. Is that correct?
In regard to this investigation, obviously the evidence is set out in the report. Primarily, I relied on the recordings of the meetings where your conduct was relevant to this investigation. I've been given no reason to disbelieve the trustworthiness of these recordings, and I don't think you challenged at any point that you made the comments that were attributed to you. And it's on the basis of those comments that I then made a reasoning as to whether the code was breached or not. I mean, as you're aware, there are, in the background to this, and having seen your recent submissions, clearly there's an underlining dispute regarding a planning issue in regards to this matter. And as I've just explained, my recommendation or my consideration that you failed to comply with the Code of Conduct was based not on the accuracy of either party in terms of that planning advice. It was about the way that you decided to make your concerns known in the public forum during the committee meeting.
Right, thanks. So, the first thing that you did, I appreciate the first thing that you said today was that it was not within your remit to check for yourself the veracity of the legal issues at stake here. And you understand that the point that I'm making is that there are laws in planning, so when we're in a planning meeting, there are laws which override the Code of Conduct in as much as I have to obey those laws. The Code of Conduct will be secondary to the laws of the land, Waverley's Code of Conduct. It does not take priority over when it comes to the crux. You know, if you're at a point where you're saying, which one is it then? Normally you need both. I would accept fully that you require both. You know, the code of conduct should be adhered to at all times, and as far as I'm concerned, I don't think there has been a breach of the code of conduct. But legally, as far as I'm concerned, I have a right. I've put the documentation in, and if you would, if you don't mind, ask the lawyer who's available for you, very kindly come along today to help us out, whether or not that responsibility does lie on me, because that's important. If you're thinking, well, no, I'm just making
Can we just have a question? You're in fact asking the question whether the law of the land overrides the code of conduct. Is that the question you're asking?
I think we ought to start from the beginning, because I think I might just get a blank. I don't want to lead anyone up the garden path. If we could start with where I've got in the annexes, I've got to find it, the very last one I think it is, or last but one. I've got an awful lot of paper here. I don't need that. There's two documents which are Annex 4, and at the top, Mr. Oram I don't have a page number because I didn't clip them together. It quotes the habitats regulation, so it's the last. They pulled the penultimate piece of paper, but the last annex that's there. Yep. At the top it says habitats regulations, and the habitats regulations have changed since.
You're not going to be asking.
No,
you're not
Chairman,
going to
I
ask
have to
him
give the
questions
background
on
because
the. Can you let me speak? You're not going to ask him questions, are you, about his views on the habitats regulations or things of that nature? Because that's not what we're here for.
I'm asking Mr. Oram whether he would ask the lawyer that we have with us whether the principle at 9.5, and I was trying to explain, Chairman, that I know that the regulations have been updated since 2010. There's the 2017 regulations, but it's effectively the same within Regulation 9, that every competent authority, every councillor, when they are in a planning meeting, in the exercise of any of their functions, shall have regard to the requirements of the Habitats Directive so far as they may be affected by the exercise of those functions. What it's saying is that at meetings where there is an application affected by the Habitats Directive that comes under the directive, then we have a responsibility to consider legal compliance and our position, and we have a responsibility to consider the law. So if we start there, can I ask that question? Can you ask that question?
No, you
is
can't.
that correct? Really, Chairman, we're not allowed to know whether what's being done is lawful?
Can I make it abundantly clear on one or two matters? Firstly, that Mr. Hodgson is here as an independent legal advisor to advise the panel and everybody present on the procedure for this alleged breach of protocol hearing. He is not an expert. He may know a lot about it, but he's not an expert, so far as I'm aware, on planning legislation. He's not here to tell this panel or advise this panel or the hearing as to whether or not habitat directives are legal, illegal, whether the council's done things legally or illegally. He's not here for that at all. And the panel is not here either to listen to whether or not legalities have been complied with by this authority. I should say that since Mr. Oram's investigation, we have had a workshop on the matter, which is referred to in your report, and we have had a barrister's opinion on all these matters, which has been circulated to all councillors. But that is a side issue and is not an issue before us today. We are purely dealing with the protocol. Now, if you are asking the question of Mr. Oram, which I think you are asking, which is, if the council is doing things illegally, that will override the protocol. Therefore, I can, if you like, breach the protocol because the council's acting illegally. Is that right? We can ask that question. Okay, so you just understand that the Conservative whip is going to tell me what questions I'm allowed to ask. I am not here as a Conservative whip. I'm here as the chairman of the Standards Committee. And it has absolutely nothing, the fact that I'm the chief whip of a political party makes absolutely no difference to this hearing at all.
Perhaps I'm going to have to go back a little bit more to the beginning. I thought that we could make some reasonable assumptions, Chairman. If we can refer you, please, Mr. Oram, to page 3 of the documents, which hasn't got a number on it, but I can't complain, mine haven't. It's the third paragraph down, it's a yellow agenda page at the beginning, and it says today's panel has been convened to consider the report from the external investigator to establish the facts about this situation. Yeah? Establishing the facts means getting to the truth of the matter, doesn't it? So that we could, because you need to make a recommendation, this is my understanding, you'll make a recommendation. And before you make that recommendation to the panel, you'll want to be certain that you're doing the right thing. Can I assume that's correct?
Yes, that's correct. But could I just draw your attention to the fact that when it refers to facts, it talks about facts relevant to whether you have breached the code of conduct or not. And as I've clearly stated in my report, the veracity of your concerns regarding the planning advice is not relevant to whether the code has been breached or not.
Thank you, Mr. Oram. Now, I've noticed in your report, you've said, and I'm going to have to find it, I'm not going to have time to go through all the documents I've got there, but somewhere in here, paragraph 6.4, if I can refer you to page 71. And it says, the circumstances in which the behaviour occurred are relevant in assessing whether the behaviour is disrespectful. For instance, obviously, if I was being punched in the face constantly and said something nasty in return, then I wouldn't be guilty of a breach because the other person was doing worse. In fact, I mean, you wouldn't expect me to be the person who was picked upon and in front of the standards board in that case, would you?
In those circumstances, and that is an extreme circumstance, that would certainly go into consideration. However, in terms of the conduct of others, that's normally considered a mitigating or aggravating factor to breach. Councillors have a responsibility to treat others with respect, regardless of how they perceive the conduct of others.
Absolutely. But if I was being treated with extreme disrespect and had been for 2 or 3 years, unaware, to you obviously, because we're not looking at previous times of other events, and we haven't been looking at what's been going on over the past 20 years. That's not the subject here, but the circumstances that we were in at the time. Would, for instance, if I was asking a question of an officer, a question I'd asked many times, and I was unable to get a response to that question, and that question was a requirement, a pre-requirement to me doing my duty. If I had to have the answer to that in order to be able to meet my duty, but I was not being given an answer to that question, wasn't being given a straight answer to that question, then would you consider that to be an important consideration in whether or not I was in breach of the code? If someone else was basically trying to wind me up, for instance, by simply being totally disrespectful to me, of course, by not answering my questions, but if that was the instance, if that was the case, would that make any difference to your determination?
There would firstly be an objective consideration of your conduct. So regardless of the conduct of others, your conduct would be looked at objectively, and we would decide whether that was considered respectful or not. Having done that, then there would be mitigating or aggravating factors taken into account when considering what action should be taken in relation to that conduct. Now, in this regard, I believe you're suggesting that the officers involved have effectively guilty of dereliction of duty in relation to not providing you with advice on which you can make lawful decisions. I would suggest that the council has procedures in place to deal with complaints made about officers, including allegations that they have not responded appropriately to questions, and that it is those procedures and policies that should be followed rather than trying to publicly undermine them during the meeting.
Thanks. I think if I used the word dereliction of duty in respect to the council, I'd be up in front of the standards panel, Mr. Oram. But yeah, I'm having difficulty here because, I'm trying to work out whether it makes any difference. I appreciate your role as an independent person. You're not here to help me get off of something if I'm guilty, and you're not here to help the council to slap a gagging order on me, which is seen in public perception, if it would not be fair to do so. So you need to know which way it is, but unless you know whether the unless you can check the veracity of the council's position, are you in a position to be able to know whether, for instance, that I am exposing a huge scandal, and your role in it at the moment would appear to public perception, to people watching the webcast, might think that, well, we're not allowed to talk about the truth, and we're not allowed to look at the situation that we're in at the time. We're not allowed to consider that whether or not what was being done was unlawful, or whether we're covering up a massive fraud, or whether we're harming people, or compromising the environment, or whether this is going to be a huge waste of risk to public funds as a consequence of the recommendation that you are making to this hearing at the conclusion. I mean, there may be unnecessary sacrifice of our heritage, our culture. It might be about ruining our borough, and I might be the Lone Ranger coming in on his horse and trying to save the situation, and I'm asking a question in the chamber, and it might appear to people at home, which worries me, because I met you at my home, and you're a really nice guy, and you've done everything properly, and it's not within your remit to do. So I've got no criticism of what you've done. I'm just very sorry you've been dragged into this, frankly, but you get paid, so I'm not that sorry. I don't get paid for it. I have to do all of this. If someone wants to make, they could spend their lives making complaints about, vexatious complaints about me, and I just have to give up my entire diary to anybody who does it. You understand that? They have complete control over me. They can bully me as much as they like.
Can we have a question?
What I want to know, would it make a difference to you? Would you want to know whether you, if you were recommending that, that there were sanctions against me, would be seen to be supporting something that's unlawful, fraudulent, and all the rest of it? Or would you have to know first? Because that's, as far as I'm concerned, you should know before you make a recommendation what you're letting yourself in for. If there's likely to be criticism or whatever, if the public know better than some people in this room as to what's going on, and if you thought that there was a 300 million or £2 billion fraud associated with this, which is being covered up by the council, and I'm the whistleblower.
Where are we going? Look,
would you want to know the truth? Would you ask the lawyer for advice to see whether I'm correct or not? Because I want to get to whether or not I'm correct in what I'm saying in those meetings and what I'm saying now. Because I put together Farnham residents on the basis of we're going to bring truth to this place. I'm not allowed to come here and lie. It would destroy everything that we've got and built. It was very successful. I just want to know whether, where we're being told here, there's an assumption that I'm not telling the truth. There's an assumption I'm wrong. There's an assumption that I'm being really annoying in the chamber because I don't know what I'm talking about and I'm just harassing them constantly and they've got to shut me up. But if it's, and that does look, well, if you don't know what the law is and the laws that are governing our actions in terms of decision making in planning, I can understand that. I have to get really tough in that chamber because if you want to get answers out of people...
Can I phrase a question on your behalf, Mr. Hyman?
No, please don't.
Which I think is what you're getting at. If the legal officers had given wrong advice to the council, would that justify the way that Mr. Hyman dealt with it in the council meeting? Just assuming that.
Well, I'd word it slightly differently. If the complainants were covering up a multi-million-pound fraud, in sort of the wild extreme, but whatever, if it made a big difference, and that was being covered up, if I had shown that been proven correct over a number of times, but was completely being blocked and had to be shut up by those people, and that's what this was all about, would it make a difference to what you were to the recommendation you've made?
I think I've made it fairly clear in the report that the veracity of your concerns has not been relevant to my consideration as to your conduct in relation to whether you breached the code or not. I am reassured by the passion that you're displaying on this subject today, that my interpretation that you have serious and significant concerns and that you made these allegations in good faith was well founded. I do not have the expertise. I do not believe the panel have the expertise to consider the concerns you're raising. What I would say is that the problem that I have with your conduct at these meetings is the manner in which and the forum you chose in which to raise these concerns. Now, I haven't been presented with any evidence at all to suggest that you've tried to raise these concerns privately in the past, that you've gone down the appropriate routes in terms of either challenging the advice being offered or making complaints about the relevant officers. Instead, you chose to present them in a forum where that evidence wasn't able to be presented that you're talking about, where a full discussion on that evidence wasn't for that time and that place. As I stated earlier, if you have concerns about the legal advice, that should be raised outside of the meeting prior to these considerations so that it can be properly considered.
That explains quite a lot, because I thought when we chatted, I thought I'd been through some of this, and I'm a little bit surprised that you haven't been told the background to this. The question here, actually, you do draw our attention at 6.8, if I can turn to page 72. We say on page 72 that halfway down, Mr. Devlin and Mr. Lucas was, I was publicly accusing of providing incorrect legal advice. Well, I was questioning advice. If that's taken to be publicly accusing someone, you know, I get publicly accused of things every day, and we get really upset about it. But I don't know whether we've got a snowflake generation or something like this, but that's here now. But if you can't question somebody, I think it's difficult. Do you stand by what you say at the very last words of paragraph 6.6, as Lord Lamming stated in the Victoria Climbier inquiry? Councillors must not accept at face value what they are told. Is that overriding, or do you think that's unimportant? Because I think that seems to me to have been ignored. And if you simply read that bit, we wouldn't be here. We wouldn't have wasted any of the past 2 years.
For fear of repeating myself, I do believe that is true, but as already stated, there are policies, procedures in place within the authority so that these matters can be dealt with by the relevant people in a manner that isn't leaving a councillor effectively undermining and trying to humiliate these officers in a public meeting.
I do apologise, because I can see where the problem is now. And I had seen it from here that you haven't been given the background to this. I take it you're unaware that in 2006, when this particular legislation, environmental law...
It's not relevant, Mr. Hyman.
I'm sorry, but I've just been told something by Mr. Oram, which is actually incorrect. I.e., that let me go back to my notes. Actually, I can't remember exactly what it was that he said. I didn't jot it down. The issue at hand, as far as I'm concerned here, is that I've been proven right. I was proven right in 2006. I was proven right again May last year by these judgments. And Mr. Oram and Miss Cameron have, from these documents, quite clearly been misled into believing that I'm wrong. So the council's all the good guys, even though there's an admission in the communications between the monitoring officer and Miss Cameron that I had been proved right. There was a document written in the summer, which was a couple of months after I'd managed to bring things to a halt again, temporarily only, because of the Sweetman judgment. And it was admitted there at the time that I was right. But the council has continued to tell Mr. Oram and Ms. Cameron that they are complying with the law. Well, it's absolutely clear.
If I take that as a question, sorry if I've caused any confusion, I will again repeat, the veracity of your concerns aren't the issue here. in terms of whether you failed to comply with the code or not. I have not made any comment on the validity of either party's argument in relation to the planning matter.
Okay, so as far as this is concerned, it's a done deal then, because if they make a complaint, if they can act as they can do whatever they want, they can. The public at home have seen, and it's the whole reason that Farnham Residence exists. We put it together in order to clean up this council because of the disgraceful behaviour over many, many years that was perceived by the public. And we've been elected in here to do something about it. And when we try to do something about it, when we've been proved correct in the past, we then get shut up, we get bullied. I mean, two of our councillors, who were first elected in 2015, Councillor Fraser and Councillor Williamson, were bullied terribly by the opposition. Of course they were. A horrible situation for them. And we have it all the time. I don't know whether you've had an opportunity to go through the webcast over the past few years. I don't expect you to want to look at them. I don't know whether you've seen the webcasts.
Have we got a question?
It has obviously been withheld from you that when I have challenged the council on numerous issues, I'm not talking about legal challenges through the courts, because that is a last resort which we haven't been to yet and haven't needed to, but we may need to now, it would appear. Has it not been made clear to you that actually I've embarrassed the council on numerous occasions because they've proven them wrong? I stopped their £30 million stock transfer attempt in 2004. I stopped the local plan in 2006.
Mr. Hyman, this is not within the knowledge of Mr. Oram.
But
the fact
Mr.
of the matter
Oram
is,
has
you
made,
make sweeping remarks that the council has been doing things illegally.
I'm happy to answer any questions when it's time to ask me questions.
You ignored council's advice when it was which we received in December, which actually said the council were right and, with greatest respect, you were wrong.
Mr. Chairman, I have got that with me. You're referring to the advice of Wayne Begland, where I asked the question, do we have to have convincing objective evidence to satisfy Waddensey? And the answer was, we have got it. Now, Mr. Begland has no right to say we've got something unless he's going to produce it. It's not an answer to a question. The answer to the question was, yes, you do have to, and you haven't got it.
That is not the issue. This panel has one decision to make, or two decisions to make,
and it's already been made, Chairman, has it?
On the complaints. That's all we're here for. We're not here to rummage through what has happened in the past, legal veracity of whether the law should be applying this way or that way on particular planning applications. That is totally irrelevant, which is why I asked the hypothetical question to Mr. Oram, that even if you were totally right and the council were totally wrong, which I don't accept was the case, but if it was your conduct acceptable in those circumstances? And you've got the answer. So therefore, it doesn't really matter, does it, whether you are right or the council's legal department were right. The fact of the matter is, your conduct of respect, lacking respect, is alleged to have happened. And that's what we're here to decide, whether or not you have been sufficiently respectful to officers of this council, who from the very nature of an officer can't answer back. They just get asked to give advice, and they're not in the political forum of being able to have a set to with members.
Mr. Chairman, what you've just said there is completely upside down, isn't it, surely? It's I who, when the chairman decides I'm not allowed to talk about something, we're not allowed to discuss whether what you're doing is lawful or not, and whether I'm right or wrong, or whether you're covering up fraud. We're not allowed to talk about any of that. You're telling me that the officers have no ability to come back. They can jump into a meeting and are allowed to say anything they want at any time. It's the members who don't have the opportunity. It's us who are controlled. I can have a member of staff sit there and say to me that they can say there and they say, Mr. Hyman is wrong. without putting together anything, completely ignoring the questions they're asked, just simply blanking, as they've done for the past 20 years and been proved, and I've proven them wrong time and time again over that, as you're well aware. And I have to sit here. The residents at home that I represent have to sit and watch their webcast with me being gagged here by people who are telling me that it doesn't matter how bad this bunch of people are, do not stand up to them. I'm being told that if we get Farnham residents or other independents elected into this chamber, they are going to be gagged. They are going to need to spend a load of money to bring their own representation along. And you know what I've always said to people and relied upon is the fact that if they're right, they'll be okay. As long as they tell the truth, they're okay. I've ensured our people, when they were elected in 2015, when you're in there, just tell the truth. You'll be safe. And what I'm being told now is, actually, my premise is I've misled people. That premise is completely wrong. You can have vexatious, anybody can come along if they don't like the way that you put things, not the words you say, if they don't like the way that you say it. And of course, you know, beauty's in the eye of the beholder. Anybody can decide they don't like things if they don't, you know, they don't have to give any justification for it. We then end up in a kangaroo
You're going to have
court.
your opportunity of speaking, Mr. Hyman.
Okay, thanks.
The
Well, I think I've explained to Mr. Oram where I am.
Trying...
I want to move on, actually, if I may, to going through Mr. Oram's comments in his report. May I do that, Chairman?
Well, yes, but get on with it.
Thanks. Well, Chairman, you've wasted years of my time. And Mr. Oram, you were aware. You were aware that in the first place I was told of this on the 13th of April 2017.
I have no recollection of exact dates on that, I'm afraid.
And I was asked to come in for a meeting. I wasn't allowed to be told what it was. I was just told of serious complaints against me and that I would need to come in. And I said, no, I'd complained about that system because I don't see why the monitoring officer should withhold from us what the complaints are and just make us sit and stew until he gets back from holiday, which is what happened because the monitoring officer was away for a fortnight and I came in the first opportunity on the 25th of April and, on the and then opened the papers that he had given me when we came here. We sat down, he gave me the papers and I had to go away again and he told me to have a think about my own behaviour. And, you know, obviously I knew at that point that it had already been decided in advance. But when I got to, I looked at them the next morning and I just knew it was a complete waste of time and a wind-up and you know, trying to undo a lot of years' work that I was put together. I then went outside, did a bit of weeding to calm down, had a heart attack. And went into hospital for months. And I think here I'm being complained. Do you think it's unfair if there is any intimation taken from what anybody has said or in here that is unreasonable, you know, that I was holding things up? Because I had a heart attack from what was putting in front of, well, 2 hours after I'd opened the thing. No connection, obviously, between them. I'm not saying that. But, you know, is it okay to, do you think, for people to make out that I haven't been... as communicative as they would want, that I've got to jump to whenever anything comes in, I'm under somebody else's control. Do you think that that's what this standard system expects of me, to be controlled by others, that I have to do what they say, regardless of my health?
It's not really within my ability to comment on the council's handling of this. The only thing that I really am in a position to comment on is the communication and the cooperation, your cooperation as part of my investigation. And the only evidence I can offer on that is that you were fully communicative, if I can not say that, and cooperative with me and fully cooperated with the investigation.
Thank you very much. I mean, I did notice I'll pick up actually in my speech another issue that was there. Let me move to paragraph 611 on page 73. I did ask this. I don't know whether you've been, just as a matter of clarification for me, in case I'm missing something. Footnotes 16 at the bottom of page 73 says, can you refer to paragraphs 310 to 313? And when I go back to those, it stops at 38. And I just assume that's a typo.
It is. Apologies for that. It's a ruling from Heatham versus Public Service Ombudsman for Wales that I've referred to in more than one report, and I believe that I must have cut and pasted it from a different report.
So it's not here at all? Yes, sorry.
No, the paragraphs to which that footnote relates would normally be the sections of the Human Rights Act that are relevant to freedom of expression, and I failed to include those in this report, so I can only offer my apologies for that.
Okay, so you would normally expect us to have that information in front of us, would you? I mean, should I look at those now?
It's just the legislation that talks about freedom of speech, which is in the Human Rights Act. It says little more than that. The detail around freedom of speech is offered in paragraph 6.12 of the report.
So you don't think we need to cover that? It's in here. It's already in here. There's not a. I'm not being prejudiced by not knowing something that you would normally tell other people.
I don't believe so. No.
Okay. I won't be fussed and demand that we have it in front of us or anything if if you're satisfied we know enough.
Well, just to check, you're aware of the Human Rights Act and freedom of expression. That it exists.
Yeah, yes, but
Okay,
the fact that it exists, obviously I know it exists. Yes. HESAM's very interesting, isn't it? Because it says here that I represent my electorate. I draw attention to their preoccupations, defend their interests. And you understand I'm saying I should be allowed to continue to do that, and that this order would prevent that. Do you believe that this order would prevent me from doing that, or do you not think it would affect me?
I don't think it would prevent you from doing that.
If I was unable to come into the chamber and ask questions about in planning meetings, in respect of, we've had lots of different things where I have highlighted things that people right across the borough, residents right across the borough, have been very happy, particularly Aarons Hill's issues and flooding issues in Cranley. If I'm not allowed to query them, do you not appreciate if I'm not allowed to query the officers and be a little bit persistent, I'm not able to get at the things which perhaps other councillors who aren't so persistent or don't have the same knowledge aren't, they're not going to get to it, and so our decision making isn't as good. So as far as I'm concerned, if I'm asking questions and not making personal remarks and I'm telling the truth, I should be okay. As long as I'm not making personal comments saying, you are or I don't like your attitude, or, the things that other councillors say, if you've watched the webcast. I don't say those things. I'm very careful because I have to try and get information. I'm very forthright, of course, and I have to be. And in certain circumstances, for instance, where I said the word, the first complaint was where I said a single word. What was the single word I'm being complained about in the first complaint? Can someone remind me? Oh, nobody knows. Yes, actually, I was rather hoping someone would.
If you're looking at, you can deal with that with Mr. Isherwood, but I mean, Councillor Isherwood is saying that you suggested that some of the advice given by the lawyer was incorrect.
Yes.
Part of what he said in his complaint.
There was a point, wasn't there?
On page 13, if that helps you, Councillor Hyman.
Oh, so that's why I can't find it. It's right at the beginning. No, I was actually looking for it in Mr. Oram's report in the actual. Yeah, misquoted. Isn't it? That's the word I used, misquoted. And that's there's nothing wrong with the word misquoted, is there, Mr. Oram? Can I allowed to say that?
The issue here, Councillor Hyman, is absolutely you're allowed to challenge. You're allowed to present your alternative view. The legal officer is able to give their professional advice, and then members of the committee can decide on which they wish to place weight. It is unfortunately you might refer to it as persistence in not allowing members to do that, but insist on pursuing the matter in a public forum, which is why I consider you've crossed the line in your conduct.
So, Mr. Oram, there's an assumption there that if I took those questions outside the chamber, I would get an answer to them.
It would be hoped that you would, and as I've said previously, if you felt that the officers were not fulfilling their responsibilities to address those properly, then there are complaints processes and that are available within the authority that would provide for those matters to be dealt with in the appropriate forum.
Okay, so you assume that eventually, if I'm correct, the council will admit that I'm correct on a point rather than they would keep denying it forever. There would be a way of me getting a straight answer ultimately to a simple question like, for instance, you've said in here that the crux of the matter here is the issue of the appropriate assessment. You've managed to obviously understand enough of it to see that that's what I'm querying, the content of the appropriate assessment set out in law. If it was absolutely clear that our appropriate assessment didn't have what the law said had to be there, you would expect that at some point I would be able to get someone in the council to say absolutely right, it's not there, is it? We need to have the bird numbers, they're not in there, we'll correct that, we'll get them, we'll redo the assessment. Thank you for the information, Mr. Hyman.
There's a presumption in your question that your legal position is correct. My understanding is that your legal position has been considered by the authority and it's been disagreed with. But again, I'm straying slightly outside the remit of my role in addressing that.
But who's telling you that the council is correct? I mean, when I've been found correct and they've been found wrong so many times, and there's legal judgment from last year that makes it absolutely clear that what Natural England and the council have been doing was unlawful for 10 years, does that not seem a little bit odd to you that they can then turn around to you and say, but we haven't changed anything we're doing, but we're now acting lawfully, when they've already admitted that they were acting unlawfully and the judgment did apply and they had to change their ways?
Details of any of that haven't been considered as part of this investigation. As I've already stated, this investigation has been focused on how you presented your concerns at the 2 meetings and on your conduct. And I think, it might be helpful for the panel if you could not only focus on your perception of the conduct of others, but perhaps reflect on your own conduct as well.
Yes, it's important to do so. I mean, I have to ensure that I'm correct in telling the truth in what I'm doing. I don't think is there any suggestion from anyone around here that I'm not abiding by the law in any way at all. I mean, I've been asked to consider whether you failed to comply with the code. My reasoning is set out in the report as to why I think you have. I've indicated that it's not what I consider to be at the greater end of seriousness. I think it's very important that councillors with your undoubted intellectual abilities have the ability to challenge. So I would suggest that drawing in criminality is way beyond anything that has been suggested, certainly in my report. So if we are, because I should obviously, you're absolutely right, I should look at my behaviour and everybody else should do the same. I'm not the only person who has to look at their behaviour, obviously. And, in a situation like we're here, it's not just me on trial. I mean, there is an element that you could make a recommendation that that having considered all the evidence, you considered it vexatious, the complaint, and you hadn't realised in the first place, and that you would recommend it be dismissed.
Hyman, can we try and keep the point?
Just to be clear.
If there are any fresh questions, please ask Mr. Oram on fresh, so we can't go round and round in circles. It's not doing you any favours. Again,
just to be clear, it's not my role to consider whether the complaint is vexatious or not. My role is to make an objective assessment of the facts in relation to the complaint. Those facts were apparent to me in terms of your conduct, which is obviously the focus of my investigation. the recordings of those meetings?
Okay. If I can refer you, I've already referred you to paragraph 6.6, which you state, in considering whether Councillor Hyman's failed to comply with the code, a line must be drawn between the requirement for members to treat others with respect and the freedom members have to disagree with the views, opinions and actions of others. It's your view that members should be able to express in forceful terms, which I fully admit I do, because I'm representing my residents and they expect me to. It's what I was elected for. Concerns about any of the aspects of the running of the council or advice being provided to them by officers. So I'll just repeat that. It's my view that members should be able to express in forceful terms concerns that they have about any aspect of the running of the council or the advice being provided to them by the officers. But there seems to be a bit of a contradiction because I feel I'm hearing that I'm not allowed to question the advice. And then, as Lord Lamming stated in the Victoria Columbia inquiry, councillors must not accept at face value what they are told. So if I'm asking, I mean, this says that if I say to an officer in this chamber, can you just confirm to me that we've got bird numbers, you need bird numbers in an appropriate assessment and they're there, that officer's going to give me an answer and I'm entitled to be forceful and not accept their answer if I know it's untrue, the answer they're giving. If they say, yes, it is, and I've got the document in front of me, as has happened, and I can take you to the webcast, I'd be happy to, because this is what is happening. I'm saying, have we got the bird numbers in that appropriate assessment? Because there's a legal judgment, Commission versus Greece, that applies to us and everybody else who draws up appropriate assessments. It must contain the bird numbers. So I've asked the lawyer, have we got the bird numbers? And our lawyer said, yes, we have. And you go to the document, it's not there. How far am I, in that situation, how far am I able to push before it becomes rude? Can you explain that to me? Because I don't seem to understand it.
It's difficult to talk in the abstract, but I think I've suggested at the top of paragraph 6.8, while ideas, policies, recommendations and advice may be challenged and criticised, individuals should not be subject to unreasonable or excessive personal attack.
Can you explain to me which actual words were excessive personal attack in your opinion?
You were given
point me to that?
You were given the opportunity at the meetings to put forward your own view. When that wasn't accepted by the legal officers, you started accusing them of misquoting the law, of providing incorrect legal advice.
Sorry, okay, no, we can take this one at a time, please, because I'd like to. So where you're saying the unreasonable or excessive personal attack was using the word misquoted, saying that the law had been misquoted. Did I say you are misquoting the law, he is misquoting the law, or that person's trying to mislead everyone by misquoting the law? Or where was the bit that's being considered an excessive personal attack? Because I can't see the actual words that I used that justify any such conclusion. I
think the evidence as set out in my report is clear and my reasoning behind it. You can have a difference of opinion with that, and it'll be for the panel here.
Sorry, Chairman, it'll
be for the panel here to decide whether you've breached the code or not.
Thanks, Chairman. Can I ask that I'm being accused here of making unreasonable and excessive personal attacks, and the whole thing seems to bear upon that issue, and I'd like to know which words it was, because as far as I'm concerned, I was stating facts, and it's my duty to do so in the chamber. And if I'm being accused of it, I want to be absolutely clear. So I understand. I mean, I don't want to go away from here feeling that I've been done an injustice. And I'm sure you wouldn't want members of the public to, the public perception of this to be that it's just nobody's going to answer the questions even in here for me. If I ask whereabouts are the words which prove that there was an excessive personal attack, can we go to those, please, and identify them, Chairman?
Could I suggest you look on page 17, which is Annex 3, from the Borough Solicitor, who puts in direct quotes of what happened at the meetings in question, 17 and 18. And I think...
which words is it that are a direct excessive and personal attack.
Well, you're talking about, you said misquoted. So far as
Misquoted is a direct personal attack, is it?
It's up to Mr. Oram to say, but Mr. Oram, looking at the, as I understand it, looking at it, all the dialogue that occurred, and having heard and watched the webcast, came to the conclusion that there was failure of upholding mutual respect.
Yes, but Mr. Oram said that there's unreasonable behaviour here, and I'm just trying to identify it, because surely, shouldn't we be justifying this, or is this just a complete waste of time where I'm not going to get an answer to a straight question? I'd like to know, because I came here very hopeful, actually, this morning, Chairman, that if I was able to explain to the independent person and the investigating officer, I assume they're absolutely independent. I know that Mr. Oram's paid by Waverley, but he's done this role many, many times. And as I say, we met at my place, and he's an absolutely straight-up guy. And I've had a great deal of, even though I hadn't been able to prepare properly, I thought that speaking to Mr. Oram, he would be helpful in ensuring that we get to the truth of this, and that we, that the panel's able to make a very balanced decision on whether what I actually said was good or bad, because most members of the public sat at home would read 6.6, the Victoria Climbier bit, and they'd read F on page 74, if we go to that. And they'd think that this is just a complete stitch-up, because I haven't actually done anything which is anything nearly as bad as what you're allowed to do. And I'd like to address that point, Mr. Oram, if you wish. If I can turn to page 74, and my rights under Article 10 of the Human Rights Act. We'll start on page 73, the very bottom of 73, where it says that Article 10 of the European Convention on Human Rights protects not only the substance of what is said, but also the form in which it is conveyed. So it protects the form in which it's conveyed, the mannerisms. It says, therefore, in the political context, a degree of the immoderate, offensive, shocking, disturbing, exaggerated, provocative, polemical, colourful, emotive, non-rational, and aggressive that would not be acceptable outside that context is tolerated. I don't have to read that list again. I can't see a word. I mean, you fully appreciate, obviously, that when you come into the council chamber here, you've got the role. You told us from the.
Let me answer the question, shall we?
Yeah, if I can just finish the background, Chairman, if I may.
Not really. Let's keep succinct questions. It's question time, not your speech time. Okay?
You quoted from the planning guidance, PAS Local Government Association guidance there. And our role in the chamber is different to the role of the officers. Our role is to represent the electors, and the officers are to represent, advise us, their role is to represent the council and the council's interests. So that's a confrontation, isn't it? The two of them, it is by nature a confrontational system.
It depends whether the requirements of the constituents is different from that of the council.
Absolutely, and you understand in the planning context, which is what we're looking at today, that very often the government's position, which the officers are putting forward because it's the policies and the system that they have to stick to, is directly the opposite to what most of the public, or certainly the objectors, want, because that's the way planning is. Yeah, you've always got somebody who's going to complain about it, but it is a very confrontational system, because you've got on the one side councillors and on the other side officers, and they're representing completely different interests that are at odds with each other very often. That is the case.
They can be at odds with each other, absolutely.
So when you're looking at paragraph C here and you're talking about what a councillor is able to do, my own view, quite frankly, is that this list of what you can do here would be actually quite inappropriate in a planning meeting. That's not really describing what I can do. It might be unfair to say, oh, look, as long as I don't go to as far as provocative, exaggerating, polemical, all the rest of it, I'm fine. Even if I do, I'm covered anyway, but if I just stick below that, obviously there's no problem. Because I have to judge what I can say in the chamber and what I can't. When I'm being blocked, I have to judge, how am I going to address this in order to be able to try and get an answer and represent my resident properly, and the council's interests as well. In your opinion, I didn't in any way go anywhere near any of those words, did I? Or was my behaviour, which would you say?
No, to be absolutely clear, and I'm hoping it comes across in the report, this is a very finely balanced decision relating to whether the line that's considered acceptable has been crossed or not. Now, I've given my view based on the evidence I've seen. That's set out in my report. The Standards Committee, and part of the role of the Standards Committee within a local authority, is to decide what the best culture is for their organisation. And to an extent, they have the ability to interpret what these words mean when they're looking at the Code of Conduct and they're talking about respect and matters of that ilk. And so the Standards Committee here can listen to your arguments and make their own decision. I've made a recommendation because I did consider it very much at the lesser end of seriousness, and I know how passionate you are about this. My concern about your conduct was the forum in which it occurred, primarily. You suggested to me that you felt that discussing this matter behind closed doors was not the most appropriate route to go down. I disagreed with you on that, and that's where that line for me is.
But you would accept today, if I'm unable to get an answer or resolve any of these sorts of matters in a meeting with officers, where then and if I'm unable to, I mean, you do accept that I had asked for advice from officers and meetings and hadn't been able to establish or arrange a meeting. I mean, obviously they want them to be a big gang of the lawyers there if they meet, so you've got to try and make a lot of diaries meet up at the same time. That's what I was told by the lawyer that I asked when I was trying to put the meeting together. But also Councillor Andy MacLeod was also unable to.
He can't give evidence about that.
Is that in your report? Did I read somewhere? Councillor MacLeod had also asked for... and are you aware that the workshop event that you thought was going to sort everything out, and so we'd be in a position when we came to this meeting, which is what I've been saying all along, if we come to this, we need to have the law sorted. We need to have all of that sorted out the way behind us. We shouldn't be here, really, still wondering why the council is saying I'm wrong when they've admitted I'm right. Or, if you want to look at it from the other point of view, why am I saying that the council is wrong when they keep telling me over and over again that they're not? But of course, I've got the legal judgment on my side, because the legal judgment in Sweetman is pretty clear, and in the communications between the monitoring officer and Vivian Cameron, those were raised, and in fact the monitoring officer admitted that I was right, and I'll address that when we look at...
Suggest you give your
Vivian
statement
Cameron's.
later, Mr. Hyman. Have we got any more questions to ask? We've got to finish today, if we can.
We've got to get to the truth as far as I'm concerned, Chairman, and I'm very disappointed that I'm having trouble actually getting any consideration of right and wrong in this decision, because we should be looking at what is the correct information here, what is true. Very
as far as our hearing is concerned, the evidence is on the webcast. The evidence has been looked at by Mr. Oram. We're dealing with the protocols. We're not dealing with anything else. And as I understand it, you accept what's on the webcast, because you can't exactly disagree with what's on the webcast, but you disagree with its interpretation as to whether that was respectful or not respectful. Is that where we're at?
No, I am actually... I'm saying that the circumstances of this have not been explained properly to Mr. Oram, and I apologise if because I have tried. Mr. Oram's made it clear at the end of paragraph 6.8, Chairman. He says that it was, he says, in my view, it was at this point that Councillor Hyman's conduct became unacceptable. And that was where it says that I publicly accused Mr. Devlin and Mr. Lucas of providing incorrect legal advice.
Quite.
How can you explain to me, please? You know, if I was in a public area where I can only serve my residents properly if I'm asking the questions in public because I can't get them in private. I can't get them outside of a meeting, outside of a meeting like this or whatever. And so in public, I have to ask an uncomfortable question of council. It's obviously a question that's uncomfortable to the council, and I can't get advice. If I feel I am getting incorrect legal advice because I've got the law in front of me and it says the opposite, it's what we're being advised there, then is there can you suggest a circumstance, a way that I can do that without actually giving anybody the opportunity to say that they're being accused of giving incorrect advice? How can you question something without someone taking the hump if they want to? You know, I mean, offence is taken. You do agree, do you? But offence is taken, not necessarily given. People don't necessarily have to say anything for someone to take offence.
I agree. There are two parts to that question. The first is, and as I've stated throughout, my recommendation would be for those discussions to happen in private.
And if they're not possible, how do we do it? I mean, I'm taking that out
Let him
because
finish
we've failed.
the answer, please, Mr. Hyman.
Thank you, Chairman, but I'm asking the questions, aren't I? Is this just
No,
a
we're
waste of
listening
time,
to the
Chairman?
answers, and it's questions through the chair, if you don't mind, and if a witness is giving their evidence, we will not interrupt them.
If you believe that you've been unfairly treated in terms of seeking advice, as is recommended in the local association's probity and planning, then, as I've stated already, a complaint about that office failure to give you proper support should be submitted and so that it can be dealt with in the appropriate forum.
You're telling me there is a way for us to get information? I've spent 10 years trying to get answers to certain questions, and you're telling me that there's a magical way which works for people that we're unaware of.
I'm simply telling you that there's a route to take your concerns if you believe that an officer is not acting appropriately. In terms of getting answers to your questions, I don't have the necessary information surrounding that. But in similar circumstances, I suspect it's not getting the answers that you want rather than getting any answers.
If I can take you to paragraph F on page 22. It says that past cases draw a distinction between... Sorry, page 22 of the report. It's page 74 of the papers, Chairman. It's got two numbers on it. It's my fault, I read the wrong number. Past cases draw a distinction between fact on the one hand and comment on matters of public interest involving value judgments on the other. As a latter unsusceptible of proof, comments in the political context amounting to value judgments are tolerated even if untrue. Well, again, not necessarily relevant to a planning meeting, but this does stress that whatever situation it's in, if you are stating fact, if you're right, then there is a lot more room for movements than if you are wrong. Is that putting it simply? That being right means that it's very difficult for you to be accused of poor behaviour if you're the person who is in the right.
I think it's actually making a slightly different point, which is that even if you're not in the right, if you've made those comments in good faith, then there should be some allowance for that. Okay. And so if I'm in a meeting where I'm making comments in good faith, so if I'm absolutely right, I'm 100% protected, aren't I? Because obviously I'm right. And the only barrier I have to leap over is the one of am I doing it in good faith, which is a lower barrier. That's It is, but I would also draw your attention to paragraph H, of that section, which points out that civil servants who would be akin to officers of the authority, unlike politicians, they are involved only in assisting and implementing policies, not making them, and as such they must enjoy public confidence in conditions free from perturbation if they are to be successful in performing their tasks. And therefore it may be necessary to protect them from offensive, abusive attacks when on duty. Now, I'm not suggesting that your comments were significantly offensive or abusive, but I have expressed the view that, in my opinion, they slightly crossed the line.
And thank you for that. And that that issue was at the point where I portrayed an inappropriate assessment as an appropriate assessment. Is that correct?
Where you accuse the officer of doing that.
Right. And well, I have trouble here understanding the difference between an accusation and a statement. A statement of fact, you know, there is no information in that document about bird numbers. That's what we're talking about here. At what point is that an accusation? Because as far as I'm concerned, if we have the right, if we must not accept at face value what we are told, that seems to override everything. Am I right about that? That there really is the primary issue here. We do not have to accept. I mean, I know I've had plenty of advice in planning meetings from this current chairman saying that we have to take the advice of our officers. It tells us we must not accept at face value what they're told. We have to question it. How, if I question something, can I be absolutely certain that I'm not going to have someone say, "You're questioning me, you are insulting me"? Because that's what I'm getting here. Can you understand? That is my position, that if I ask a question, I have the right to ask a question, and therefore I have the right for them not to turn around and cry about it if they're trying to cover up certainly if they're trying to cover up the fact that they can't answer the question or whatever.
The officers are tasked with advising the committee, and they are the professional officers there to provide the professional legal advice. If you've got concerns about the validity of that advice, then as I've read from the guidance, you should raise those concerns with the officers beforehand and not try and publicly undermine them. You can state in the meeting subsequently that you disagree, but to question their professional abilities at the meeting is I believe, going or that they're applying the wrong legal tests, etc.
So it doesn't. We must. When you say we must not accept at face value what we're told, actually you're saying the opposite. We have got to accept it. I think that's what you just told me.
No, Councillor. It's about the forum in which you present them and the manner in which you do.
Any new points, Mr. Hyman? Because I think it's time you wrapped up your questions.
Will I have the opportunity to question the I need to ask.
Sentence. What are you asking?
Well, I need to ask. I need to ask some questions of the complainants, Chairman, and but I don't know whether that.
If it assists, you did ask the question earlier whether we'd be happy to. I am happy to answer questions. I don't think I answered that question yet earlier. But
because otherwise I'm going to have to get to the point.
We'll get to it once we finish with Mr. Oram.
Well, I am trying. Chairman, you see, it would be a lot easier, if I may explain, it would be a lot easier if I wasn't being blocked in getting answers. You've basically set rules here as the Chairman, and you're telling me that we are not allowed to look at the circumstances. Well, it's in these documents, we must look at the circumstances, but we're not allowed to.
I am telling you, and from advice from the independent legal advisor, Paul Hodgson, which confirms my understanding of it, we as a panel are here to deal with the simple, what should be simple facts of whether at the particular meetings referred to, you breached the protocol or not in not giving respect to officers and councillors, particularly officers. That's all we're here for. And what you've heard from Mr. Oram is that even if you don't like the legal advice you've been given at a meeting, and you think that your knowledge is
Chairman,
superior to
may
theirs.
I, Chairman,
Wait a minute.
Because these are legal judgments, and you're implying that I'm wrong. You're saying, and you think because you were a barrister for a while.
No, I'm not.
At some point, or a lawyer, the fact that I have been proven right here, and the position you've taken over many years has been shown wrong by these judgments, and I'm being judged by you when you're the one who's wrong, and you're trying to cover this up with
everybody else. A little bit of respect, Mr. Hyman. No, the protocol applies
Chairman,
today.
I want to get to the truth here, if I may.
So are we. Now, have you any further questions of Mr. Oram? I said at the beginning...
Yes, I want to go back to exactly where I was at the beginning, because we have gone round in circles, because, I just keep getting the answer, it's not our remit to look at that today.
And that is the situation, Mr. Hyman, and it's not going to change.
You're saying that my defence... I have absolutely no defence here because the decision's already been made, because we're not going to be allowed to look at the circumstances. We've got advice that says we can look at the circumstances.
Let me make it clear. This panel has not made its mind one way or the other. What we have is the report from Mr. Oram. We are here purely to deal with whether there are any alleged breaches of the protocol. We are not here to decide whether you are legally right, the council is legally right, the barristers who've given opinions, and they're only opinions, are right. We're not here to do that. But it's the procedure that members have at meetings with officers present, how you treat your fellow members, how you treat your officers. And Mr. Oram's view, having read the webcast, and his view, that you went over the line. Not seriously, but you went over the line, and in particular with reference to paragraph 6.8 of his report. Now, that's his view. You cannot ask Mr. Oram about all the background of this borough council, because he doesn't have it, it's irrelevant, and all he is looking at is whether there's a breach of protocol. He's given his opinion. That's the only place we're coming from. If you want to have your, quote, day in court to sort out whether you're right legally or not, this is not the right forum for it.
I'm not saying that it is, Chairman. What I'm saying is that at the beginning of this document on page 3, it says to me that we're going to establish the facts about this situation. And I did think that perhaps we'd be able to do that rather than just a pretense of some sort of proper process and democracy. I've made my position clear, Chairman.
The facts we're looking at is the facts concerning an alleged breach of the protocol.
Yes, okay.
That is the
we
facts
started
we're
here,
looking
Chairman.
at.
Chairman, we started here. Let's try and get this done as fast as possible then, because I put down 5 points here. If I can work through this, and we'll just get answers to these and we can go home. Because obviously, if everything's been decided, there's no point in me trying to tease out any of the, the extent to which we're allowed to look at the circumstances or whatever. I'm just going to find out whether the independent person is going to give me some help here in establishing whether I am correct in the
position. Get to the independent person, we can ask those
I'm sorry,
questions.
the investigating officer, I meant,
right.
Chairman, that was my mistake. Would you please mind asking your legal advice, because I do fully appreciate you don't have the legal advice, but I'm not allowed. I understand I'm not allowed to have legal advice here. The opposition can, but I'm not allowed to. I'd have to pay for it myself, and I'm certainly not going to tell everybody who wants to stand for Farnham residents as an independent that they've got to go and get. Be prepared. If they're going to stand, they've got to be prepared to get vexatious. Complaints against them, and then they're going to have to.
Can we do the last questions?
So I'm asking you if you will please help me out here by getting this clarified for us, and that is whether it was my duty in the chamber to look and question these issues. Habitats regulations at the top of Annex 4 I took you to before, where it says where we have to have regard to the directive. Will you please ask Mr Hodgson if he will confirm to us that...
I'll ask Mr Hodgson in a moment what role this hearing has, because I think that might be helpful. You don't obviously...
Is my defence allowed to be heard then, Chairman? Can I get an answer to... it's going to be really quick and easy if we can just deal with these simply rather than people saying, oh no, let's not do that, we'll go around it sideways.
I've told you the procedure at the beginning of the order that people are going to speak. Now, you are challenging, if you like, the fact that this panel can't go into the background about habitat directives.
No, Chairman, only a matter of what was my duty at that meeting. That's what I'm questioning.
Well, what he has said already is that you have every right to question an officer and to say that you have a different view, but it must be done in a respectful, non-adversarial way. In other words, you say, with the greatest respect, Mr. So-and-so, I think the advice that you've given the committee is incorrect, and suggest that the perhaps correct interpretation should be A, B and C. That is the way to ask the question, and not to be disrespectful. To say to an officer, you have given incorrect legal advice, you are misquoting the law and trying to portray, etc., is a wrong way of doing it. No one is suggesting, and this panel, I'm sure, would not suggest, that any party or any person at a planning meeting or any other meeting should be shut up from asking questions and challenging advice given. It's the way it is done that's the important thing, and that's why we're here. The way it was done.
Sorry, Chairman, did you just say that I said you have you have given incorrect legal advice? Did I say that to an officer?
Look at paragraph 6.8 of Mr. Oram's report. That's what he has found. Page 20. (72 overall).
I'm not the only one who can make that mistake. Good. And it's... Okay, so... I didn't say, it doesn't say there that I said to officers, because I was questioning, I was just worried there because I thought, if I said that, I'm wrong and I have to apologise. If I said to the officers, you have given... I mean, that's fairly personal to say you have done this and you have done that, isn't it, if you start bringing in a personal rather than just addressing the information. Because, I try to address the information. I try to be fairly careful. I didn't say you have. So where you said that, where you've just intimated that I said to our lawyers, you have given incorrect advice. I didn't actually say that, did I?
Well, I'm only reading from Mr. Oram's report, which quotes, and in that he publicly accused Mr. Devlin and Mr. Lucas of providing incorrect legal advice, and Mr. Devlin is of misquoting the law and of trying to portray an inappropriate assessment as an appropriate assessment.
Yes, and I think what I'm saying is that I was challenging the officers, but I wasn't making a public accusation, was I?
That is what Mr. Oram... Having looked at
so
the
can I ask Mr. Oram, do you accept that saying that the way you say that I've publicly accused them, but I did challenge them, would you accept that the point that I'm making there, that I didn't actually accuse them of anything? I was challenging their information.
My interpretation of the evidence watching the footage was that you were challenging the validity of their... Were you not challenging the legal validity of their advice? You think their advice was correct and you weren't challenging that? Is that...
Yes, that's what I'm saying. I was challenging. I wasn't accusing them.
So you didn't, you weren't suggesting that they'd provided incorrect legal advice?
I did suggest that their legal advice was wrong, because you can't really question it and without suggesting that it is, can you? If I'm questioning something, any question is a suggestion that it's that it might be incorrect. Is it not?
I think I've made it clear in my report that I felt that you went too far in saying that the legal advisors were misquoting the law, that they were trying to portray things as things they weren't, and therefore providing incorrect legal advice.
And if I was absolutely correct about that, and was trying to find, if I was correct that an appropriate assessment, obviously in law isn't appropriate unless it has particular content. So, and that somewhere in law I've seen in the past, some wagers called it inappropriate, and I don't think that's unfair. Is there something unfair about me saying? It says it's difficult to formulate a question here because I didn't know the process and I was unable to really put all my questions together. But where you say here that I am publicly accused Mr. Devlin and Mr. Lucas of providing incorrect legal advice, are you saying that accused is the right word, or would you change to the word that I would prefer, which is to challenge, because I'm entitled to challenge? Was it an accusation, or would you accept that challenge is a better description?
My interpretation was that it came across as an accusation, but obviously the panel can make their own considerations on that, and I'm sure they've heard your own view, which was that that was not your intent.
Chairman, can I ask whether Mr. Orum's evidence there can be backed up with the webcast? Can we watch the webcast of that? To see, because if he's saying that, I would like to query, if I may, where he thinks that I was accusing them rather than challenging them. Is it possible for us to watch that? Because I don't know anybody who seems to think I was.
We can do. I'm conscious that it's 1:10. We're going to have a break for lunch.
Good.
I would like to get Mr. Oram disposed of is the wrong word, dealt with and finished before lunch. I'm concerned that we're not going to finish today the way it's going at the moment.
Chairman, if we could do this, the easy way, if I could just get an answer from from your advisor as to what my duty was in the chamber, we could move on. I'm afraid I'm having to go round in circles because.
Right, let's do that. Mr. Hodgson is sat quietly, and could I ask him, please, to tell us what the role of this panel is today and what is relevant and what is not.
Thank you, Chairman. In terms of the role of the panel today, it is, as I think you've already summarised, to look at the question of whether there has been a breach of the code based on the facts that are set out in the investigation report, and those facts clearly relate to the matters that were said at the meeting by Councillor Hyman. So that is the focus, and really it is about, largely boils down to the manner in which these things were done and said in the meeting, not all of the background and the rights and wrongs of the particular planning issues. So the panel needs to focus on the issues of what was said by Councillor Hyman. Do those amount to a breach of the code? If they do, what's the appropriate action?
Thank you, Chair. I mean, that's very helpful for a start, but obviously it doesn't answer my question. That was, you wanted the explanation of what we're doing.
You just ask him then the one question you want. I don't want to...
Well, I want to take that a little bit further, Mr. Chairman. Well, I was hoping we could get there quicker rather than having to go through your route. But you say it's all about the manner. It would be helpful, as far as you're concerned, then to look at the webcast of these, because then we'd be able to look at the manner in which I was. If it's manner that is there, then I'm not sure whether I know that the independent person, Ms. Cameron, hadn't had a chance to look at the webcast before we met back in the summer.
Right.
I don't know whether she has
the way
now.
forward is this. But clearly, Mr. Oram has given a view as to his interpretation of the webcast. What we'll do is we will, I think, let's look at it after lunch. First thing, after lunch, we'll look at the particular webcast relating to the incorrect legal advice.
My question to if I may, to Paul Hodgson through yourself and through Mr. Oram, is in respect of our duties. Does Mr. Hodgson agree, for a start, that the Sweetman judgment there, which he's seen, and the terms of the Habitats Directive and Circular 0605 are my priority in those meetings. We have to abide by them because Regulation 9.5 says so, that it is a duty of members it's very simple. I mean, I feel I shouldn't have to go back to such basic principles, but that we have a duty to the law to ensure that we are compliant with this legislation, and therefore to question, as Lord Lammy has intimated, that we have a duty to question the responses that we get from our officers, even if it looks like we're being accusational or inquisitorial. That is our duty, to make sure that we are complying with the law.
Thank you, Chairman. I think this point has been summarised probably very well by the Chairman, in that members do have duties to question and scrutinise, and quite wide latitude in meetings to do that. But the crux of this is the manner in which it's done, not whether the point was right or wrong.
I'm sorry, can we have a little bit more clarity there? Was that a yes? Where I say, is it our duty to ensure that we are compliant with this legislation? And so, because obviously where I'm leading to is that if we have some evidence, or if we believe there is firm evidence that the advice that we're being given is incorrect, then should we persist in order to, however much the resistance, however much we've got someone sitting there saying, I'm not going to answer your question because I can't answer that, was I in a position at that time that I would have to continue, that I ought to continue and persist because my duty is to obey the directive and the other laws which govern our decision making?
I think we're in danger of me starting to give evidence in this, and I think it's the duty of the local authority to obey the law in its decision making, of which members are a part. So I don't really think that's a question I can answer, a hypothetical question about whether you had a duty to persist in that situation. I think the panel will look at what did you actually do, and did the manner of what you did breach the code or not? And that's really it.
So
okay,
we put the code above the law then, in that case?
It's your interpretation of the law, Mr. Hyman.
I'm sorry, I've got quotes here. Actually, this isn't my interpretation of the law, Chairman. This is the law. Could we ask the lawyer then whether this is my interpretation, whether I wrote this stuff, or whether it's actually the law? Because we do need to clear up this. This is ridiculous.
And how it applies to a particular planning application, because it's a little bit more than what
which is set out to us in the judgments, yes. Exactly. That's what it says. It's not me, Mr. Chairman, that's interpreting the law.
And I assume, therefore, you don't agree with the barrister's opinion when he talked about, which we had before Christmas, when he confirmed that we'd complied with Sweetman ever since that judgment came? You don't agree with that either, presumably.
Okay,
But we're not into that.
No, Waverley's website says the opposite, actually. Waverley's website tells us that the Sweetman judgment had forced us to look at our approach, obviously change our approach, change it in order to be compliant in future. That's what it says.
Exactly right.
So
case law, I don't need to tell you the law, but case law adds on to statute law, and so when a case is decided, it adds to, we in this country we don't have like a French code where everything is in one place. We have statutes, and then case law adds to those statutes, interprets it, and gives guidance. Therefore, this council has fully complied. I think what is being said, we fully complied with the law. When Sweetman came in, various changes were made to ensure that post-Sweetman we fully complied thereafter with what was then the way to do things.
Chairman,
that doesn't mean prior
this
to
is important
Sweetman,
because, well, Chairman, no, what you've just said is, with the greatest respect, is rubbish. Because I know that's what you're being told, and perhaps you don't understand the situation. I expect that you have an in-depth knowledge of this. But I've got on this bit
Mr.
of paper,
Hyman,
Circular
I think
06.
it's now time for us to adjourn. You're getting to the
for you
stage
decide
of
that we're not
personal
allowed to
attacks on me, which I'm not prepared to listen to.
Chairman, may I explain? Look, I apologise, but I've had 2 years, I've had 10 years of this, where people come out with statements and then you're simply not allowed to question them about it. I mean, you've tried to just tell us that we were doing everything lawful, when you've got a decision that turned around and said you haven't been doing it lawfully, and you've managed to spin that for this hearing. Which covers a serious
This is a serious allegation you're making, Mr. Hyman. I would suggest you are very careful.
Absolutely, Chairman. Absolutely serious. That this cover-up for the past 10 years is extremely serious. There is an extreme danger to the bird species. I mean, what happens if this summer, after more snow, there are no birds left alive on these heaths because the numbers are dwindling? And you've been caught out on it. And we're about to wipe them out. You can see, why aren't they giving us the bird numbers? Because they're almost wiped out.
Thank you, Mr.
And
Hyman.
it's a cover-up, Chairman.
Thank you, Mr. Hyman.
We
are going to adjourn
lunch.
now for lunch. I would suggest we have half an hour and come back at 10 to 2. And we will look at the webcast as soon as we come back. We will then carry on. You can ask a few questions to the complainants. I think you asked Mr. Oram, and you covered every point you could possibly cover with Mr. Oram, and then we'll move on after that. So thanks very much. We'll adjourn until 10 to 2.
Well, it depends where I get answers. It's 10 minutes, but plus whatever time it takes if they're never going to answer a question, Chairman. It's very difficult. Chairman, may I also ask if we can, in my submission, I put in a link to a similar one, which might well be a case of me, actually, perhaps. I had thought that perhaps I should ask for another 20 cases to be taken into consideration, because obviously, the sorts of things that I'm being accused of as here, I've continued doing. But there was one issue, and I put a link in, and I wonder whether we could go to that as well. I did put it in my evidence, so just if we can do that as well, that'd be great.
Let's deal with that when we get there. What I'm keen to ensure is that we get through. Yes, Mr. Bainbridge.
Sorry, Chairman. Happy to answer questions. I think at the beginning right at the beginning of the hearing, you said that there would be an opportunity to say anything that we may want to say, or I may want to say. I have got very briefly 2 or 3 minutes that I wanted to say, just in terms of the context of my complaint. And then happy to take questions.
You will have your 2 or 3 minutes. Councillor Isherwood will as well, if he wishes. And then there's 10 minutes of asking questions.
Chairman, could I just ask, after we've seen the videos, could I just have 1 or 2 more questions of Mr. Oram, because I want to, after having seen it, I want to ask him, whether he still considers it to be accusatorial or merely.
Right, we'll ask that question, whether he still says it's, and he's seen it already, of course.
Yes.
Yeah. So you can ask him whether he's changed his mind.
A long time ago, I'd imagine.
We can ask him whether he still takes the same view. I can ask that question, whether his views have changed now he's seen it again. Okay?
Excellent, thank you.
Good. Right, let's look at it.
So this is the video of the relevant section of 16th November 2016 Joint Planning.
So before you set it going, can we just have the page reference number so that because we have got this transcribed and we might be able to check it as we go through, just to make... I thought it was also covered in Mr. Oram's report, wasn't it, in more detail, or am I mistaken?
Yeah, Chairman's frozen.
I knew that's what I was trying to find earlier. I'm sorry, I wasn't able to. My fault. Thanks.
Right. Okay.
Councillor Hyman.
Thank you, Chairman. We've heard quite a lot of emotive talk, and I think it's important that we try and solidify this, because if I, for instance, refer you to the top of page 117, very top of it, it's where our objections, and I share the objections that Councillor Frost and Councillor Coburn in particular, and Councillor Edwards-James and others have said in respect of the design. But it says here, paragraph 65 of MPPF 2012 states that local planning authorities should not refuse planning permission for buildings or infrastructure which promote high levels of sustainability because of concerns about incompatibility with an existing townscape. So, you know, the officer advice here is almost saying to us, it really doesn't matter how much you hate it, an inspector is going to turn around and overturn whatever you say. So we definitely need to solidify this. And if we just look at that, we're referring to the MPPF at paragraph 65. If I may refer to the same document at paragraph 119 of the MPPF, it states, and I quote, "The presumption in favour of sustainable development does not apply where development requiring appropriate assessment under the Birds or Habitats Directive is being considered, planned or determined." So the references which we have in this officer report to this being a sustainable development and it being the presumption in favour of sustainable development applying to this, that does not apply. Where it says here at the top of 117 that we should not refuse permission for development which promote high levels of sustainability, forget it. This is an unsustainable development in terms of the national planning policy framework which we have to abide by. Now, of course, the question in relation to paragraph 119 of the MPPF is, does this require an appropriate assessment? The outline permission had a document in it which stated that it was an appropriate assessment. It's just a two-page document. It didn't contain the information necessary by law for an appropriate assessment, because an appropriate assessment by law has to include any mitigation. It has to include, it has to be judged against the Wadensee criteria requiring convincing objective evidence. And furthermore, it requires that we consider the risk of the development, and that is against the conservation objectives of the SBA, which means we need the bird numbers and the trends. So I would simply ask, I mean, the point is we cannot lawfully grant consent to this development unless it satisfies the exception tests, which it doesn't. We cannot grant consent lawfully unless we have an appropriate assessment containing the bird population numbers and trends and an assessment against the Wadensee criteria. I want to know whether there's one available, because I haven't seen one, and if there isn't one, we don't have a choice. We have to refuse, and in effect what we're doing is revoking the consent because of the catch-all principle of environmental law, Chairman. I understand there are arguments that Natural England have used in the past. They are, in this instance, self-contradictory, because they're saying we don't need mitigation here, but of course Way Hill development was refused recently by this council because it didn't have mitigation for the Weldon and Heath SBA. Sturt Farm required mitigation. The hamlet in the woods.
This is nothing to do with Sturt Farm. Can we stay on track?
It is the same because, Chairman, this is linked because this development would have an in-combination effect in the same way, on the SBAs, in the same way that these other developments would have. And the others have needed Some of the others have needed to have mitigation. You can't ask some people for mitigation and not this development. So I think that argument is
You've
strong.
made your point. Thank you very much indeed.
Chairman, we're not talking about principle. It's been granted. We're talking about the design in the centre.
Yes, exactly.
Chairman, that's why I'm addressing this issue, because the Habitats Directive and Environmental Law overrides your officer's statements that the principle has been established. You cannot establish a principle unlawfully. If you have made a mistake in granting outline permission, it is required by law that we correct that mistake at this stage.
Can you please move on?
Thank you. Well, I'd like Mr. Devlin, if he would, just to confirm that the catch-all principle does apply, and that we do not have.
I will turn to the officers at this point in time and ask Elizabeth and Barry to address that comment.
Thank you, Chairman.
Thank you, Chairman. Members, if I could be absolutely clear about this. This particular site is outside of the 5-kilometre buffer zone. So, notwithstanding that, at the time of the outline consent, we appropriately asked ourselves the question whether or not the development would have a likely significant effect upon the interests of the SPA. And in fact, looking at the outline report, in fact, because of the location, the judgment was in respect of the Wilden Heaths SPA, because that is more appropriate in this location. Now, our judgment, because it was that it did not have a likely significant effect, you will be aware that that means that an appropriate assessment is not required. That comes from the habitats regulations, and therefore you don't need to worry about the presumption in favour of sustainable development being kicked out because of the need for appropriate assessment. It simply isn't right with respect to Councillor Hyman. It's a sequential approach. We applied it properly at outline, and the inspector endorsed that. Just to extend the argument a little further, because I think this may come up again, every time you get an application which may trigger the question, is there a likely significant effect? If you conclude, because of the offer to, for example, bind Farnham Park to contribute a sum to enhance the SANG, in which case you're providing appropriate mitigation as an applicant, you are therefore indicating that the likely significant effect is effectively mitigated to the point at which an appropriate assessment is not required. Now, I know that sounds like a lot of words, but that then enables you as planning authority to reconsider that the presumption in favour of sustainable development can remain. So I hope that's clear, and I hope that that's helped you, because I suspect that the same comment may arise again. But in relation to this, Councillor Frost is absolutely right. The principle of development on this site, I know it's not very popular, but it has been established by the outline consent, and the matter of whether or not the development would have a likely significant effect on the special protection area has been dealt with at outline stage. Thank you very much.
Mr. Chairman, I would just add that I think the head of planning is most succinctly summarised the requirements of Regulation 61. She's not distorted it in any way, correctly summarising the sequential approach. And I would just like to quote from the case of Jones versus Manfield, which is on environmental impact assessment, but is very, very analogous to this situation. The court therefore said, it needs to be borne in mind that the EIA process is intended to aid efficient and inclusive decision making. In special cases, it is not an obstacle race. And with respect to the councillor, I think he's trying to pray and aid the habitat regs as an obstacle race to decisions of this nature, and it's not appropriate. Thank you, sir.
Thank you very much indeed. Councillor Hyman, that's
thank you, Chairman. With respect to what's been said there, I mean, I think we all know that this actually is a serious issue in Farnham.
Can we please move on? You've made your point.
We've had a denial, and I think I should be allowed to quote from the law as opposed to simply assumptions.
We've just had the law quoted. Please, can we move on?
Misquoted, Chairman.
No, I beg your pardon. I think that deserves an apology. I really do. That is out of order.
Mr. Chairman, the Habitats Directive it has is applied differently to the environmental impact assessment regulations, which Mr. Devlin quoted. It has a very strong presumption.
Sorry, I'm really not prepared to sit in here and hear the officer's insulted. He either apologises or he leaves. He doesn't compel
I did
me.
ask for an apology.
Do we have to apologise when we're in the right, Chairman?
You can discuss that.
All development was stopped because this is so serious a few years ago. You will recall it is a very serious matter and it hasn't been applied properly for many years.
I totally disagree with that comment, and I would like you to move on, please. Have you any other comment?
I will certainly apologise if I am wrong, but I would very much like to establish this at some point and be able to discuss it properly, rather than simply be told that we've got an answer and you're wrong and we're not allowed to speak about it anymore, which is what we've had for the past 18 months, Chairman.
Can we please move on? You haven't been here for 18 months, so, you know, I take your point. Discuss it outside the meeting with the lawyers. Can we move on to Councillor Gray?
Thank you, Mr. Chairman. I'm not going to repeat all the comments that have been made by my fellow councillors. I was at the site visit.
Should we perhaps... no, we're going to have to cover it all together, aren't we? I was just wondering whether we should address this. I was wondering whether people would be able to remember the first one when they'd seen the others, and that
Councillor Hyman.
most efficient.
Thank you, Chairman. This seems this site is close to the heart of many of us, because I know that when the pub's land used to back right over to the bottom of Bethel Lane, it backed onto my father's back garden. We used to hold up bonfires there, and the pub never worried about it. But the land's gradually gone bit by bit. I can understand that without the car park it's not, it's going to be a lot more difficult to use, but I agree wholeheartedly with what Councillor Potts has said in terms of this is an overdevelopment of the site still. Obviously I know that part of the Upper Hill Road extremely well, having been brought up nearby, and that is a very dangerous area for a lot of cars going in and out. Councillor Fraser rather stole my thunder on the issue of the Upper Hale Road being redesignated the A287. It doesn't surprise me that he did. I know he cares about it a great deal, as I do. Car parking, you know, any extra car parking would, if people are going to park on the pavement or against the road there, round that bend, it is a recipe for disaster, and it's also a recipe for clogging up the Upper Hale Road completely. Obviously, Surrey County Council's comments do not take into account the plans that they distributed only last year. The beginning of last year, I received copies, having requested them for their proposals to make the Upper Hale Road the A287 again. So I can't see that that's right. Although fair play to the developer, it's an awful lot better than what we saw previously. You know, the previous scheme, he's put a lot of effort into this, and there is a possibility, I think, that in other circumstances I would vote in favour of this if it were moved back from the road a bit, perhaps slightly lesser. If I was convinced that, that there weren't going to be people parking on the road from it. But you know my position, Chairman, in respect of the law. This is less than a kilometre from the SBA. I'm not going to be voting in favour of this anyway, because there is it doesn't satisfy the legal constraints. If I can refer you to, I think, page 31 for a start. We've got the effects. This is the protection that Farnham has against inappropriate development, and whilst I agree with most of what Councillor Hodge said, I completely disagree with his view that it would be granted by an inspector if we turn it down. Well, not if we use the law as the law is written, rather than turn a blind eye to it. We have, according to this, it satisfies the CIL regulations because the SANG contribution does not pay for the provision of new SANG. Well, that's actually the problem here, because the SANG strategy that we've got is unsustainable. It doesn't pay towards land. It should be paying towards land. What happens when Farnham Park runs out of its imaginary mitigation? And of course that's another problem. I don't think there's a person in this room that believes that the mitigation, calling Farnham Park a sang, actually does a jot. But we are charging millions of pounds over the years to developers to sell them that. It's like a tax on development. It doesn't help anybody particularly. If you turn to page 41, Chairman, you'll see that that's recommendation B, and that's a situation where if the developer doesn't pay or doesn't sign a legal agreement to pay many thousands of pounds for this imaginary spa tax. We know from the judgment of the European Court, we know that the constraint here is, and I'm quoting from NPPF, para 113, footnote 24, so this is in planning guidance, it's Circular 06/2005, it states, one sentence here, competent national authorities, that's us, must be convinced that there will not be an adverse effect and where, on the SBA, and where doubt remains as to the absence of adverse effects, the plan of project must not be authorised. So where there's any doubt, what we must have is convincing objective evidence, that's what it states in paragraph 20. If there's anybody here, if Mr. Hodgkin, Councillor Hodgkin should give me convincing objective evidence that calling Farnham Park a sang and having an imaginary access to the east of it by pretending there's a car park there, if that has any effect, then I would...
Is this relevant, Councillor Hyman?
Absolutely, because the law states, I mean, if you look at paragraph 41, which I've referred you to, it states down here, halfway down, since the planning authority is not satisfied that regulation 62 of the regulations applies in this case, it must refuse permission. We haven't got a regulation 62 application. That's a limitation that does allow development if we don't have convincing evidence. So we haven't got convincing evidence. Regulation 62 doesn't apply. I have to refuse and everybody else does because that's what the law says, Chairman, and I'll leave it at that. Thank you.
Thank you. Councillor Coburn, sorry.
Did it in simple writing, Chairman. Right, I just wanted to get back to this application. That's really what I've come to talk about. I'm actually going to speak up for the developer here and for the development. You know, we've been told many times in this council chamber we cannot blame a developer for coming in at outline. We've been told that over and over again. It's within his right to come in, and he's coming for an outline permission. Not only swords, it's a lovely road when again, because you can see very clearly where the... You know, I actually think this...
Inspector. So I myself think it's not only likely, I'm inclined to vote against, Sir Hyman said, in terms of the legal
approach. The law allows it to come forward in an outline.
Yeah.
Yes, thank you, Chair, through you. Essentially, the point has to be reiterated and re-emphasised. This is an outline application. It's in the developer's gift to come forward with an outline application. It's provided in the law. He's entitled to do that. Now, that shouldn't weigh in the balance against this application before you today. To actually look at this pejoratively, because it's an outline application, is an unreasonable approach. The law allows it to come forward in an outline sense. That's the first point, and it's re-emphasising something councillors rightly endorsed. You haven't heard that before. It's nothing new. The second point, in terms of perhaps understanding that this may be lost on appeal, if so, and if any of your reasons for refusal are unreasonable and can't be sustained, then of course it's the public purse and there's costs that inevitably follow. So do bear that in mind. It is the public purse. Now, I wouldn't go so far as to say that there should be a cost warning here, but if you in your hearts perhaps understand you may lose this appeal and yet run forward with reasons for refusal such as highways, perhaps not agreeing with the statutory consultee, it could be said that's an unreasonable reason for refusal, and to sustain that appeal is going to be quite difficult. So there's a cost implication there. The third point in relation to Councillor Hyman's comments about the SANG, we have an avoidance strategy that was adopted in 2013 and updated in 2016, and in that avoidance strategy you agreed to a particular course of conduct to offset harm towards the SPA. That was your own adoption. Now, with that in mind, in terms of actually asking for contributions to offset harm in terms of development coming forward for housing, be it how many bedrooms, and calling for contributions to offset that harm, that's the approach of the council. Now, we say that because of that avoidance strategy, essentially, if there's an agreement coming forward to say that we're going to enter into that Section 106 obligation to pay in line with your own strategy, what more can the developer reasonably do? What more can they do when it's your own document, your own adopted policy? Not much more. I don't think I need to say more, councillors.
Thank you. Councillor Frost.
The splays you talked about on highway grounds, the second one, if we did that, and then we got...
So we can't argue against that. I don't believe, I think I quite understand the
what detriment.
Do not criticise me or
the fencing provided. How tall's that fence?
Thank you. I've got two people who want to come back. Are there any new points you wish to raise? Councillor Hyman?
Only to clarify for Councillor Frost, I mean, I'm rather surprised that after, was it 10, 11 years, there are people in this room on a planning committee who don't know the basics of the main constraint of development.
Please,
Chairman.
please,
would you ask Dan Lucas,
we have
please?
a protocol, Councillor Hyman. Do not criticise me or other councillors. Thank you.
Would you just ask, if you don't mind, Chairman, that Mr. Lucas, Dan Lucas, our lawyer, confirms that the constraint, regardless of what you might call avoidance strategies or whatever, that the legal constraint here isn't actually as is written on page 31, where it says that it's it has to satisfy the local plan.
You have had the legal answer. He is a specialist. We must accept his instructions.
I thought we were here as councillors because there are occasions when the advice we receive is wrong. Otherwise, we wouldn't need any councillors.
Excuse me, that is strictly against the rules, strictly against our code of conduct. You cannot criticise an officer. Please withdraw that.
Officer,
yes, you were.
If it was taken as a personal criticism of any individual, then I will withdraw. But it wasn't. It was a simple statement, Chairman,
I would like you to
not
withdraw that
right
comment.
all the time.
I'd like you to withdraw the comment, please, Councillor Hyman.
I can't remember exactly what I said, but if it'll keep you happy, I'll withdraw the comment. And we're not perfect people, none of us are, and isn't that here why we're here? We should be able to debate these matters and find out not who's right, but what's right, Chairman.
Thank you. We'll move on.
Chairman, for many, many years, we have debated very...
I've forgotten what I was going to say.
Because to me, the...
Granted permission, again, their sort of wider properties is the matter to weigh up for members is... Yes, thank you, Chairman. I'll work through. There's a number of points. Some of them have been covered off.
We have to be very, very careful in our reasons for overturning the inspector, if that is what we are going to do as a committee.
Sorry, I didn't hear you then.
Councillor Hyman.
Well, Councillor Coburn just said, but there is no dilemma. I disagree with her on that, in as much as there is no dilemma here, really, because if you turn to page 76 of the papers where we've got at paragraph 18 under other matters, this is the appeal decision. It says that unilateral undertakings before me are named to provide mitigation. I'm sorry if I'm confusing people with legal speak and legal matters, but it does say, I'm allowed to read it, I think, it will avoid harm to the Thames Basin and Heath Special Protection Area. However, on the basis of my conclusions on the main issues of this appeal, I have no reason to consider this matter further. So the inspector's made it absolutely clear in his judgment here that he has not considered the legal issues in respect of habitats regulations and the statutory instrument Circular 06/2005 and the directive. So you know we can obviously on such matters raise points which are very solid. If I can refer you to paragraph 119 of the, not in the papers here, but of the National Planning Policy Framework. That's in respect of sustainable development and the definition of sustainable development. It states at 119, the presumption in favour of sustainable development, that's in paragraph 14 of the
Chairman,
NPPF, does not apply where
not
development
for,
requiring appropriate assessment under the birds or habitats.
Haven't we watched that bit before, 10 minutes ago? Or did I say exactly the same words in two different meetings? And are we, I don't know what we're watching at the moment, and I don't want to spend all afternoon watching the webcast just for the fun of it. We've done the bit.
Have you seen the bits you want us to see? I think we're just repeating what we said in the earlier meeting.
Yeah, but it's not actually any of the words here that on page 30, page 65, sorry, of the officer report we're looking at here, I think. And we've been through there where I said that I'm...
If you're happy we've seen everything you want us to see, then that's fine. Is that okay?
No, those are the two which were put into evidence by the
There is a
the complainants. I think I've got one or two links that I put in. So if you're asking, do we want to see any more? I'm not saying yes. I'm certainly saying I would like to see the others. But Fiona, sorry, would you mind explaining to me why we're looking at this bit, because I'm not sure where we are.
Just for a point of information, so if you page 67 of the report, there's some wording there. Unless someone is going to argue, as someone might have tried last night, I think, that an inappropriate assessment equals an appropriate assessment, which obviously it isn't, because we were told last night, and we have to be consistent, that we required SANG for development. I think that's probably the only bit within the report that we haven't seen on the screen, so just a point of information.
Thank you very much for that clarification. I thought we'd gone back in time again. It's very confusing for me to be hearing... When you keep saying Mr. Hyman on that thing there, I keep wanting to respond. It's very difficult. No, Chairman, I thought I'd made that clear. I put a couple of links in. Well, I don't mind watching those afterwards, but or when I'm questioning Mr. Bainbridge. I think that, okay, let's go to it. Let's do it now. Get it over with. The two links. Because the trouble is we're going to be going back to a lot of them that we're questioning. The two links in my that I put in my evidence. I'm pretty sure I put a couple of links in my evidence, Mr. Chairman.
Councillor Hyman, is it your Annex 4 that you're talking about?
No. So we're not going to get to the truth. We're just going to be narrowly constrained.
Again, point of information, it's that what Councillor Hyman is referring to, I think, are the web links within his statement rather than within Annex 4.
Oh, yes, sorry. When I say web links, I meant to webcasts as opposed to web links to documents, and you were thinking I meant to the documents, the source documents that are in Annex 4, were you thinking? Because obviously they're not webcasts, they're just documents from...
Just trying...
Well, I consider it to be relevant. You've just told me that nothing else is relevant if you don't want to listen to it or something, Chairman. I would very much like to be given enough room to...
We're only going to look at webcasts that cause the complaint. I don't want to look at every joint planning committee meeting you've had since you've been a councillor.
Well, if I want to do that, then I would put in sort of 70 or 80 web links, wouldn't I, Chairman? I don't think I've done that, have I, Chairman?
No.
No, I put in one or two. In there. No, I mean, you know, it's not much to ask, I thought. I mean, I've got 92 pages of stuff here, and I put in, you know, sort of like a handful. I don't think I'm the one causing the problem here. Can we watch the webcast, please, or not? To the links that I put in.
Which meeting and why?
The why, Chairman, was because it's under my duty, is in respect of the duty that I have to represent my residents.
No, well, we take that on board. We'll accept that. You have a duty to your residents. I have a duty to my constituents as well. That's fine.
There is one at...
But you see, the problem is we've only got your statement this morning or late last night, and we haven't got the links loaded up on our machine. We've only loaded up the webcasts that are relevant to this inquiry.
Chairman, can I ask Fiona, does she have the links on her? You know, if you've got my...
No, she hasn't. Right. The panel does not wish to see any more webcasts. We've seen the webcasts.
You're not accepting my evidence then, Chairman?
You can give your evidence when you get to it, but we do not wish to see any more webcasts. We've seen the webcasts that relate to the complaints, and that is what's relevant. And I'm now going to ask Mr. Oram, having seen the webcasts again, are your views in any way different?
The question was whether he considered it was accusatory, Chairman, I think, rather than, you know, in there was
I phrased it as to whether he wishes to amend anything in his report, or whichever way you want to look at it.
My own opinion from the video footage hasn't changed my opinion on breach. I think where I have an issue is Councillor Hyman is allowed to give his alternative view as to the legal advice being offered. He does use emotive language in that, such as that they're turning a blind eye to the law and that they're recommending the council act unlawfully. But he's allowed to make those comments. The officers are allowed to respond, and then rather than letting members then consider which they prefer, Councillor Hyman seems to feel the need to have the last word, and whilst doing so, makes accusations against the officers that I consider unreasonable.
Thank you. Right, we're now going to move on to Mr. Bainbridge, and we are going to ask him to say 2 or 3 minutes if he wishes. And we have already his complaints, Annex 3, pages 17 to 22. Mr. Bainbridge.
Thank you, Chairman. Yeah, just really to clarify and pick up a couple of points that have been made, as I suspect that Councillor Hyman will ask me questions along those lines anyway. But I did just want to say before I say anything that this is not a vexatious complaint. That has been said, and if that were the case, there would be numerous complaints. This is the only complaint that I've made about Councillor Hyman, or indeed any councillor. It's not vexatious. This is a complaint that's not about me or behaviour towards me. This is about attitudes towards my staff and committee, as you've seen, and treating them with respect, and the effect that this has on them, which is significant. I have a responsibility as a manager, and I also have a professional interest in seeing good standards for conduct maintained by councillors, not just as an officer of the authority, but as its chief legal advisor, and also as one of its deputy monitoring officers. So it is in my professional interest to see those standards upheld. But primarily, every day when I come into this building, it's about seeing my officers in my team treated with respect, and wider colleagues as well, because of course it isn't just legal officers that sit in planning committees or other committees. And this is a question of tone, and it's cumulative. It's not just one meeting, which I've complained about. It is a number of meetings or a number of applications within those meetings. So it's cumulative, and it's cumulative across those people in my team who attend those meetings and who hear a tone which suggests that they are perhaps at times deliberately giving incorrect legal advice, as you've heard today, as Councillor Hyman said, possibly to even cover things up, which I don't accept at all. So the background to this and the context of this is it's about tone, it's about the effect that it has on members of my team, and therefore has on me as a manager. Just to pick up another point, and it's something that has been said by councillors in those meetings, in fact, and has been said outside of meetings by officers to Councillor Hyman, is come and speak to the team about these issues. Come and speak to the lawyers, if you want to refer to them in that way, but come and speak to my team. There haven't been any attempts by Councillor Hyman to do this, to engage with officers outside of the committee. In fact, in one of the meetings he said that he intended to do that, but that never happened. And to do that in a normal and constructive manner. I think the chairman, Councillor Isherwood, invited him to do that outside of the meeting to engage with Mr. Devlin, and I don't think that ever happened. I have to say, in 17 years of being in local government, I can't recall a situation with an individual councillor where he or she has not wanted to engage with officers. There are plenty of councillors who you never speak to because they don't need to come and see you. But those that are engaged in issues in committee that pique their interest will come and speak to officers. I have never been approached by Councillor Hyman. I know that Barry and Dan, when he was here, and others in my team have not been approached to discuss this and to discuss why the view is of the authority that it is, and why that same view is held by our external advisors as well. You know, I've got a team that's trusted by councillors in this building. We've built up that trust over many years, both individually and collectively. And you know, Councillor Hyman should be able to trust our judgment in coming to us and not raising things just in the committee. So it's not about whether, and I will come to an end, it's not about whether or not Councillor Hyman is right or whether we are right. It's about disagreeing in a professional, consistent manner. Also disagreeing in a professional manner that's consistent with the code and with the member officer protocol. And what we expect to take place between officers and officers and councillors. There was just, sorry, the final point was just an example about this duty one way or the other and whether it trumps the law or so on. If I can look at that from my perspective as a solicitor here in the authority, my duty as a solicitor is to my client, the council, the officers within it and the members within it, all of them collectively and individually, and to act in their best interest or the authority's best interest. But that doesn't trump my duty to do that in a respectful manner. And there have been many times where I've disagreed with councillors in committee and in other contexts and had to say to councillors, with respect, I think you're wrong here. The law says X, whereas I think you're thinking Y. But it's done respectively, and we wouldn't have that trust with the team if that weren't the case. So much the same way, yes, there is the legislation surrounding EIA and habitats and planning and everything, all of that. But it doesn't trump the code. Those two things operate to their fullest together. And that's my perspective, and the same is true for officers as well. Thank you.
Councillor Hyman, and bear in mind the opinion has been given by Mr Oram, the facts have been given by Mr Bainbridge, so perhaps you can just ask him questions relating to the facts, if you disagree with any facts. And we've seen the webcast.
Thank you. The first of the webcast that we saw there. We've been told that it's not an obstacle race. I was questioning the catch-all principle, and I was told, I mean, Mrs Sims and our lawyer told us that at the time, at the meeting, that I was wrong. I quoted paragraph 119 of the NPPF in terms of sustainability, and I was told I was wrong. I look in the big story in Farnham at the moment is Folly Hill, which has been granted appeal, and in there the council has admitted, stated that I was right actually. Those decisions we made those years ago shouldn't have been made in the way they were. I was ignored and the decisions weren't made correctly, quite clearly. Waverley have taken my stance and tried to use it in the Folly Hill appeal, and of course I was right. The inspector is also quite right in saying that if you assume that there's an appropriate assessment, this is on the Folly Hill one, if you assume the appropriate assessment is complete, then they're legally correct. Well, yes, it is, but it isn't. What I want to know from Mr Bainbridge, will you please tell people, accept people, that the position I was taking at the time in respect to the catch-all principle was correct, because only, and you did say you were concerned that I'm ignorant because I didn't come along to you and try and arrange a meeting. I didn't need to. These meetings were at the, what was it, 31st of March that we've been looking at, 2017. And on the 10th of April, 10 days later, our lawyer, which I think at the time was Dan Lucas, stated, and it's in my evidence, do you accept I was correct about that, about the catch-all principle? Or are we going to revert to a position where you're saying, no, it doesn't apply, or it does only when we feel like it does?
I'm not sure that's a question about my complaint about your conduct in the meetings. To answer your question, the point you made earlier, Barry and Dan in those meetings delivered their advice in a respectful way, and my view is that your response to them was not respectful and was a breach of the code. Now, that's a matter for the panel, for the committee to decide here today. They will form their own judgment on that. But from my perspective, Barry and Dan, as I said in my complaint, delivered their advice in a professional way, as they always do and always have done. I'm not going to get into a debate over the rights and wrongs of the legal positions surrounding the planning, because it's not relevant to why I'm here today. Mr. Oram's already said that, and I'm afraid I'm going to say that again now.
Yes, but this is about public perception here, and obviously anybody who's watching this is thinking, hang on a minute, you're not allowed to look at whether he is being... I mean, in a situation where if the council was involved in a major project of with the developer, and that they'd set it up over the years, overcome problems with slightly iffy ways, which at the time seemed okay, but hey, we didn't expect snow in 2008, 2009, which messed everything up. All of a sudden, we had to take a new strategy. They didn't. And we're now constantly having to live with this, well, we've got the evidence and we haven't. We're being told... The chairman earlier, Mr. Bainbridge, stated that Mr. Beglin, who had responded before Christmas, could be relied upon, and that I appear to be contradicting what he said. And what he said at paragraph 53 on page 16 of the of his response to my questions, it says, he says, it follows that the answer to question 9 above is that, A, the council does have convincing objective evidence that the Farnham Park SANG and the SAM strategy are effective applying the Waddensley judgment. That is a QC, I assume it's a QC, sorry, barrister's response states the council does have convincing objective evidence that the SANG and SAM strategy are effective. And I think it's a matter of public knowledge that it's in public documents, the Joint Strategic Partnership Board say they don't have any evidence. You know, if the evidence is there, this is what I keep asking for. I'm constantly being frustrated, as are many others, including Conservative councillors, who, when they go to our offices, are not given the documents that they ask for, can't get a straight answer. Can you please confirm to me that actually where Wayne Begland here says that the council does have convincing objective evidence that satisfies the Waddensley judgment of the SAM strategy as well, it doesn't exist at the moment, actually. Will you confirm that to be true? Because if I'm allowed, if the chairman here is allowed to misinform people so that people think that again I'm wrong about this, can you just please tell us that? Do we or do we not have that convincing objective evidence that Mr. Beglin surely must have seen if he's going to write something like that down? Can I see it?
I'm not sure what relevance it has to your conduct in the meetings that are the subject of my complaint. Mr. Beglin's given a view. If you disagree with it, then respectfully disagree with it. But Mr. Beglin is a planning barrister, highly regarded, defending our local plan through a number of hearings last year, amongst other things. And he's given a comprehensive advice which reaches a conclusion. I'm not going to sit here and say that he's wrong. I think, Chairman,
you've got 3 minutes left, Mr. Hyman. I would suggest you ask questions of fact.
I can ask that question over and over again and still not get an answer, can't I? I think perhaps people can start to see what a problem it is.
It's not relevant, Mr. Hyman. You've got 3 minutes left.
Well, you seem to think it was because you brought it up earlier, Chairman, as to what Mr. Beglin said, and you were misleading this chamber. And again, I think it's perfectly clear to people if I ask a straight question, is Mr. Beglin right or wrong? Oh, it's nothing to do with us. It's clear that this is untrue. Yet the chairman's allowed to spout it, pretend I'm not allowed to say anything about it, and I have to be judged on the assumption that I'm wrong. And you know, I've got people winding me up like this constantly because they simply can't answer a question straight. Okay, now you say there were no attempts for me. I asked Dan Lucas to organise me a meeting. And he said, it may take a little while because it's going to require all of us to put together, it's going to need the head of planning, the head of legal, both of the planning lawyers, and goodness knows, all these other people to tie in with my diary. Well, I'd have to tie in with theirs, obviously. And it never happened. And it states in this report, and I'm sure you've seen it somewhere, I can't quote you the paragraph number off the top of my head, that Andy MacLeod had also tried to, and he had been unable to get a meeting organised. So, you know, the idea you're telling us here that you've just made a statement that I had made no attempts to try and meet with our officers. Do you accept that that statement you made isn't true?
No, I don't. I know about the Andy MacLeod, Councillor MacLeod request, and that, from memory, in terms of the timing, came just before we had both the local plan examination hearings in June 2017 and then, of course, the Dunsfold Park inquiry, a 3-week inquiry, not long after that. Either side of that, of course, we had various other inquiries as well. So it was a very, very busy time of year. And I think that was explained to Councillor MacLeod at the time, that at that time, effectively 6 or 7 weeks of officer time between the legal officers and the planning officers' time was taken up being effectively in this chamber and around it, dealing with those matters. So I think it was acknowledged, certainly when I met with Mr. Oram, that simply because of the passage of time and how busy everybody was at that time, it was overlooked. I would go back to the answer that I gave him previously, which was that, or what I said in my statement, which was, I have never been approached by you, Councillor Hyman, to discuss these matters. Mr. Devlin has never been approached. I've not seen anything from him to say Mr. Councillor Hyman would like to meet with me or with the other planning lawyer in our team. I've not had an approach from you to talk constructively about this. And I think the position is you're not going to agree with what we say, and that's fine. That's absolutely fine if we walk away and say, well, we agree to disagree. I think that there's been no attempt to have that kind of discussion and acknowledgement that we may well not agree, and then that has to be that, and it's time to move on. We've had as much advice.
May I move on?
If I could just let him finish the question, then that is your time up.
Well, as you say, time's up. I'm being timed out.
Yes,
if I could just finish that sentence. We've had lots of advice on this now, external and internal. And the position has remained the same from you know, in terms of the advice being given to the authority, and I don't think it's going to change. And I think the only thing that will result in Councillor Hyman, you going away and being content, is for somebody within the authority to say, yes, you are right. And from what I can see, that's not going to happen because the advice is not coming out that way.
Right. Mr. Chairman, can you please put on the webcast now so that I can, because you know, this is part of my evidence. I think we should be able to watch it. It's very brief. It's not going to take anything like the time of that.
We've finished that. We're now going on to Councillor Isherwood, if he wishes to say a few words.
Thanks, Chairman. First of all, I'm here as a Waverley councillor. I'm not here as a Conservative. What my political leanings are is neither here nor there. And what Councillor Hyman's leanings are is immaterial. Many years ago, I received the Queen's Shilling and became an officer and gentleman. Subsequently, when I left the Air Force, I retired as a senior RAF officer. I did not retire as a gentleman. And I think that is a position I hold now. I look for respect in others. I don't seek confrontation in any way, shape or form with anyone. I just talk, our lawyer here has made a number of comments. Every time I go on a site visit, I take this book with me, the Constitution and Council Procedures. And there's always a little sticky in it on site visits. And one of the things I always ask members to ask the officers at the site questions or seek clarification from them on matters which are relevant to the site inspection, and further to ask officers either by email or phone or visit for any clarification prior to the meeting. I think that's quite important. I made a complaint to the monitoring officer on the 6th of April 2017 after thinking about it for a week. Again, not wishing to seek confrontation. I expected it to be finished by the 7th of April 2017. I could see nothing other than a simple matter of respect. And that's really what I'm trying to say here. And that, Chairman, is really all I want to say.
Thank you very much. Now, are there any questions of fact you want to ask of Councillor Isherwood? Councillor Hyman.
Yes, Councillor Isherwood, you have represented Waverley on the Joint Strategic Partnership Board.
Yes.
And the Joint Strategic Partnership Board is the regional joint committee which sets out the strategy by which all of these... so you've got a good knowledge of the constraints that are before us in law in these meetings. When I'm in front of you asking these questions, you've got a full knowledge because you understand the constraints, because you've been representing us on obviously what that board does is work out how we manage to obey the constraints. You have to know those constraints, so you consider you have a good knowledge of it.
Can we keep relevant questions to the protocol, please?
Yes, I see. Got nothing to do with it. What are we talking about? 4 years ago, something like that. Things have moved on. I respect the judgment or the advice that they give. It's got nothing to do with my comment here to the monitoring officer. I simply wanted to show respect to the officers who were stating their professional understanding and knowledge.
But and you firmly believe yourself that in these debates, I mean, where you made this complaint because obviously you considered that I was wrong in the point that I was making, that I shouldn't be allowed to make that point, because we've already established that yes, it is a duty. I think we've had that answered at last, because it took all morning to get it out of you, that it is actually a duty of ours to obey the Habitats Directive, and that it runs alongside the Code of Conduct, that we have to try and abide by both. But my point in the first place was what's when you've got a conflict. When you've got a conflict, which one takes priority? Because sooner or later you have to take tough decisions and decide what you've got to do. And in a meeting, I'm defending my actions by saying that I've got to be tough. You could tell from those I wasn't being rude to people. I wasn't jumping around or shouting around. I was being perfectly measured. I was asking reasonable questions. And we saw that the chairman butts in overrides, refuses to allow things to be... and that I've had years of this, where the chairman has just bullied and stopped us, Farnham residents, being able to speak at the meetings, because certainly, obviously, he doesn't want to have points to be made. Now, I want to know whether, in your mind, at the time, when you made those complaints, you thought I was wrong, or whether you thought I was right, but you needed to shut me up anyway.
I did not bully you. I invariably get criticised by members of committees for allowing people to exceed their time of presentation in the debate, and I invariably allow people to come back time and time again. I did not in any way, and you or anyone else, I do not bully, I do not make a judgment on what they are saying, I make a judgment on planning matters in planning meetings. Simple.
But in terms of the question that I asked, were you at the time there, when you made that complaint, were you of the mind that I was wrong? Or did you think to yourself, well, Mr. Hyman's probably right, but I don't like the way he says it, so I'm going to complain?
No, I didn't. That's not the way I treated it. I looked at it purely as a matter of respect to a lawyer, a planning lawyer, who had given comments from law, and I was quite happy with his comments. It was the way you challenged him, which should have been done outside the meeting, prior to the meeting, if you had thoughts on that matter, but in no way, shape or form was I bullying or restricting you or supporting one or other.
So after you made that complaint, which you appreciate I was unaware of, you said that you thought it might be done in a day. I think I received it on the 13th, something like that. I'm not sure. I don't know exactly, but obviously it wasn't within my control to sort this thing out. Particularly, I didn't know about it. Do you think that if you were proven wrong, or if I had been proven correct, what I had been saying at these times when I said misquoted, if I was proven correct, would that have made a difference to you? Or do you think, no, it doesn't matter, Mr. Hyman is pointing out that actually what we did is make an incorrect decision because he was right and we were receiving the wrong advice? Because obviously we do accept that we do receive incorrect advice occasionally. Do you accept that?
No.
So officers, your statement is officers are always correct in the advice they gave us?
In points of law, we are talking about, yes.
Okay. If I could show you a webcast here, very briefly.
We're not going to look... You've had the answer. We're dealing with these complaints. We're not dealing with whether the law is right or wrong. This panel will make a decision regardless of whether the law was on your side or the officer's side. We're looking purely at the protocol, as our independent legal advisor has advised us what we should be doing.
Thank you, Chairman. And I do refer you back to the independent, the investigator, having stated that the circumstances matter. Now, I know that you are very keen to limit the extent to which we might consider what the circumstances were. And you want to make absolutely sure that this is never a question of, am I right or am I wrong? You're trying to say, did we like the way he said it? We know that I could have ranted and raved and still got away with it supposedly, but for some reason...
3 more minutes to ask any questions.
If you just want to stop it now so that I'm not allowed to have any webcasts, if I'm not allowed to put any evidence forwards, I mean, you know, if you just want to show everybody it's a kangaroo court and that it's, you know, if these... We just heard the most ridiculous statement from Mr. Isherwood, as far as I'm concerned, that says we're always right. The legal judgment in the case of Sweetsman pointed out that...
Are you making a statement of your evidence? You'll have that next.
Well,
or are you
Mr. Chairman, what I'd like to do is to
Mr.
prove that the complainant, Mr. Isherwood, was incorrect in his in holding that the officers never make a mistake. Because 4 days after he made that complaint, we had a joint planning committee meeting here at which he was, I'm pretty sure he was chairing. We can confirm that if you'd let us put up, 20 seconds of video, and I've got an exact web point to it. It would take a few seconds to get to that web point. We just clicked on it. If that would be played, what we have got is Dan Lucas stating, and actually I think I've quoted it in the documents, at least I did quote it in the documents which were sent through on Monday. I don't know whether people... I have been assured that the things that I sent in on Monday have been distributed to to everybody here.
Chairman, just point of
Pause
information.
the clock for a minute. Yeah.
Apologies. Point of information. The statements from Councillor Hyman, the statement and a number of documents were sent through at 3 o'clock yesterday, with a further document sent through overnight. They were not submitted before then.
Sorry, Chairman, I wasn't referring to the documents. I was told that I had a 3 o'clock deadline yesterday. My Waverley email system didn't allow me to attach things. So one document, which is just the legal one, the very last bit in here, is the one which they very kindly included. And I do appreciate Robin allowing that to be put in, but it is totally should be uncontentious. It appears that it's being denied the content of this doesn't actually matter. But as far as I'm concerned, I put in emails on Monday morning. I wrote an email saying that you need to Tom Horwood, telling him that I might be dreaming it, telling him that he needed to immediately address issues of having made exempt information and or secret information, confidential, whatever you want to call it, public, and in particular an email address, which should certainly not have been put out. And I asked him to correct that immediately, to speak to the person concerned. That was done,
and I apologise for that at the beginning
of the documents, I'm told that those documents have gone out. This is nothing to do with the stuff that I sent out yesterday, before the deadline, and the other bit I sent in this morning, which Robin kindly allowed me to do. But it's of no consequence.
I assume you have no more questions.
I want to know whether those documents have been received by the members, whether they are aware of the documents I submitted on Monday, because you know, they do speak for themselves, and they've got a quotation in there which I think is
Let's ask
germane to
Mr.
this.
Taylor, please.
I've been very clear with Councillor Hyman this week. Obviously, there are emails going to and fro, councillors and the Chief Executive, myself and others all the time. I was very clear with you. You needed to tell us what it is that you wanted to submit. The deadline for the statement wasn't 3 o'clock yesterday. The deadline for the statement was actually back in November and was extended 3 times. The 3 o'clock deadline yesterday was simply trying to be reasonable, and actually it was about, you asked me the question, Councillor Hyman, can we print the things for you? And in the interests of reasonableness and practicality, I said that if things could be submitted by 3 o'clock, then we would do the printouts. And if they were submitted after 3 o'clock, you would need to do the printouts and bring them. As it occurred, even though you sent some documents after that 3 o'clock deadline, we've printed them anyway. There were other things in your email that you sent on Monday that didn't relate to this conduct hearing. And as you know, the Chief Executive responded to those and is dealing with them separately. They're separate matters. They're not related to this standards hearing.
Right, thanks very much.
Thank you, Mr. Chairman. Unfortunately, I have been assured this week. I was in here yesterday, the quality meeting, and I went into the office, and I was absolutely assured that those documents had been forwarded to, I'm sorry, Vivienne isn't, it's the other Vivienne, Riley, who's a PA, I think to yourself. Thank you, Robin. Absolutely assured me that they had been distributed. I'm rather disappointed that they hadn't. I asked these questions, to find out, to make sure, and if I'm getting incorrect answers, it is very difficult for me when all I'm getting is conflicting information. How can you prepare for any sort of thing like this when you're getting conflicting information? And Robin says
sorry,
that.
Mr. Hyman, you've.
I want to have that webcast put up there. Will you allow us to, or is it only other people who are allowed to actually put in evidence? I think this is getting ridiculous, Chairman. You're just being rude and blocking everything. Could you have some respect for me, because I have a right here to defend myself. I think it's quite reasonable to ask evidence to be shown.
As has been explained, you were given the opportunity of supplying your evidence. You supply it, not us. Back in November, we extended it in December, we extended it in January, and we then extended it to 3 o'clock yesterday. Now, it's very difficult for the panel who wish to prepare for this case if your case is not with the rest of the papers, which it wasn't, because we'd received the papers from everybody else on time first. Now,
as a matter of personal explanation, Chairman, I've made out from the very beginning exactly what my attitude is, and I've got the summary down here. I have not kept it secret at all. And you also have a position statement within the documents at Annex 14, is it, or something like that, the second part of Annex 14? I think.
We obviously had what you told Mr. Oram and so on. I accept that. But the fact of the matter is, bearing in mind, we are dealing with this protocol alleged breach, which we've got to decide upon, and it's relating to those 2 complaints, not everything else that's gone around it. We have to limit what we're talking about, and that is what we are here to decide. the complaint of Councillor Isherwood and the complaint of the Borough Solicitor, Mr. Bainbridge. That's all we're here for. And whether you are legally right on things, whether the officers are legally right on things, or whether there's a bit of grey area in between, is not material and will not be relevant to our determination. Now, so far as I'm concerned, you've now had your time for Councillor Isherwood. The next, Councillor Isherwood, you wanted to come back briefly?
If I may, Chairman. Maybe I didn't express myself very well, but certainly when a planning lawyer quotes from law, I accept that word. That's really what I'm saying.
And Mr. Ishers, when I quote from law, you don't accept it. I mean, are you saying that
yeah,
the
well,
documents
one
here...
officer is paid to give advice, and we are laymen. I happen to be a lawyer, but I would never dream of telling the council that our solicitor is wrong and I'm right. I may have a discussion with him, but I would never in public, even as a lawyer, disagree in public with an officer without giving respect.
Absolutely, Chairman, but in a position where, and if you would allow me to show that, the webcast link to the 10th of April, 4 days after Mr. Isherwood put in his complaint, where Dan Lucas stated, Mr. Hyman is absolutely correct that the catch-all principle does apply. I think it's very important that...
It's not relevant as to whether you are right on the law or not. Therefore, we're not going to see it. Now, I want to
surely,
move
Chairman,
on.
in these circumstances, if I am being blocked and quite clearly what Mr. Isherwood has just said to us in respect of our lawyers always being correct, it can't be true. Our lawyer
That's not what he said. What
he
he said is, when lawyers give advice, he accepts it. That's slightly different.
Yes. So,
say...
if I can refer to paragraph 6.6 again to the Victoria Climbier case and Lord Lamming, who's saying that...
Look, Mr. Hyman, the stage is now reached where we're going to hear your evidence. So shall we do that?
Are you going to listen? Oh, another 2 years of... are you going to listen? Or is it pointless,
of course we are going to listen.
Mr. Chairman?
We have your statement. We have a bundle. Position statement, and you headed it, Defendant, Councillor Jerry Hyman. That document we've got, which includes the ones that came through at 2 in the morning. So...
But you're unaware of Monday's... oh, no, you received because I circulated to all councillors.
Questions about how this inquiry was going to be led, and also involved the complaint about the publication of the documents and certain information about our independent person's email address being on them. I've seen all that. I know what's happened since. It's not totally relevant to this hearing.
In your view, Chairman, I'm sure
in my view, and my panel...
But it's not necessarily a matter of fact. That's just something you're saying. I mean, whether it's relevant to this hearing, obviously, is a matter of, you'd have to... The independent person and Mr. Oram would certainly need to look at it to work out for themselves whether they thought it was relevant, wouldn't they? If you're not going to send people information so they can't see it, they don't have the choice of deciding whether or not it's relevant. You're deciding, the whip of the Conservative Party is deciding whether...
It has absolutely nothing to do with the whip of the Conservative Party.
No, personal interests are completely irrelevant in any justice.
Let us commence. Can I just try and help you out a little bit here? You just tossed the Conservative Party towards this bench, and as you know, I'm not a member of the Conservative Party, although I have been in the past. I can assure you I did receive all the documents that you are referring to immediately after you sent them, and I have read them carefully. And whilst you may well want the independent person and Mr. Oram to have seen them, they obviously arrived well after they had made their respective submissions and judgments.
But are you saying that I couldn't put anything in after they'd done their... Because that's not the case, I'm sure.
Chairman, Mr. Hyman, please listen to me carefully. I didn't say what you're allowed to do or what you're not allowed to do. What I said was this is not a Conservative panel, and that I saw the documents which you are querying were not sent out. They came to me, And I am just also pointing out, because you requested or said something about the independent person and Mr. Oram seeing them, that their reports were made before you sent out those documents. I have not said you can't do anything, so please don't misquote me.
So I wasn't trying to misquote you,
And could I ask
I was
Mr.
just
Taylor,
asking whether you were saying that you knew that they had seen them or not. Because the position, my position is that it's not satisfactory, perhaps, that I have asked a few times as to whether those documents were circulated or who they were circulated to.
The panel have seen them all.
Yes, I know the panel have. The question isn't that.
Right, we'll ask
has the independent person seen
Mr. Taylor, shall we?
Thank you, Chairman.
Sorry, what documents are you showing me there? Was it an email that I sent out with a covering letter on Monday?
I'm showing you now what it was. We had the opportunity.
No, that was sent yesterday. Sorry, that's not the email from Monday. No.
Can we ask Mr. Taylor, please, to
Thanks.
clarify what's been received by whom and when?
Part of the context of this is that the deadlines for receiving submissions to go into the papers were in November, then in December, then January. So all of this has been happening in the last few days. Now, it is not the case that we've looked through the documents that Councillor Hyman's referring to and have decided they shouldn't be part of his submission. As far as I was concerned, there was no request for them to be part of the submission. Now, if there was a request buried within an email that I've missed along the way, I'm afraid that is the result of things happening at the last minute, but I don't believe that to be the case. I did not sit down. When we have spoken this week, Councillor Hyman, I made it very clear that rather than just referring to things in the email and for me to make a judgment about what your submission would be comprised of, that you would need to send me, headed up, statement and annexes to that statement. And that's what you did. You sent me a statement yesterday with two or three annexes, and then a further one during the night. And I looked at all of those early this morning, made a decision about which of those could be an open and which could be an exempt. What I didn't have on my task list at that point was looking at the documents that you sent on Monday. I would have done if I had been clear that that's something that you wanted to have submitted. So, yes, Chairman, there may well have been a confusion between what Councillor Hyman was expecting to see and what is here in the pack. But I'm afraid that is a confusion that would have been avoided if the submission was sent earlier rather than being done at the last minute. And all I can say is that I and my officers in the last few days have worked very hard to make sure that we can accommodate Councillor Hyman's requests, made a commitment to him to share things with the panel that he sent to us saying these are things I want to go into the pack. As far as I'm concerned, we've worked very hard to do that, and that's exactly why you've got these additional documents here today.
Right.
Thank you.
So your evidence...
Mr. Chairman, if I may just come back on that, because it sounds like I've made an error here. I did write to Tom Horwood and I asked that it be emailed to her. I'm absolutely certain that and obviously I would naturally assume anything that is sent to someone else, sent to somebody who is part of this meeting would be sent to everyone. That is generally the rules. If you contact, I had been instructed I am not allowed to get in touch with Miss Cameron because that's a procedure. That's fine. I understand that. Obviously, I wasn't able to email her myself to say, "Hey, your email's been put into the public domain. I'm awfully sorry about that. The council's made this mistake, etc., etc." So please, can you pass this on to her?
Chairman,
and I asked Tom Horwood to forward it to everyone, and I've been told it had. And this is the point. I've been told that it had been forwarded on to everyone. And it now appears that I was misled. Can we just establish that?
The subject matter, Chairman, of the email that Councillor Hyman's referring to, there were two parts to it. And the first part is headed up, Publication of Exempt Standards Panel Information. It relates to the thing that you started this hearing with, referring to the fact that there was a mistake made in the administration prior to this hearing today, where information which wasn't exempt, but which under our arrangements was meant to wait until today to be released, had been released, and that was a mistake. Councillor Hyman understandably and fairly, said, please forward this email to Vivian Cameron, our independent person, and phone her immediately if possible. And it was clear to me that the request there was that there was information that had been put into the public domain, including Ms Cameron's personal email address. And Councillor Hyman referred to the need for us to contact the independent person, and we'd already done that. I had already contacted the independent person, which is right for me to have done, to disclose the fact that there'd been this disclosure, and of course we had already spoken to the Information Commissioner's office. If it was not clear in this lengthy email that actually some of the attachments were to be part of the pack that would be considered at today's standards hearing, then I'm afraid that is because this was going on very last minute and there was not that level of clarity that I would need. So I say again, there was no intention on officers' part to exclude any document that Councillor Hyman has put forward. Rather, we've tried to do everything we can to accommodate Councillor Hyman's needs in the week before this battle took place.
Okay, that's very kind of you. Thank you very much, Mr. Taylor. But I started my email to Dear Tom, urgent please, two matters. Please forward this email to Vivian Cameron, our independent person, and phone her immediately if possible. And I was told that it had been forwarded to her. I assumed that this information had been disseminated, and now I'm being told that it wasn't. And I've checked that a number of times, so I'm quite upset that I've just been misled as to what people know.
You made a request in that email. I've got a copy of it. You made a request in that email. That request was complied with.
And the second element
was forwarded to you?
Yes, it went to the independent person.
Is it? I'll have to ask that when I have an opportunity to ask. I think I'm being told that it didn't.
If she was told what had happened, and also we informed, as I understand
yes, but that's not the same as when you asked to. I did. Please forward this email to Vivian Cameron and phone her immediately if possible. And I did check. And I was told that it had been. So, look, it's not particularly important. It just makes me understand now that there's certain information that people haven't seen. That's okay. As long as I know that, I can understand what the position we're in. Thanks, Jim.
Well, it certainly you didn't request that that email be sent to the panel, for example. Because when you're
it would naturally be if you're going to send something to people in advance of a hearing, it goes to everybody else. I could have said, can you send it to absolutely everybody?
My understanding was that the reason it was being asked to be sent to the independent person was because it was her personal data which had been disclosed, and that I think that's a reasonable thing to assume.
But you would naturally, surely as a monitoring officer, I can assume that you're going to send it to all members. I thought it was your duty to do so.
Never assume anything. It's very dangerous in life.
Am I correct? Chairman, am I correct to assume that if it's that those documents would normally it is your duty to send them to everybody, or am I wrong when you say never assume?
Through you, Chairman, in this case, Councillor Hyman, you had copied in all Waverley councillors into your email, so they already had all of that information. And also, I don't think there is any reason why I would naturally send an email of this nature to all councillors, and there would have to be a specific reason for doing that. There were two things in your email. One was headed up publication of exempt standards panels information. So that was about the mistake that had happened. The second area was not relevant to today's panel hearing, and it's being dealt with separately. So within your email, I did not detect any request for either the email itself or the documents attached to it to form part of your submission to this panel, so therefore it didn't.
Okay, thank you very much, Chairman. I can see that we've got a different view here in respect of what is relevant to this hearing, because we've had the statement.
Well, that's the stumbling block all round.
We do have to have a problem, don't we?
We are dealing with a narrow issue of the protocol. You wish to deal with the whole of the legal issues.
No, Chairman, I want to try and get to the truth. This is all about the issue of whether or not I have whether or not the Lord Lamming was correct in what he said in the Victoria Columbia case, because it seems to me that it applies everywhere else, but we're being told by the complainants, and I'm trying to follow it up, that we do not have the right to question whether the lawyers are correct. And so what I have to do here, Chairman, with respect, is that I have to show that every time that I prove the council to be correct, they simply deny. They will not accept that we should be able to question the legal advice because it isn't always right. We're being told here it's always right, we mustn't, so I'm guilty.
Now, let's just take a step back. We have your summary position statement, which we've read, which is your evidence, and the same as I've treated everybody else, their written evidence is and I will, obviously read it. We have read it all. Is there anything you want to add to your summary position statement before I ask whether Mr. Oram wishes to ask you any questions?
Absolutely, Chairman. Oh, hang on. So have I now... Are you asking me if I have now presented my case? I thought we'd only just sorted out the...
Yeah, well, I'm asking that we now do present your case and that we take your evidence
well, could we please
writing.
start, Chairman? What I'd like you to do, if we can start off, please, by putting up the webcast.
We've already ruled that that is not relevant to your evidence. We're not going to see webcasts
well, if I could just be given a
councils.
moment to decide then, Chairman, because if I'm going to have to approach that in a different way, then I need to have a little think about it, if I may.
Okay, fine.
Is that okay? Can we have a 5-minute comfort break for everybody?
5-minute comfort break, yes, fine. We'll reconvene at 3:20. Just to give the fairness and on the basis that it's only going to last a minute or two, we will listen to this webcast of the meeting of the 10th of April. We have, of course, got Mr. Hyman's transcript, which is in his statement, but so that we can hear it, we have, in the intervening period, found it, I think, so we'll listen to what it says. Thank you.
Yes, thank you, Chair. The catch-all principle does indeed apply, and thank you, Councillor Hyman, for confirming, because you kept your initial question quite generic, and normally your responses are in relation to EIA. So thank you for your clarification. Indeed, you're correct. It does also relate to the habitats regulations, and I'm grateful for your clarification on your point. That answers that particular question. Yes, it does apply.
Thank you very much. Can we have a vote, please, on the amended condition 3 to move the permitted...
That was all we needed to look at, yes. Well, we've been told by Councillor Isherwood that whatever I tell him he doesn't believe, he believes it if it comes from his lawyers. I just want to be absolutely sure here that people understand that what I've written down there is what was said at the time, that...
Now, what do you want
Sorry, may I continue? Mr. Lucas was absolutely... certain there that I was correct and that the position taken by the lawyers, by our lawyers, and this council at the meetings just 10 days earlier, the legal advice we received was wrong. The legal advice we got here on the 10th was that I'm correct, the catch-all principle does apply. And the whole point of these complaints is you're arguing that I was out of order because the catch-all principle doesn't. I was wrong, you're saying. But in fact, just a few days later, I was proven right. And where Mr. Bainbridge is, complaining that I didn't arrange a meeting or whatever to talk about this, I didn't need to. I'd been told that I was correct. I mean, the council was carrying on its own inimitable way, but I'd already been proven correct as far as I was concerned. Why would I spend a lot of time trying to get a meeting with somebody to get them to say in private that I was correct when they'd already done so in public? I wouldn't need to. So,
and that was in that particular case.
And that is, and this is very important, Chairman, because in that first complaint, which is what I'm addressing, in that first complaint, we had a couple. It was the Baker Oates application, wasn't it? The first complaint, and in that application, Councillor Ward and Councillor Coburn had spoken before me, I think it must have been before you started the webcast here, but I know Councillor Ward had started up and said we certainly shouldn't be granting consent to this, and was bemoaning the fact that we were being given advice by officers that there was nothing we could do about it, that we could not revisit the original decision. And Carol Coburn took on board the advice she was getting from the officers, and she was bemoaning the fact there was nothing that we could do, that we were being advised that we had no solid planning grounds for refusing consent to the reserved matters application for Baker Oak Stables. And I was helping them out. I was saying to them, actually, you know, this is where the complaints are, this is what the complaints are about, that I was saying, actually, you know, your officer advice isn't correct, guys. We've got the catch-all principle which applies. We have to revisit it. If a mistake's been made, no appropriate assessment, easy. So we do have planning grounds. And, of course, you know, I can understand, therefore, that if the complainant, Councillor Isherwood, is absolutely certain that he makes a natural assumption that everything I say is wrong and that everything the officers say is right, then I can understand why he was interrupting and stopping me from making that point and why he's upset, but that I was confronting and querying the officers' advice. We know full well that from it's difficult to get an answer out of a lawyer, it seems, but we do know that the duties that are upon us under the Habitats Directive require that we ascertain our compliance with the directive, with the law. And I was trying to make sure that we did. And this complaint is about, you know, in a situation where I was trying to make sure we obey the law, and I have been proven correct by this, but only 10 days later. You know, why on earth has it taken us 2 years to get to this point where I'm able to say in public that, look, I was right there. Please admit it, because it makes a difference. If you, in the first place, you know, when we read through Mr. Oram's report, you can see throughout it that there is pretty much an assumption that I am incorrect. Now, you know, I obviously find that insulting, and I find it disrespectful that I'm naturally assumed to be wrong. I can understand why people do believe that if a council says something to them, it has to be correct. But hey-ho, it isn't. We know it isn't. We know that, you know, that not everything that comes out of Waverley Borough Council is a statement of fact. We have to be a little bit careful. On this occasion, I was correct. The decision to grant consent to the Hopfields, you know, it has been confirmed here, was a decision that was made incorrectly because I was ignored. And what we've got here is the party that's intent on ignoring the law and filling Farnham and the rest of the borough up with housing that we don't have to take because there is a restriction in law, are complaining about me being right. They're putting in complaints where I'm right and they want to shut me up so that I'm not proven right again at any time. And, you know, that's obviously difficult. I have to accept it's a role that I've taken on and people elected me to do, and I come into the chamber and I have to persist. But I was doing my duty at the time. And I was proven correct in that first case. Thank you for allowing the webcast to be shown, because it confirms what I'd put down in writing there. I think everybody should be satisfied that actually I was doing the right thing at that meeting, whether or not I was being perhaps excessively rude in querying that, but surely when I was right, I had to query it. It was a duty. That's what I'm saying, that the evidence that I put in front of you, the annex is particularly Annex 4 there, which explains the law, and you know, and I don't expect our investigation and independent person to you know, to have a full and complete understanding of the law any more than I have, or obviously anybody else in this room, it would appear. But, you know, we're being told constantly, and we have Daniel Bainbridge saying we always obey the law, and we've got the other complainant saying, oh, Waverley's legal advice is always correct. Obviously it wasn't on this instance here. I was correct. Our lawyer has admitted afterwards that, you know, the decision that was made in the November time, when I think I'd only been a councillor for about 3 weeks, or on the committee for 3 weeks, 3 weeks into the job, and I get a complaint against me for being right. for trying to save Farnham from one of the most horrendous planning applications there is. So I can understand why the Conservative Party doesn't want me to be able to talk about this and wants to gag me. Because if they're not serving their residents, if they are putting some wider Conservative Party diktat that says you are not allowed to apply the Habitats Directive properly, you're not allowed to limit development in your area. I mean, obviously, Hopfields is the Hopfields and the Folly Hill applications that went through are terrible for Farnham. I think everybody agrees it. And the Conservatives could have stopped it, and we see here they're deliberately trying to shut me up when I'm telling people that we can refuse consent to these. I mean, if Mr. Ward had known at that time, and Mrs. Coburn, who spoke before me, that actually I was correct and that the law said that we could refuse that the reserved matters, then we'd be in a very different situation. It is difficult for other councillors to know whether I'm telling the truth or not, but when I'm proven correct afterwards, to have a complaint put in against me by the officers and the chairman who were proven to be wrong about it at Farnham's great expense, I think it's a little bit rum that I then get a complaint against me for it, and you can understand why there may be a public perception that it's vexatious. And you know, when you're getting to what Mr. Oram says is a very fine balance as to just cross the line, well, you know, what about our duty under the Nolan principles to tell the truth? To be correct, rather than cover up. You know, we've had all these years of cover-up since I exposed it in 2006 and stopped the local plan then, on the Waddensea issue, you know, which is precisely the same point that the Sweetman case recently confirmed. That Sweetman didn't change the law, as the chairman would like us to believe. Sweetman simply confirmed that the Waddensea judgment does apply to us and that you cannot evade your assessment of your imaginary mitigation by pretending that it works at an assessment, at a screening stage. You can't screen out your mitigation. You have to actually check whether it is, and provide a full assessment in detail, proving that it is effective, otherwise you're not serving the directive. If you're out to make things up, imaginary mitigation, obviously that can't be lawful in terms of habitats. Waverley has unfortunately always tried to say that it is lawful to do that, and they're continuing to say it now, and they are continuing to fail to comply and to give Farnham and the rest of the borough the protection that it requires. And this came up at Aarons Hill as well, and we got exactly the same story from our lawyers, complete and total denial of what the law tells us. That's why I'm very careful only to stick to what the law does say and what Waverley have admitted, because again, I mean, for instance, in 2014, when the Secretary of State, I got the Secretary of State...
Can we just keep to the point of what we have to decide?
I appreciate you don't want me to list all the times where I've been proven correct and our lawyers incorrect.
No, because it's not relevant.
Well, if we've got one of the complainants standing up and saying that here, as the, you know, some of the backing is perhaps the basis of his complaint was that he considers that our lawyers are always right, then surely, Sharon, we're not going to solve this problem until we get certain people to understand that our lawyers aren't always right. We need a little bit of humility, and we all work together to do things the right way, rather than have a bunch of people who can simply say, I'm right, I'm not going to listen to you guys, and if that guy says anything different, you take him to the Standards Committee because we don't like it. We're not going to have anyone question it. I mean, what sort of council would be that way if they didn't have stuff that they were hiding, Chairman?
So
now,
are you saying that if the lawyers are wrong, you can treat them with disrespect?
No, Chairman, because I did not feel that I had... I know we get to the point where you question me later, but I certainly did not feel that I disrespected the lawyers, because the only thing that I actually said there really was misquoted, Chairman, which was a statement of fact. I'm an engineer, Chairman. I mean, you know, I did not think if I say the word misquoted, am I going to end up with a standards complaint against me and be gagged and thrown off of the planning committee and all whatever else people might want. you know, I simply thought that you could see from, you can see from those webcasts that we watched that the chairman does try to control the meeting and control what I can say in the meetings fairly tightly, particularly when I get to a point where we're really getting to the nub of the matter. You know, some certain things have to be sat upon, and that is what was happening here. I could have tried to spend a while saying, you know, in the nicest possible way that I felt that the information provided by the lawyer, that he may have been misled by whoever he had received that information from, or, you know, try to blame it on someone else or whatever, so that people don't take things personally. But, you know, we do have to be thick-skinned, as it says in this document, when we're in councils, a little bit. For me to say that the law had been misquoted, there was no element that was personal in that at all, unless the person who has done it wishes to take it so. It's a simple, you know, if I say, that's a dirty glass, well, the person who last washed that might run out of the room crying because I've criticised their ability to wash a glass. No, it's just a statement of fact. The glass is used. You know, we don't have to all act like snowflakes these days, Chairman. I feel that that's what this is really about. People are complaining because, you know, I happen to be right. I'm probably not right about all of the issues, and I would desperately like to know where I am wrong on things, because obviously that affects my decision-making. But we cannot get anyone to say where I'm wrong. And I think that says enough in itself, actually. If people will not turn and say, look, you are wrong, and I can demonstrate it here. When I turn around and say, look, this isn't an appropriate assessment because it doesn't have the, you know, I quote from the Greek case law, and I say it doesn't have the bird numbers in there, it doesn't have the evidence in respect of the effectiveness of, the extent of the effectiveness of the mitigation. You know, there are a lot of people, another councillor has said it in the chamber too, who would like to get this, you know, sorted out so that we never have to discuss it again. It is incredibly tiresome for me to have to come and do this job constantly and just get people block me and then complain when I use a word misquoted. I mean, what do you think the public out there think of the waste of money of what's going on here today? The waste of time. How much time, apart from giving me answers, how much time do you think it takes for me to prepare for any questions? If I walk into this chamber and I don't know what the process is going to be, and I didn't receive the papers till Saturday, right? There were a load of papers here I did not receive till Saturday. I've got people complaining they didn't receive mine. I got 90-odd pages on Saturday. And I personally have put in a minimal, because, quite frankly, preparing for something where I don't even find out what the process is till the day, I can't find out whether I'm going to be able to question the complainants or not. They don't have to be there. I put in documents, do everything I can to try and get people to ensure that they're sent to everybody, and then I find out that actually they haven't been, even though I've been assured they have. I mean, it puts me in a very, very difficult position. How can I put together a coherent case? I have to come here and babble like an idiot, because, you know, it would take me months to prepare for this completely if I had to sit here and take any questions from people without any idea of what they're going to ask me. And that's what I tried to do. I spent a lot of time. I have got pages and pages of stuff that I prepared, going through everything. But I'd only been given, I think it was like 5 or 6 days to put my evidence in the first place, back in November, so I put in a one-page sheet eventually. Because, you know, I'd got that far, I'd put together about 40 or 50 pages of stuff, and then we came to... I'm going to have to go through all the webcasts. And you know how long it takes to go through webcasts, annotate them, check them, try and put everything together. I simply didn't have time, Chairman. When I'm getting vexatious things, I cannot give people my life and say to them that, yeah, if you chuck me out 90 pages through my door, I'll put a 200-page response back to you within a few days. I can't do it. I'm expected to, and I'm criticised for not doing it, but I can't do it. This is vexatious complaints, a waste of time. I was right on the first issue, Chairman. If I may, let's move on to the second complaint. That was to do with the Cricketers Pub, which is my dad the land at the top of our garden used to be owned by the pub until somebody built a house on it. So you know, I did know the site quite well. We saw on the website that this was. Let me see. We were told there that we do have an avoidance strategy, and this was the officer's response was that we have an avoidance strategy, so we are legally compliant, which was adopted by the councillors, and therefore, if there was a problem with whether we were lawful or not, it's the councillor's problem, not the officer's problem. They're saying it's your policy, you've adopted it, but of course, most of our councillors blindly vote for what the officers tell them to do. So anything that comes from an officer then becomes our policy, and if there's been a mistake in doing it, it's the councillors who are told, it's your policy, don't blame us, by the officers. Now, you know, I have a little bit of difficulty with a system that works that way. As you can appreciate, it's probably behind most of the problems I have with this system. We have to, at some point, though, accept that we have to obey the law, and it's nothing to do with, oh, you decided it's an avoidance strategy, so don't blame us. You know, you just got to look at the fact.
Councillor Hyman, we're not going to go into the avoidance strategy either.
Well,
it's not our role.
Well, that's what you're doing at the moment, Chairman, isn't it?
Can you please limit your extra remarks? We've got your position statement. What I said at the beginning is that everybody would have an opportunity of a short extra words. Now, I've been very tolerant, and we've had about 20 minutes worth. But can you just sum up whatever else you want to say with particular reference to the protocol alleged breaches?
Chairman, okay. The second, let's go back to where I was, because I'd covered the first, where the first complaint, it has been shown that actually the people who were, you know, that I supposedly insulted here, when I said misquoted, when I was questioning it, I was right to do so. I was doing my duty. I was required by law to do so, regardless of how I was being treated, regardless of the fact that those people, as has been proven later, were not giving us correct information. I mean, I could be really upset about that, and according to these, I could rant and rave about it and still get away with it. Apparently, I'm overstepping the mark by saying the word misquoted. But our town is getting wrecked by people who aren't listening and who won't look at the law. But we did get it satisfied in the end. The council will never ever admit it again, of course. The catch-all principle does apply. The second one also covered the catch-all principle. But it also, the second complaint, we were also talking about the appropriate assessment and whether it was whether an appropriate assessment had to have certain information, otherwise it was obviously not appropriate, and if it's not appropriate, it's inappropriate. I don't really understand where people have a complaint with me questioning whether an assessment is appropriate or inappropriate. The fact is that it's set out by law. It's not up to me, and it's not up to you, it's not up to anybody else in this room to decide what is an appropriate assessment and what isn't. The law says what you have to have in there, and it's in the Article 6.3 of the Habitats Directive, in combination effect, and you have to consider the impact in view of the conservation objectives, which is the habitats conditions and the bird population numbers and trends, and they call it bird population dynamics. Of course, we're not allowed to look at that because it snowed in 2008, and this is the big problem we've got. A bit of a mistake was made in 2008. We'd set up, presumably, you know, hard work had gone into it by Natural England and others, and we'd set up a system where it really didn't seem as like it mattered whether it worked or not with sangs and salmon and the rest of it, because the bird numbers were very healthy. They were at twice the level that they'd been some 7 or 8 years earlier when the SPA was designated. So everything looked healthy, but it snowed and we didn't expect it to snow. Everything went pear-shaped and 90% of the birds were wiped out. And we're in that situation again now because those numbers have never recovered since. And obviously, if the authorities had changed their stance at the time and acted, and done things lawfully, then we wouldn't be in the situation we are now, where houses have been built and they're having an impact. And we simply don't know what it's going to, what the impact is, but we do know that it's...
This is not relevant, Mr. Hyman.
Well, Mr. Hyman is trying to tell this... this
Get to the point.
OK. The point here is that what I'm doing is standing up against misinformation that's in this chamber that's leading to appalling decision-making. I have a lot of help from other people. I'm very appreciative of it. Quite frankly, I never ever started on this to do any of it for myself. It was a matter of actually, all we really wanted to do was make sure that this council didn't wreck our town. It's ballooned up into a lot more than that because they're wrecking all of the towns now. But if I come in here and tell the truth and I'm constantly disrespected and people are blocking me, stopping me talking, insulting me, I'm not allowed to say any word against it whatsoever. I'm entitled, I think, to have my day in court when when we address the matters. If we go to our second complaint, which Mr.
Twice now.
Yeah, that's okay. I'm still continuing. We're at page 65, Chairman, isn't it? Which says, and this is what I'm. This is what I'm accused of. It's a terrible thing to do. In the middle of page 65, it says, "I thought we were here as councillors because there are occasions when the advice we receive is wrong. Otherwise, we wouldn't need any councillors." I think the logic there is obvious, because obviously, why would we need councillors if the officers are always right? We'd just let them make all the decisions. We never, if we can be guaranteed that officers are always correct, there's no point in having a councillor, is there?
Councillor Hyman, officers give advice, councillors use their discretion to decide, based upon the legal situation we're in and other advice given, where we want to go.
Yes, absolutely. So, and we're allowed to, as Climbier case said, that we are allowed to question it, unlike what Mr. Isherwood seems to think, unlike you've told me in the chamber before. We are actually allowed to question that advice, and that means that we are allowed to be contentious. We are allowed to face up to the issues. Where I say I've thought we're here as councillors because there are occasions when the advice we receive is wrong, otherwise we wouldn't need any councillors, the chairman turned around and said, "Excuse me, that is strictly against the rules." Now, I have difficulty believing that there is a rule that says that I'm not allowed to say that. I'm not allowed to suggest even that there are occasions when the advice we receive is wrong. And we end up with this massive, ludicrous circus going on. It's cost a lot of public money and a lot of time and a lot of heartache. We're here because I said there are occasions when the advice we receive is wrong, otherwise we wouldn't need any councillors. And the chairman said, "That's strictly against the rules, strictly against our code of conduct. You cannot criticise an officer." That was a personal criticism of an officer, supposedly. I mean, who in their right mind would turn round and say, you can't criticise an officer, when all I've said is there are occasions when the advice we receive is wrong? I mean, ridiculous. They said, "Please withdraw that." And I'm then bullied.
Okay, you've made that point.
Bullied.
Next point.
I'll give you my evidence, thank you, Chairman. I am then, as you can see, bullied. "Please withdraw that," it said. It wasn't an officer, criticism of an officer, Chairman, I said. This is what we're meant to be considering, I think, Chairman. And I'm told, yes, you were. And then I say, if it was taken as a personal criticism of an individual, I'll withdraw it. But it wasn't meant that way. It's simply a statement that not everybody's right all the time. "I would like you to withdraw the comment, please, councillor." And, this is the sort of behaviour everybody has to face here. And it makes everybody want to come here and be a councillor, doesn't it? And we get that sort of behaviour.
Councillor Hyman, can I just interrupt you?
Mr. Bell?
As a panel, we accept entirely that you're allowed to comment and make your own observations as to some of the advice you're being given. The issue before us, as this panel is the code of conduct and relates to the method and the tone of which you make those comments. This is the issue. This is a single issue. The issue as whether you're allowed to criticise and make comments is a non-issue for this discussion. It's just that single issue as to whether your conduct and manner in making these comments on those meetings was either in accord or not in accord with the code of conduct and the officer-member protocol, which you yourself have signed, and from that we understand you undertook to abide by. So that is the single issue. I think you are frankly doing yourself no service going on to the wider issues of whether you were right or wrong or whether the officers are right or wrong. That they are not relevant to the discussion today. That they are relevant issues, I think we would accept, but they are not relevant issues for this particular panel on this particular day. How we address those...
Chairman, I mean, we do keep going back to this, don't we? Because as I started in the first place, and I feel like I've been blocked all along from actually considering the circumstances, because it's all about the circumstances. And if the circumstances are that someone else is wrong, forcing us, we don't know why, what their personal reason is. I'd love to know the reasons why. If we've got people who are there stopping us from making the right decisions and it's wrecking our towns, ruining things for our residents, we are not allowed to represent those residents. That's what I'm being told today. And you're telling me that we're not allowed to consider the circumstances.
No, I don't. With great respect, Councillor Hyman, we have not said that. You have made the point, quite forcibly, and more than one occasion, both this morning and this afternoon, that you consider that the circumstances under which the comments were made are relevant for the panel to consider. We take that as a panel on board. We have seen the webcast, and it is now up to us to take a view of our own. You've made a point. It's an entirely relevant point, which I think we all accept around here, that continuing with this issue and going into on and on about it, frankly, is doing you no service in allowing us to come to a conclusion one way or the other.
I do appreciate your interjection there, Councillor Bandon. That's, and I agree. I mean, that I might not be doing myself a good service here, but I do appreciate that this wants to be, the only way that the Conservative group can possibly bring this forward is to try and keep it extremely narrow and not consider the circumstances. And I'm having to I've tried to point out that it's a duty in the circumstances, Chairman.
Councillor Hyman, I object to that. As a panel, we are following council protocol. It's not an issue of Conservative policy or residence policy. It's a matter of existing council policy. I don't think any three of us around this table here want to be in this situation. We are in it because there is a council procedure and we've been appointed to hear it. It's not something we enjoy doing. It's not something that we would prefer to spend our Friday doing. But we're here because it is protocol. It's nothing to do with party political issues. It is council policy we are following. Thank you.
Well, thank you. And yes, and I've had 2 years, not just a Friday. If I go through my summary position statement, Chairman, I am sorry it hasn't been possible to reach an informal resolution to this matter because I've always all along said that it was vexation. We should be able to, but I have not been in a position in that time to know what the complainants wanted, what sort of results they would want. And it had been suggested, I think, in the evidence of Mr. Bainbridge that what he wanted to do was to remove me from the planning committee so that I couldn't question these.
I don't think that is right. I would have thought it's pretty clear from Mr. Oram's report and the meeting you had with the monitoring officer and the independent person. It was pretty obvious what we were wanting. But that meeting didn't come to a conclusion because you wanted to raise the legal issues, which was made clear by the independent person and the monitoring officer. That's not what they were there for.
Okay. If I may refer to page 22, Chairman, where it says, and this is the end of Mr. Bainbridge's complaint letter, and it says at the third paragraph there, and let's skip the first half of it because I think it's a little, it says, oh, well, no, it's difficult to take, not to take it in context if you skip it. My concern is not just for members of my team, but also for other officers who see their colleagues being spoken to and about in this way in public meetings, and who will be wondering how they will then be treated when they're in a position of advising a council or a committee. Of course, I look at it from the residents' point of view. How would, how residents will feel if they're going to be treated this way in a committee. He goes on, having said that, I am nevertheless seriously concerned for the way in which members of my team are being treated by Councillor Hyman. But bear in mind, I'm being shown to be correct, and these people are giving us incorrect information. This behaviour will, should it be repeated, lead to me considering whether I'm willing or able to provide a legal advisor to any committee or meeting of which Councillor Hyman is a member. I took that, and you're telling me I'm wrong, as saying that if Mr. Hyman does not stop questioning my lawyers, I mean, they should be able to stand up for themselves and answer the questions, you'd have thought, but if I do not stop asking them these difficult questions, then he's not going to be able to put any lawyers on the committee. Now, that says something, that's very, very important, because surely, Mr. Chairman, that if Mr. Bainbridge isn't putting any lawyers on the committee and we require it, he's not fulfilling his function. He's actually saying that he needs to consider his own position. That if I'm not found guilty of this, Mr. Bainbridge is either going to have to leave if I'm not taken off the planning committee. I don't know how that can be read in any different way.
Well, I think you're making assumptions.
Well, it's interesting because I did mention this and everybody shouted me down, but it is what it says here, isn't it? I thought that's what he was saying.
Doesn't mention planning. You're on other committees on this council.
Sorry. Into that, I'm never concerned members of my team would be treated by council. Members of my team, so his lawyers are being treated. That would only be in planning meetings, I think, wouldn't it? And this behaviour will, should it be repeated, lead to me considering whether I'm willing to be able to provide a legal advisor to any committee or meeting on which Councillor Hyman is a member. OK, so you're saying that, yes, it's not just planning. Actually, he's not going to be able to provide a lawyer to any committee. But it only actually applies to planning, I think, I would imagine. I'm not allowed to ask him any questions, but if Mr. Bainbridge would like to say anything at this stage,
is there anything more you want to say in your evidence? You've been speaking for an hour already, and it was just anything to add to your written statement.
Well, that's what you wish, yes.
But I think you should be finishing now, otherwise we're not going to finish today.
Well, as I've said, I invite detailed scrutiny of my position, and I've been trying to get some straight answers and just get straight to the points. But let's lay them out for anybody who doesn't have them, the position statement in front of them. My position is firstly that the words that I used.
No, Mr. Hyman, we're not playing to the gallery. All the other statements have been taken as read. So will yours. You're going to be treated exactly the same. We did not have Mr. Oram reading his report from cover to cover.
Yeah, but that was 92 pages and
we're not having yours either, and I made that clear at the beginning.
Well, there are only 5 bullet points there, Chairman. Is it possible for me to go through them? Well, sorry, not 5 bullets, but points 1, 2, 3, 4 and 5. I don't need to go through.
We have read them.
So
you
know
don't
my case
need to read it.
OK, so it's already been decided. In that case, Chairman, I will. I think I just need to take a second because I need to make a summary here.
No, you do a summary at the end.
OK, in that case, Chairman, let's move on.
Right, Mr. Oram, have you any questions of Mr. Hyman, Councillor Hyman?
Councillor Hyman's already given me plenty of his time willingly during the course of the investigation and gave me ample opportunity to ask all my questions then. Any other outstanding queries that I might have, I think, have been addressed already by the conversations that have happened within this hearing. So no further questions from me.
Thank you very much. We now move on to the independent person, and we have the independent person's statements on pages 79 and 81 on Annex 10 from Vivian Cameron. Is there anything you wish to add to those statements? Yeah, but speak.
No, not in relation to anything I've heard today in relation to my statements.
You've read, I think, the report of Mr. Oram.
Yes, I have. And
do you agree or not agree with his conclusions?
I have prepared a short statement
Good.
giving my reasons for my decision in relation to the breach.
Okay. Would you like to give it?
Would you like me to pass it to you, or would you like me to read it?
Would you like to read it?
Okay, I'm happy to.
Thank you.
I've only focused on the wording used in the council meetings and how they were presented to others in public arenas. I've not considered or have the knowledge on the underlying legal issues that Councillor Hyman has quite passionately been discussing. Based upon the evidence I've heard today, I feel he struggles to put his strong and sometimes correct views over in a respectful manner, believing he is always right, with others often being wrong. However, I feel he does not believe he is disrespecting others just due to the fact he doesn't recognise how his approach offends and sometimes intimidates others.
Thank you very much indeed. Councillor Hyman, do you want to ask any questions of the independent person?
Thanks, if I may. I do appreciate your kind advice there, I fully accept that you don't have any knowledge of the legal issues behind it. And so, you know, where this, to me, looks like a question really simply of, you know, are you supporting unlawful activity by our councils? Or I've been proven right constantly, and we just get denials all the time. The council can do no wrong. You're not actually able to take that into consideration in your judgment, and it's simply a matter of whether I'm addressing somebody, you know, whether I'm addressing people correctly or not in the chamber. Now, when I watched those webcasts, I thought I was being very restrained, very reasonable. I wasn't ranting, raving, or doing anything that was threatening, or none of the things which I apparently could get away with if I knew I could, but I hadn't realised. That's what we were allowed to do. But yeah, I'm slightly surprised. Can I take you to there are a couple of emails in your evidence, aren't there? There's some emails which page 79 at Annex 10. And you say there, you found that, yeah? At the top, so you have an expanded window and read everything. You said you've not watched the web version, but the written word was very concise. After watching the web versions today, you probably never want to watch a webcast from Waverley again. I can understand that. And we have to put our lives through this. Yeah. Anyway, it says, firstly and predominantly, Mr. Hyman is advising you his refusal to discuss this with you informally, even to give his version of events. This is bad enough. I hope you understand from today that actually, you know, that was a slightly skewed view of what was going on, that I had this heart attack the day that after, 2 hours after I read this stuff, and obviously was not in a position to come along. I did not arrange a meeting. It looks like I was being rude and didn't turn up for a meeting. We hadn't arranged a meeting. I hadn't agreed to one, so obviously I couldn't turn up. And there was medication, all the rest of it. I can't. And of course, we'd just been through Surrey elections at the same time, and I had agents' duties to do.
Could we have a question, Mr. Hyman, rather than another statement?
Well,
the poor independent person knows what she needs to know, what she's got to answer.
Yes, absolutely, Chairman. So, are you happy that, because when we get through this, you say, however, to totally ignore your request by refusing to even respond to you regarding the matter is unacceptable and surely must be seen as a breach of respect in itself. Can you understand? I took that as quite an unnecessary criticism, an unfair criticism. I hadn't actually been in that position at all, and I thought that you'd perhaps misunderstood or been misled as to, my attitude towards this, as though I was just saying, well, I'm not going to talk to you about this because I don't like what you're doing. Do you still feel that that's the way that Was that fair, the comment that you made?
As far as the comment I made dated the 31st of July 2017, the information that I actually had prior to writing that, I'm afraid I just can't remember. It's rather a long time ago, and I'm obviously not involved in this on a day-to-day basis, so it's very hard for me to accurately answer that, I'm afraid.
Maybe that to assist you, Councillor Hyman, and to assist the independent person, if one looks at page 8 of our papers, where we've got the monitoring officer's chronology, might put the thing in context.
Chairman, that is correct. The timeline is the place, if you want to comment, the timeline is the place to look there. And also, Ms Cameron's email there was in response to my email to her, which is listed below, that begins on page 79. But in terms of the timeline, what you'll see there is that there was an initial attempt at an informal resolution. That was the 25th of April 2017 with a face-to-face meeting. And then Councillor Hyman was invited to submit comments. You'll see then that there's a bit of a gap, and that's represented in the timeline, and that's described as a mutually agreed pause. During that time, I wasn't chasing for a meeting. During that time, I wasn't trying to set up a meeting or asking for any written comments, because that was a mutually agreed pause for the reasons, personal reasons that Councillor Hyman himself has referred to. Actually, it was then during the period of July, the 3rd of July meeting was arranged with no attendance. Because there was no attendance, there was then an invitation to submit written comments by the 10th of July, and there were no written comments delivered. So,
sorry, Chairman, can you just... had I agreed to a meeting on the 3rd of July?
We'd invited you to a meeting, and you didn't attend. And because you didn't attend, we then followed up in writing instead, saying, as you didn't attend the meeting, perhaps you'd like to submit comments instead, and then you didn't reply to that.
My recollection was that you asked if we could put a meeting together, and I know that my constraints at the time, you have to bear in mind that, you know, this is a summertime and it's only a couple of months after I've had the heart attack and I was recovering, I had a lot of things to do as well. I hadn't agreed to a meeting, and I keep being told that I had arranged a meeting or had agreed to a meeting and didn't turn up for it. Now, you know, I'm self-employed. I can't, when people do these things to me, I can't give them my entire life regardless. You know, I seem to be being criticised for something I hadn't agreed to, for not turning up to something and you're saying I had agreed to the meeting.
That's what it's saying, and I only put it in the context that you were asking the independent person why she'd written the way she did, and she wasn't quite sure why she said what she said, but it was helpful to see that no doubt she was told by Mr. Taylor that these were the facts before she wrote her view on the 31st of July. I thought that might be helpful to you.
Thank you very much. I'm happy with that, and I wasn't taking any issue at all with what Vivian had said. It was more what the monitoring officer is still saying, that I'd agreed to something that I didn't turn up to, and I just want it to be clear that I didn't. You know, if I've agreed I'm going to turn up to a meeting, then I'll do everything possible to get to that meeting, regardless. But and I have a near 100% record for my meetings at Waverley.
Any further questions of the
yes, well,
Mrs. Cameron?
Yes, absolutely. In relation to the actual allegations, you go on to say, Vivian, that reading through them, you form the opinion they may well breach your codes. But you said at the beginning that you hadn't watched the website. Has it helped you at all in watching that? I know it wasn't particularly nice, but nevertheless you saw what the mannerisms were in the meeting and whether I was bullying or being nasty to people or whatever. Are you still of the same... you had the opinion at the beginning because you can see that, you know, obviously you'd been asked to make a decision as to what you felt about it at the time. Your decision there wasn't predetermining this meeting in any way, and you're free to change your mind, I assume. I'm here because I wouldn't be here if I didn't think that was the case. Do you feel, knowing that we've got to the stage now where, you know, we have at least had some sort of admission, it's like pulling hen's teeth, that it is my duty,
nobody will admit it, as you know, but it is my legal duty on habitats overrides the code of conduct when push comes to shove. That legal duty, because the code of conduct isn't a legal duty, that is a code of conduct. It's not a duty to the law. And it's up to me to decide what is necessary at that time to conduct my legal duty properly. And I was being blocked. Do you understand?
Let her answer the question. You've started about 3 questions.
Thanks,
One was,
John,
have you changed your mind since you've seen the webcasts? Secondly, do you accept that if something's been done illegally, then that takes precedent over codes of conduct? In other words, you can say what you like. Those are the sort of questions I think you were asking, weren't you, Councillor Hyman?
Yes, thank you very much.
I think in relation to have I changed my mind, no, I just think it verified what I'd seen written. I'll just refer you back to the statement I made just now. I can't answer your one on your legal question. I'm not qualified to make that sort of judgment, I'm afraid. I don't know about the law between a legal issue and code of practice. As far as I'm concerned, it doesn't matter what it is, we should be respectful to other people. And that's what
And
I've
even though I was
said.
right, and other people were being incredibly disrespectful to me, obviously because they were telling me I was wrong, you understand that in those occasions I was being told I was wrong and they were right, and in fact it was the other way around. So the disrespect was towards me, not towards them, was it not?
It was the forum. It was done in a public arena. It should have been done quietly somewhere else.
But if that's not possible, if you can't actually get... Because, you do understand this has been going on for 10 years, and the council has... I've shown a number of times, and there have been legal rulings, the Sweetman ruling recently. You were told in here that I was correct about it, and not to worry your head about it.
But it still happened.
Sorry, what still happened?
The disrespectful manner in which you spoke to these people, which offended them, still happened, whether you were right or wrong.
Okay, so when I said the word, what was it, I keep trying to find the word that I was that I'm actually accused of using in the first one, where I was misquoted. I said misquoted. Did I say that in a horrible way, or something that was? How was that disrespectful? Because I'm having difficulty seeing what I've got to do differently here.
You were challenging a professional in public, yes. A professional's opinion in public. If you'd have done it privately outside, I'm sure the person would have been happy to converse with you, but it was in a public arena. And
that person was, at that time, I mean, I was questioning that person, which I'm entitled to do, obviously, in a public arena. And that person then gave the wrong information, as we know, in retrospect, as was admitted, that person was actually coming back to me. So they were disrespecting me. And do you understand that I would feel a great deal of disrespect when I know that something's right and I'm just asking a simple question about it and I get blocked? And this person who you're saying that I am disrespecting is actually being extremely disrespectful to me as far as I'm concerned, because they're just turning round and telling everybody I'm wrong.
But the other person believed they were right. You believe you were right. They believed you were right. The way to move forward on
so they should make an apology afterwards to me.
Is in public, not in public, in a private.
And if you can't get any progress in private, because the council obviously isn't going to admit to any of this anyway, what do you do about it?
That is not my remit today. No. My remit is just purely the breach.
Right. So you think I should spend all my money going to court instead of being a little bit robust in the chamber?
I can't comment, I'm afraid.
Okay. So if we move on now, you're being very kind in trying to help us out on this and give an independent view, and I do appreciate it.
Thank
and
you.
I take on board exactly what you say, because I know that it is taken. I'm an engineer. I have no speaking skills. I don't have those people's skills. I'm doing a job for people here. I'm not here to try and make friends.
Any other questions? We don't need another statement. Any other questions before we move on?
Yeah, we'll move on to the reports that Ms Cameron put in, which is on page 83, I think. Is that right?
Yes, it is.
Yes?
Yes. Okay. And you went through this, and we had a meeting there which was about an hour and a half. Now, I came along to that meeting, I had being criticised of not going to them. Did you have any problems with meeting up with me there? Had it taken a long time to organise it or anything?
Oh, you're
I thought it went okay, didn't it? There wasn't a problem. I gave you a choice of dates and we arranged it. I said any date.
I don't think I can answer that because Vivian didn't arrange it. I arranged it, and there was no real issue with arranging that meeting. It took a few weeks, but it was always going to with 3 diaries.
Thanks very much, Mr. Taylor. Okay. And again, you were completely tied in here to the issue of the legal points weren't your consideration. And you said that in the difficult to count the paragraphs, 1, 2, 3, fourth up from the bottom is the easiest way to put it. I had been made aware. And it says, I've been made aware prior to the meeting by Mr. Taylor that Mr. Hyman fought a legal point. I know Mr. Taylor then came back to you and clarified he didn't mean that I'd fought them in court, that I'd fought on a legal point. So, you know, we're not going to go that direction. He said, fought a legal point and had been found to be correct. Yes. Do you feel that you're getting an admission here from people that that is the case, that actually, you know, I was right, and this is the issue at stake in the second judgment just as much as the second complaint. Are you happy to accept that even though we're not here to look at the those detailed legal points, do you think that I was correct, or do you take what Mr. Bainbridge and Mr. Isherwood are saying, which is now that they never break the law?
She can't comment.
That's not my remit.
Is there no, absolutely not. But I mean, you know, to anybody with I'm just thinking about a bit of logic. If someone says to you that I've been found to be correct, that would mean that if I was fighting it, then the other side had been found to be wrong. Would you agree that, or because otherwise you're not really fighting? Councillor Hyman,
we've already.
I know you don't want it to be discussed,
has
Chairman,
made it very clear what her remit is. Seeing Mrs. Cameron's report, 2 pages, 83 and 84, is there anything in that report which you say is inaccurate as to what happened? Because that's what you need to ask about. Are you happy that what's recorded there by Mr. Cameron is accurate?
If you want to conduct this for me, Chairman, that's...
Trying to be helpful to try and keep it to relevant issues.
Yeah, well, your view of relevant issues is different to mine because I know the background to this, and you know, I obviously don't agree. I could not agree to the. Did you appreciate that I was not in a position to agree to the demands, because I had a little bit of a problem with the meeting that I came to with you, because I thought I was going to get listened to at that meeting for the first time somewhere. I was going to go to, you know, Mr. Oram I'd met with, and that was great. But when I got his report, I thought, well, hang on a minute. You know, he's completely all the way through assumed that I'm wrong in writing this. And if you knew I was correct and then reread that, you would read it completely differently. And that's how I felt after that. But I understood that he'd done an excellent job in actually saying, right, let's keep both sides happy. You know, we've got to make sure that Mr. Hyman doesn't criticise officers and make personal remarks about them, which, you know, that's not something that I want to do in a planning meeting. I address the facts. Questions, please. So, Chairman, you throw me off there. You've commented in here that we had an hour-and-a-half meeting and I spoke for about an hour of it. I thought that I'd come along to be listened to, and that we were going to try and you know, move forward with this. And I thought you understood that I was unable to make a local resolution because the terms were simply unacceptable. I couldn't turn around and say, no, I'm wrong. I could say, I'm sorry, I'm wrong, because I knew I was right. So, and that would be completely the wrong message to send out. It's a very simple message. I know that the chairman would try and say, well, Mr. Hyman, you'd only be saying wrong about whether somebody might have taken what you said to be a little bit rude. We're not talking about whether you're wrong about all the legal stuff. But no, surely, you know, it's the same as coming out of today. The council is going to want to turn around and say, look, we found Mr. Hyman is wrong, so that I can't attack them on these serious legal issues that are costing our borough dearly and really upsetting our residents.
Statement, please. Or rather question, not statement. It's getting to me at
demanding
20 past 4.
Okay. Do you feel the same now that, you know, I think you're a little bit more aware today that it has been confirmed I was right in those situations. Do you think I was right to not take the option of submitting?
That isn't for me to answer, I'm afraid. That is your decision.
I value your judgment because you've been very fair in other areas, and I thought that was, you know, you might be able to help me out, because I feel that I was right all along to say I can't agree to this, because if I agree to this, but in your letter I feel like I'm almost being, you know, I came to this meeting, I didn't realise that the meeting was about me submitting. I was pretty much being told that, you know, this meeting is about me giving in and saying sorry and all the rest of it, and then we can all go away happily. And I didn't understand that when I came to the meeting. I expected that my case was going to be listened to, and I thought we'll get, you know, the whole truth out and whatever. And I can understand you went there.
Can I say I did listen, but the part that you wanted to bring up and you kept repeating wasn't in my remit. And I did make that clear in my report that you had come with a different expectation than what I was able to give you in the role that I have.
But surely, I mean, I have my duty is to the residents, to represent the residents' views, regardless of how inept I might be or what sort of village idiot I might be. I may be completely, you know, the wrong sort of person to be a councillor, probably am. But, you know, we've probably got 57 people in this council who are all the wrong sort of the wrong person, so we have to make do with what we've got at the moment. You know, if we're going to be giving a message out to the people, we've got elections in a few months' time, and, you know, the idea is, you know, the question here today is, do we have to take control and throw this lot out, quite frankly? You know, in this election.
Let's not get political. Mrs. Cameron is not a political.
Well, no, this is a position that we're. This is the position that we are in today.
If you've got no further questions, can we move on to summing up?
I do wish to, because there was a.
Well, let's have a short, succinct question.
Top of page 85, Vivian. Where you've got a letter from the monitoring officer, and he says, thanks very much for your note and your time at the meeting. The reference to the legal point was about the council responding to case law that Mr Hyman has closely followed, rather than Mr Hyman himself bringing forward any legal challenge. And he's put that, and it's important for me to put on record that the council's previous approach was correct and acceptable. So you're being told here that even the council admits that it was wrong and that I was right. That's what you've been told. And that, but at the same time, they're saying that they were doing things right. Did you question, or, you know, in your mind think to yourself, oh, hang on, it can't be both. They can't be saying that, oh, we were doing the right thing, but, oh, we've had to stop, change our ways, and Mr. Hyman's position has been found true in law. Did you not question that? You know what I mean? You'd have to be a lawyer to be able to see that.
No, and I'm very confused. You're confusing me. Could you be a bit more specific with the question, please?
Okay, let's try and go back again. We've said before on page 83, it says that, and this is the fourth one up from the bottom, it said, Mr. Councillor Hyman fought a legal point and had been found to be correct.
Yes.
Okay, and then on the next page, you're being told by the monitoring officer that say, it's important for me to put on record that the council's previous approach was correct. So, do you think there's a contradiction in there? How could I have fought a legal point and been right, but the council was right at the same time?
It still isn't my role to get involved in that.
But I'm just wondering whether, then you go on to, they say, the monitoring officer says, in line with what other authorities did, so everybody's doing it, but has been revised in light of the recent case.
I don't think you can be asking the independent person questions about somebody else's email. What the monitoring officer wrote in his email is what he wrote, and you can't be asking the independent person what he meant by it.
I'm not asking the independent person there. I'm just pointing out the information that was available to the independent person here was that I had been found correct, and then we've got an email from the monitoring officer saying that, that actually the council was correct, and that but even though they were correct, they're changing what they're doing. And then, Chairman, please, if I may. It says that, however, there is no need for you to change your notes, especially given that the meeting was to discuss conduct and not legal technicalities, and in any event, it is not your role to worry about those details. Now, you know, to me, if I'm being told, if I'm acting as an independent person and I've got absolutely no knowledge of the legal side of it, and I don't expect Vivienne to have any, her skills are clearly elsewhere, and she does a good job of it, but I'm, you know, she's very, very good on the personal sides of things. But if I was given information that the accused was actually correct, but the council then isn't admitting that it was incorrect, but it has revised its stance, and then says to you, it's not your role to worry about it. You know, I think it would flag up to absolutely anybody. And I'm asking our independent person why it wasn't flagged up to her that quite obviously she was being told that, hey, look, keep your eyes on this narrow remit here. For goodness sake, don't look at the fact that Mr. Hyman has been proved correct.
You're making a statement again, Mr. Hyman. Are you unable to phrase a question?
Did it not flag up anything to you that might be a real issue here, that there might be a big issue of fraud or something which is being covered up?
No, it didn't.
It didn't.
But what it did do is highlight that where I did make an error, because of my lack of understanding of the process, that it was corrected. And
sorry, what error was corrected?
It was corrected in that email to say that I had misinterpreted what had been said. So,
oh, hang on a minute. So where you said...
Where I said about the legal point.
Yes, well, that Councillor Hyman fought a legal point and had been found to be correct. And then... so you were under the opinion that that meant that I'd won in court? Were you or something?
I'm afraid I can't remember.
I didn't think you'd said anything incorrect, but you said it was corrected, so I'm now the confused one. Sorry, Chairman, do you understand what I'm saying there? That, you know, it says here that I'd fought a legal point and found to be correct.
I don't think it's relevant. Well, the independent person has given her report. The independent person has given an account of the meeting. You're not challenging what was said at that meeting, so what else is there to ask the independent person, I ask myself?
Well, finally, only that you'll appreciate, I think, from a lot of what you've heard today, that one of the main points that I've been making is that we have got a strategy at this council of which a lot of people aren't particularly happy, which poses an extreme danger to the endangered species and the environment. We've got quite a lot of history where, as you've seen from this, you know, I've been contesting the council over many, many years on issues, and I've been found to be correct, and I've been limited, in a very limited way, successful with the help of a lot of other residents, alongside other residents, in getting things changed. But
you're making another statement.
The big issue
I'm not
here,
having any more statements from you until you sum up, Mr. Hyman. If you have any further questions of the independent person, please ask it succinctly, or I'm going to move on.
if you were part of, or you know, if you thought that the position that you were taking was going to have disastrous consequences for democracy, for a start, in anybody thinking to themselves, would I want to be a councillor if I'm going to be treated that way? You know, if I'm just going to say a few odd words which are totally, there's absolutely nothing in the words whatsoever. Would you? Well, just a moment, if I can, if you don't mind, finish, because you know what people see here is that we've got some independent people, and we want to make sure that those independent people are doing the right thing. And I want to ask you if what you will do is support openness in this council and support councillors who, so they know that if they come along, if they become a councillor, they stand, they join the democratic process, they get elected, full as I am, like I did. And if they come into this council and they have political opposition who wants to just, or officers who want to take offence at something, perhaps slightly more than might be justified.
It's not the role of the independent person.
If those people are covering up what
Councillor
amounts
Hyman,
to...
I am not having you attacking the independent person in this way. She is not,
attacking
She is not here. If you read her the protocol for the independent person and have taken that on board, this is not her remit to, as you put it, clean up this council and so on and so forth. Her only involvement is when there are problems that the monitoring officer has to deal with. That is all.
I think I've misunderstood the process, Chairman. I'm very sorry. I thought that what we had here was a panel that would quite clearly be, to some extent, political, and what we had was independent people, and they would make a recommendation to you, and in order to show that this isn't a kangaroo court, as people out there might call it, then what the independent people say, you will abide by, and therefore...
No, we will take the advice of the independent person. I asked the advice of the independent person. The independent person said to me, to the panel, that she agreed with the conclusions by the external officer, and that in her view there were breaches of the protocols. Now, she's given that advice, and we will have to decide ourselves whether we agree with the independent person or not, because we don't have to do exactly what the independent person says. We will make our own views, having heard all the evidence and heard what you have to say and everybody's had to say. When we retire shortly, we will then decide the matter. She's given, Mrs. Cameron has given us her views, and she's not flinching from it, and that is her role. End of story.
I'm sorry, Mr. Cameron. I mean, obviously, this is difficult where we're in a situation where I'm not allowed to get the truth out and you're not allowed to be told the truth of the situation. You have to wonder whether I'm right or wrong, because nobody will actually answer the question, any of the questions we're trying to put forward. But can you tell me, if you were absolutely satisfied and if you weren't absolutely satisfied in your mind that you were doing the right thing, would you still make the same recommendation? If you thought that this could end, that you were in trusting what you're being told by the officers and everybody else, and not taking independent advice yourself and really getting to know the legal side of it before you make a judgment, that by actually taking the position that you're being asked to, whereas don't consider whether this is right or wrong, don't consider the legal side, don't consider who was right. Do you think that's a safe way for us to make a decision today, or for the panel to make a decision today? Because, you know, you've being
asked the question, let her answer it.
I've made my decision only based on the information about the breach of the Code of Conduct. As I particularly worded here, you know, you are very passionate about your legal issues, but that isn't part of my remit. I can't really comment on the bigger picture. My role is purely very limited, based around breaches of the Code of Conduct, and that is all.
So, can you understand that when I see that we're in a process here where, because everything that the council does is ruled by law, you know, we are.
I think you've made your point, Mr. Hyman.
And we're not allowed to consider that, and we can't consider what's right and what's wrong.
I'm sorry, I can't help you further. My remit
but I would appeal to you
focused.
in your recommendation, if you don't mind, in your recommendation to the panel, to say that in the situation you don't think that you are able to support a gagging order.
Given her opinion, you can't pressurise the independent person to change her mind. It's not your role to bully
It's
the
a very
independent
interesting
person
system,
to say
isn't it,
something
Chairman?
else.
This is an extremely interesting system. We're learning all about it. Who on earth would want to stand as a councillor, eh? It is very strange, isn't it?
Right, well...
Well, thank you. But I would like to thank you very much indeed for what for the effort you've put into this. And I know you do it voluntarily, and it's, and I respect that and I admire that. I'm sorry that you got dragged into this.
Well, thank
and I'm
you.
sorry you've been here all day as well. But
I appreciate your comments. Thank you.
Okay. now we've reached summing up stage. I don't want any more evidence, thank you. Mr. Oram, is there anything you want to add?
Well, just to sum up, Councillor Hyman has mentioned that he felt at the 2 meetings in question that are under scrutiny today, he was very restrained. And having seen his performance today and having spoken to him at length about these matters, I would agree he was restrained. He said some things today and during the interview that were far more inflammatory than he said during those meetings. And I think he's been thoroughly indulged in doing that today. What we have seen, though, in respect to the allegations that have been made, are webcasts of the 2 relevant meetings in which Councillor Hyman publicly accused legal officers of allowing the council to make unlawful decisions, of misquoting the law, and of representing inappropriate assessments as appropriate assessments. Interestingly, we also were shown a webcast of Councillor Hyman drawing our attention to a legal officer providing what he said was excellent advice. It so happened to be advice that he agreed with. I have been accused of writing a report which says that everything Councillor Hyman said in relation to the legal position was wrong. I could not have been clearer, either in my report or today, that the legal position taken by either party has not played a part in my consideration as to whether the code was breached or not. The reason I think the code was breached, I've just mentioned his accusations towards the officers. Now, legal officers at the council have a professional responsibility to make sure that the council conducts itself lawfully. Councillor Hyman claims that that too is his aim, and he's clearly incredibly passionate about this particular issue, and whilst I'm not an expert, he seems very knowledgeable about it. My question to Councillor Hyman in my report, and which I would repeat, is I believe his level of frustration at what he sees as being ignored has meant that he started raising his concerns in a manner that are really not well served by his approach or style of presentation. I would caution his tendency to stray away from political debate into making personal accusations. I've said in the report, and I've said today, that if Councillor Hyman wants to ensure that this council acts lawfully, then I would have expected him to try and work collaboratively with officers to ensure that that happens. Now, instead of that, I've heard words like, I've got to be allowed to attack the council, and I've got to be allowed to publicly challenge, almost grandstanding. And so I am concerned about the conduct of this. I'm concerned about the wider conduct, and my position remains that I believe that Councillor Hyman failed to comply with the Code of Conduct at those 2 meetings. And I am a little disappointed that this hasn't been able to be resolved prior to coming to this standards hearing. And that's my summing up.
Thank you. Councillor Hyman, briefly, because you've already had a long opportunity.
Chairman, I'm responding to a question from Mr.
What you're doing now is giving us your final brief thoughts before we retire and make a decision.
Okay, thanks. Well, I'll sum up my position.
Brief
just for goodness sake. Mr. Chairman, thank you very much for allowing me to speak. I'd like to just clear up one point, if I may, in respect of the help that Mr. Oram has given, because I know he did try to be balanced in his in the reports that he produced. And it is in respect of, you have to excuse me, I'm trying to think 3 things at once at the moment. My head's not doing it anymore. He tried to put together a solution which no doubt he thought was entirely satisfactory and that I should have agreed to as a local resolution. But he was fully unaware that a workshop for habitats and EIA issues, which is, seriously what we need, was never on the cards, was not going to be allowed. We never actually, he has clearly been told that we did have one. What we had was an hour-long speech by a lawyer who was basically there to try and tell people I was wrong without answering any questions. And there was no opportunity for us really to get into any of the issues. And the proof of the pudding ultimately is that not one of the people here, I mean, obviously everybody here would understand the habitats issues if we'd had that workshop, and I would have been proven wrong instead of having been proven right, and so we didn't have that workshop, and it's never going to happen. So that's why I was unable to take up that. I always had to refuse, because for me to allow them to say Mr. Hyman has admitted he was wrong, I simply can't do that. I can say I'm sorry if you took things personally. I didn't mean it that way. And I can say, you know, I'm really sorry if you think I'm attacking your professional status, but quite honestly, you know, perhaps you should check where you get your information from. I don't want to insult people themselves. They seem to unable to admit they're wrong in the circumstance, and I can understand why that is, and I'm sure you can understand why people you can't admit things in the political arena, but it's not. I thank you for trying to get that organised for us, but it's never happened, so that's why I could not agree to that, and I can't simply allow the council to go away and say, Mr. Hyman has admitted that he was wrong, because that looks as though the issues which Farnham has been fighting on for so many years, saying, oh no, they were right all along. It's not true. We simply can't do that. So that clears up that point, but in summary of my position, as I think that I've demonstrated that the words used were neither offensive nor personal. I didn't say you this or anything that was actually personal about a person. I was only addressing the facts. The words themselves misquoted, you know, the word misquoted and the phrase which Councillor Isherwood objected to so strongly and required that I withdraw was completely innocuous and perfectly reasonable and normal, and I think it's ridiculous that we're here in view of that. But I do take on board absolutely what the independent person Vivian says, that my mannerisms, the way that I say it or something may be taken by people as being upsetting and seen as rude. I would ask them not to, because I don't complain about all of the stuff that people do to me. But I suppose that's you know, my fault. I should complain about everything everybody else does. Now, as far as I'm concerned, I have also demonstrated that it is our duty in law. I think I've had the admission, although it's like pulling hen's teeth, as I say, that it is my duty in law to push this issue. And it actually comes above the Code of Conduct, as far as I cannot see that there is any justification, and no one has explained to me why how the Code of Conduct can be considered to override the duty that I have in law. It certainly cannot. So, you know, I'm required to ensure that the Chamber makes the best decision that it can. As a councillor, I have a duty to try and influence my colleagues to make a lawful decision. And if I'm being prevented from doing that, I'm sorry if I sound a little bit rude in doing so. But as the Mr. Oram said, it was a fine line. We are constrained by those duties. I respect those duties, and I ask that everybody else does. And I think today you have possibly learned a little about that I am correct in what I'm saying. It's very difficult for the officers. You can understand the position that they're in, but it would be nice to get straight answers and people just to admit it, rather than have to wait for court actions to come through, or even to have to risk our own money and houses and the rest of it in challenging something when we're actually elected to the council to ask these questions and avoid all the trouble of going to a court of law. My real concern here is that the complaints, if upheld, would infringe upon my rights to free speech, my freedom of expression under HESAM and Article 10 of the European Court of Human Rights, preventing me from meeting my duties under the law, and my right to represent residents' interests. And that, I think, is probably the most important point here. It is what the complainants are seeking. We have seen that although we had initial denial, we seem to get denial of everything, it says in the documents that Mr. Bainbridge would have difficulty in putting lawyers onto committees or providing lawyers to committees where I was a councillor. So it's clearly seeking to have me removed from committees. And I think it's probably possible for Mr. Oram to also understand, therefore, why
I couldn't agree to a local resolution on those grounds, because if that was what I was going to end up with, you know, I couldn't make the demands for the remedy in the first place. I couldn't, you know, there wasn't a deal on the table that I could agree to. So I'm sorry we're here about that. But, you know, I feel that what is said at paragraph 6.6 and 6.7 in Mr. Oram's report, the Victoria Climbier, it was Lord Lamming in respect of Victoria Climbier, who said that we have we have the right to question our officers, whether they like it or not. And I would simply ask the panel to consider, how can you go against that? You know, how can you turn around and say, no, I'm sorry, when Mr. Isherwood says you're not allowed to question the officers, and we have to assume that what they say is right. Some people need educating, some people need training, they need to understand that that isn't the case. We are here for a job to scrutinise on behalf of our residents. So you know, that is my main issue, that it would infringe upon my right to represent the residents. Now, I do feel natural justice requires that all the constraints and the circumstances and the likely consequences are properly considered before we come to a decision. And I know I've spent far too much time on that side of it. But again, we've seen how a chairman and the Conservative group and officers are absolutely hell-bent in making sure that these issues are not discussed in public. I say all you've got to do, and I've said it all along, all you've got to do is tell me where I'm wrong, and I will apologise. I have no problem. If I'm wrong, I'll apologise, because that's the way I think everybody else should act. If they're wrong, they should apologise. So why shouldn't I? So tell me where I'm wrong. But the system doesn't allow for that. There is nowhere in the system where I can force people to tell me where I'm wrong. So maybe I'm just not learning. Maybe the only place I'm going to learn is when I've got a couple of people who are honest like you, say to me, hey, you're a bit tough on people, you're actually a bit rude, it does come across a bit rudely and things, and I take that bit on board, absolutely. But there is no way in here that I can actually get a resolution to the major issues that we have for our borough. And so, you know, it is, and I think you can understand with you know, when people put a lot of effort into try and combat what you know, some people see as great injustices in our borough, then, you know, it would be nice to have support in that, and some leeway in doing the job that I've been elected to do. I'm concerned about natural justice in respect to the makeup of the panel. I think I've made that clear. I think it would be far better. What I would like is for the panel to, I would expect the panel to have to go with what you as independent people said, either way, because I trust you on it. So I do have some difficulties with that, but it's not the way the system works, and I think I'm going to have to accept that. I do consider that it is somewhat perverse that the truth of the matter is not within the remit of the investigation. I feel I've been misled by the beginning of this, where it says we're going to establish the facts about this situation. I think the only fact that we have established about this is that we are not going to get straight answers from people in this chamber when we ask straight questions of them. It's a shame. And things need to be done. We need to change that quite clearly. It is about how we need to change, what we need to do, and I've understood what has been said to me. I apologise if I have made people in this chamber think that I'm insulting them personally, but I don't mean it in that way at all. But you know, as far as I'm concerned, it works both ways, Chairman, that if I've got to change what I do, then quite surely, you know, the number of occasions where the Council has been caught out on legal issues, but it still comes in here and it still tells everybody we never break the law. So the Council is completely incapable of ever admitting that it might do anything wrong. You know, I think people should just face the fact we are imperfect, and when the Council makes mistakes, they change their ways, and that's what this is about today. As far as I'm concerned, the Council needs to take on board that it must stop saying that we're always obeying the law when it quite clearly isn't. They've got to do what is best for our residents and for our borough. And I do think that unless the Council is now willing to turn around and admit, as they did in the first place to the independent person, that they were wrong, you know, we need to change our planning policy. We need to change a lot of the way things are done. And
I hope we can move forward from this to look at those issues in depth. I'd rather hope that today we would be able to get some truths out of it so that we could force them to do so, but it does appear we're going to have to force them through the ballot box. It would be nice if we had this, if we had a bit of help here. I have asked that the complaints be dropped in view of having since been proved correct on the issues concerned. The first matter, I think I've proven that I was correct in that one. The second matter, again, we've had the Sweetman judgment, which you know, the issues I've been fighting for years are correct, and they've always, again, today we've had them misrepresented to people in this chamber by members of the Conservative group who just try to tell us we never do anything wrong. Even when they've been caught out, they just can't turn around and say, yeah, we're sorry, look, we're sorting it out and doing it properly. They have to continue doing the wrong thing, which is exactly, you know, so they're in denial and they're carrying on. And frustrating as I find it, and yes, perhaps I'm a little bit rude to people who are doing this to us and have been doing for so many years, I have to apologise to them for being rude, but I'll never get an apology. Nobody will ever get an apology for how they are wrecking our borough, and I think we have to do something about that. They are crucial elements. The facts and the evidence and the law is what I've tried to bring, and what other Farnham residents and John Ward has helped to bring facts, the evidence and the law into this chamber, and we have been denied the opportunity to look at those. I do think people who, as a matter of public perception, are going to look at today's proceedings and just think, it's Waverley Borough Council. You know, they've known it, they've seen it for years, they're going to continue with it, and I think as residents we're going to have to turn around and show that actually we do need to start and take control, Chairman. So,
okay, thank you very much.
Thank you very much.
Thank you. You wanted to ask a question?
A few, if I... Councillor Hyman, let me try and curtail a few of the things that are going on. You said that you thought that Mr. Oram was a straight-up guy, and you then went on to say that you appreciated the way Mrs. Cameron had approached the matter, and you went a little bit further, actually, and you intimated that this panel should take on board what they had been saying to us. Could I just dig a little bit further and ask you to turn to page 75.7.3, and about midway through there, I'll let you get there first, page 75, 7.3. Midway through there, Mr. Oram says, having said that, I do not think that Councillor Hyman intended to disrespect the respective legal officers at the two meetings. That seems reasonable. Do you agree with him?
Absolutely, Chairman, yes.
Thank you. Could you stop there? It will be in your own interest, I assure you.
I appreciate that. Thank you very much.
Okay. He then goes on to say, and that he would not want... he would want to ensure that there were good working relations moving forward. Could you say yes to that as well?
Sorry, I would like to see good working relationships, absolutely, Chairman.
Thank you. Okay, so what we've heard today is we have had a comment from, not only from you, from a number of other people, saying it is the public perception that matters. And you made a very interesting comment when you said offence is taken rather than given. And I think you're actually spot on there, because this is, I think, where we've got ourselves in a little bit of a tangle. The independent person and Mr. Oram are not councillors, they're certainly not employees, and they have come up with a view which you have said we should consider very carefully, and I'm sure we will. Mr. Oram went on in 7.2, and I won't ask you if you agree with this, but I'll just put it on the line. He said, whilst I think Councillor Hyman's conduct did on this occasion cross the line, it is a finely balanced decision. And he goes on to say, Councillor Hyman's conduct would be viewed at the lesser end of seriousness. So his view is it's a minor thing, but it is a slight transgression of our code. Okay. You then asked a question, or you made a statement saying, I do not know what I have to do. Could I almost put it to you that you've actually almost done in some of your later statements where you're saying you didn't mean to offend, I did not want to insult, and I would apologize if I have insulted them? Can we park the major issue, which is not what you are here to answer for? You are not here and are not being asked to say, I was wrong. At the very beginning of this meeting, the monitoring officer said, an apology is not required. He then went on to say, and I might paraphrase him slightly because I wrote it down quickly, just to acknowledge that the way he expressed things could have upset people and be deemed not to have treated them with respect. Now, you've kind of said that already in your summing up, that you didn't mean to insult them, that you would apologize, although you weren't hereby being asked to, if you had insulted them, and you have agreed with Mr. Oram's report that you want a decent relationship with them in future. I would put it to you that if you could agree with the fact that you acknowledge that what you did may have been seen by them to be disrespectful, and if you could also come and say to us that had you insulted them, or had they perceived that you insulted them personally, then you were contrite, I will avoid the word apology, and that you really wanted your behaviour, and I would say theirs, but that's not up to you, to be such that there will be a good relationship moving forward. I would suggest that you have fulfilled what the monitoring office was probably asking you for. Circumstances, you did say somewhere, should be considered. I think yes, but no one is asking you to admit that you were wrong in any of your assertions about the habitats regulations, the SANGs, and the various things that are being considered by the Planning Committee. All I think you are being asked for is to acknowledge that the way you put things may have been deemed irrespectful by the officers, and in future you will try and put your very, very passionate things in a way that isn't perceived in that manner. And if you could come up with that as a statement, I have a feeling, and I haven't consulted any of my other panel members, that we've got to where we would hope to get. How do you feel about that?
I thank you very much indeed, Councillor Ward. You got about halfway through that, and then I got a little bit confused by, I mean, I was absolutely perfectly happy, because I felt to myself, I should be writing this down so that I can just turn around and say it afterwards, and then John's just done the work for me, so it's not a problem. And I think, yes, you're absolutely right in what you say, and you've put it very, very well. I didn't write it down, so I can't throw it back and say yes, absolutely. And unfortunately, but I'm slightly lost with the second part of it as to
the question as a matter of principle is that I have to consider what anybody else who gets elected to this council would be expected to do, and we have to set the example. Now, I have no problem with people like yourself, myself, Scotty, coming in here. Scotty's been in front of the managing officer as well. We're just residents, we're coming in here, we're representing people, and we don't have a party whip, so we're different, and yeah, perhaps we don't spend quite as much time as people who have been politicians or remain politicians, and they have their diplomatic skills and they say everything the way that we look at the facts, the evidence, the law, we bring it forward, we're trying to change things here. And I'm very firm that I am not going to say something or put in place a precedent which other people are going to have to try and stick to. And certainly I would not want anyone to think that they had to come into this chamber and put aside their personal principles, turn a blind eye to things in order to be able to get let off of silly, vexatious charges, Chairman. Because, I can understand how people have taken this and that, they can feel perhaps slightly hurt. But as far as the residents are out there, I think they want to know, the residents want to know, why are these people acting this way? Why are these people stopping residents from asking questions, controlling them? Why is it going on?
Councillor
so that we have to act in a way which isn't very helpful.
Could I stop you there? I'm sorry to interrupt.
I know I'm done doing some of your good work, Councillor Ward, but it is important that I do not feel we should put ourselves in a position where what we're saying is that people who have caused us great difficulties, we are apologising to them when what they're doing is far worse than anything we might possibly do ourselves. And so, I wouldn't want to go too far. And I know everything that I say is...
I take the answer to be no, which is unfortunate.
Well, I'm happy to look. I mean, this time of the day, I'm happy to agree with anything. It's been a complete waste of time for 2 years. I don't want it to go on. All I really want is for other people. I'm expected to sit here and say, oh, look, I might have hurt people's feelings. And yeah, I know. I mean, and I do care about that. But actually, why are we spending so much time on this where if people would just give a little time to looking at the solutions I'm trying to put forward to save this borough, instead of just constantly saying, no, you're wrong, we're going to carry on with what we're doing and not answering the questions. We're never getting anywhere if we treat it this way. And if I give in to the way that this council wants things to be done, then there will be no improvement. And it's the same with all the other councils are putting in a lot of hard work to try and change things. But, I'm told that the way I do things isn't the right way to do things. But, Chairman, there isn't a single person, I don't think, in this council who has over the years been as effective as I had. Not as a councillor. I've only been a councillor 2.5 years. But, in the issues, in fighting the issues, in getting changes made, improving things, saving, billions of pounds on the housing and that sort of thing.
Councillor, do stop there, because...
Being effective is more important to me, Chairman, than whether somebody considers that what I've said to them is well, they don't like it.
Okay. I mean, can I just... One thing, and I will be quiet then, Chairman. You've actually sort of said you don't want to insult and upset people. You've actually said that you would be sorry if you did. The fact that there is potentially huge problems in the council, some of which I may personally agree with you and some of which I may not, is something which you might here have drawn people's attention to and got the little cogs turning. But that is not the function of this panel. And I can only just sort of make a plea that you would accept the items that I put before you. Otherwise, the panel has to go away and consider things, and I think it would be most unfortunate. But I have to take it that what you're saying is no.
It's not a blanket no to what you're saying, but there were so many terms in what you said that it became difficult. I felt that it could be used against us. Mr. Chairman, the situation that we've got here, having exposed issues over many issues over the years, we have serious problems
Councillor
here,
Hyman,
and we should be addressing those issues instead of trying to force me to turn around and come up with some diplomatic words that keep people happy.
You've made your position clear, Councillor Hyman. I think we have no alternative but to retire and consider
I would have no alternative to put in
complaints.
complaints.
Please don't interrupt. and consider whether there's been a failure to comply with the codes of conduct. We'll be accompanied by the clerk, who will be taking notes, and if necessary, we will be asking the independent legal officer to advise us. In fact, probably be wise to come with us anyway. So we will now retire, and hopefully we'll come up with a decision shortly. But I can't say how long it'll be. Consider everything we've heard during the course of today. The panel heard evidence from Mr Taylor, Mr Oram, Mr Bainbridge, Councillor Isherwood, Councillor Hyman and Ms Cameron, the independent person. The facts about what was said by Councillor Hyman at the specific planning meetings and which led to the complaints are not in dispute. The panel watched the webcasts and have seen the transcripts of what was said. Councillor Hyman has set out a lot of detail about the background and his beliefs about the legal position in respect of various planning issues. Mr Oram and others pointed out on many occasions that their conclusions did not determine whether Councillor Hyman or officers were correct on these legal points, as that was not the issue to be determined. The issue was whether the manner in which Councillor Hyman conducted himself when challenging officers breached the Council's member code of conduct. Having considered all the evidence and taken into account the views of the independent person, the panel unanimously concluded that 1. Councillor Hyman was acting in his capacity as a member of Waverley Borough Council when attending the relevant meetings. 2. The allegations were set out in Mr Oram's report in some detail, including transcripts of the exchanges between Councillor Hyman and officers and Councillor Hyman and the chairman of the Planning Committee meetings on the 16th of November 2016 and the 29th of March 2017. The panel considered the members' code of conduct, and in particular paragraph 2. On 2.1, you must always treat member colleagues, officers, other organisation and members of the public with respect. 2.2, you must not conduct yourself in a manner which is contrary to the Council's duty to promote and maintain high standards of conduct by members. 4. The panel also considered carefully the officer-member protocol, and in particular at paragraph 20, where it is stated that members should, quote, avoid criticising officers, particularly at meetings open to the public or in the media. Avoid actions or words that may appear to others to be attaching blame to an officer, particularly when the officer is not present. And avoid words or actions that may serve to undermine the professionalism and integrity of officers. 5. The panel noted and were very mindful of the fact, as set out in the investigating officer's report, that the conduct is not intended to stifle the expressions of passion and frustration that often accompany discussion about the efficient running of the Council. The panel fully accept that members can and should be allowed to challenge officers. However, it is important that members do this appropriately and in a way that treats officers with respect. 6. The panel formed a view in accordance with the views of the investigating officer that Councillor Hyman's conduct towards the legal officers was not deliberately malicious. However, it did strongly appear that Councillor Hyman did not give any thought or was not aware of how his conduct might impact on officers. The panel was disappointed, firstly, that the complaints have taken so long to determine, and secondly, that it was necessary to have a hearing rather than to resolve the matter informally. Having heard all the evidence and representations and recognising the circumstances and context put forward, the panel found that Councillor Hyman's conduct at the relevant planning meetings did breach the member code of conduct and the member officer protocol. The panel agreed with the investigating officers and the independent person's views that Councillor Hyman's conduct crossed the line between challenging officers in an acceptable way and therefore breached the code. The panel do consider that members can and should challenge officers. However, this must be done in a respectful way. Having heard the evidence, the panel considered that Councillor Hyman's conduct was not respectful to officers in respect of the specific complaints and therefore breached the code. The panel wished to make it clear to Councillor Hyman that such conduct is not considered acceptable at Waverley Borough Council. 9. The panel carefully considered Councillor Hyman's rights to freedom of expression under Article 10 of the Human Rights Act. The panel were very mindful of the need to balance Councillor Hyman's right to express political opinions against the rights of officers to be treated with respect. The panel considered carefully the points set out by Councillor Hyman and the investigating officer in his report and the enhanced protection afforded to politicians. The panel considered that a finding that Councillor Hyman had breached the code should not represent a disproportionate restriction on his freedom of expression. And those are our findings. And we now have to decide on the next stage, which is what actions, if any, should be taken. And I would refer everybody to pages 49 and 50 of the papers before us. On page 50, it sets out in paragraph 8 what the panel could do. But as is clear from the third paragraph on page 49, the panel must give the opportunity to Councillor Hyman to make representations, in writing if he wishes, but I would hope we wouldn't have to adjourn for that to be put in writing. And we have to consult the independent person as to the suitable action to take. So perhaps it might be wise first to ask the independent member, the independent person, as to her views as to what would be proportionate in particular for us to do, bearing in mind that finding that we have found in accordance with the external examination report.
Thank you. Yes, I've been looking through your list here of possibilities, and I'm taking note that this, and I'm not sure if you still grade it the same, but it's a minor breach. So I don't know how that works, but assuming it's still a minor breach. And based on Mr. Hyman's statement that he provided yesterday and some of the words that he has said today, if he was prepared to perhaps provide a written apology to the people involved, that could be an option for him, you know, to accept responsibility. If he's not prepared to accept responsibility, then that won't work. But he did say when he was speaking just before this all finished, he was sorry for upsetting people. And as I think I've commented, I don't think he means to do this.
Sorry. Where in the list of things that we can do, we can't make someone apologise, and the apology has got to be in a way where you recognise you've been at fault, that you wish genuinely to give the apology and prepared to do something about it. And I don't think that is, an apology is contained in the list. I think the apology has to happen, as I understand it, on the step before a panel hearing.
Yes, no, I appreciate it.
I don't think we can make him apologise. If we did make him apologise, it wouldn't be a genuine apology, I think is the one view that could be taken.
Oh, yes, it would have to be voluntary, without a doubt. Then You know, the other thought I did have is, because there has been some progress this afternoon, perhaps 8.5 with some training.
And how about 8.1 and 8.2? I mean, I think they're fairly standard, but...
I'm not quite sure what is involved in publishing the findings. I'm assuming you just mean this all goes out in public to everybody.
Well, I can ask Mr Taylor what was meant.
Yes, I'm a bit out of my depth.
No. Well, it might be that, I mean, a panel haven't decided what should happen, but probably 8.1, 8.2, 8.5 might well be ones that we'll be considering carefully. Could you tell us, to help the independent person in particular, what 8.1 and 8.2 entails?
Within our arrangements, there's already an automatic process by which, as you've found, Councillor Hyman, in breach of the code, as I said at the start, the decision notice, so the notice of that decision that you've come to will be published on our website, will be made available for public inspection, and will be reported to the next available meeting of the full council. So I think that
so
to a degree...
8.1 and 8.2 will happen automatically?
Yes.
And on 8.5, if the panel was minded to consider training, I think it would have to be training not done by our own officers. And if so, how long might it take for that to be arranged if we should decide to follow that course?
So if you decided to follow that course, we would speak most likely with Hoey and Ainscough Associates, either to arrange training through them or have recommendations from them as to where we would go, and we could either look up an appropriate training opportunity for Councillor Hyman to attend, or arrange something bespoke if there was nothing in the immediate future.
So how long would it take, do you think? I mean, I appreciate you haven't looked it up, you know, because you didn't know what we'd be doing, but...
My guess, Chairman, would be that we would be able to do that within a month, I would imagine. But that is my best estimate.
Okay. Councillor Hyman, would you like to address us as to what do you think we should be doing by way of actions, or what we should not be doing? And are you happy to give us orally rather than in writing?
We'll watch the webcast, and you turn around and you say such conduct is not considered acceptable at Waverley. And I'm just wondering that if I agree just to sort something out, and I'll do whatever you say, which, you know, is pretty much the situation that's been hung over me for the past 2 years, then, you know, I don't think I want to continue with that any longer. I'd like you to give us something solid. We know you're going to publish the findings. We know you're going to report the findings in some way. But as far as the rest, if I don't know what sanctions are likely to be against me, then I cannot consider the consequences. If I'm likely to be to have, I assume that things like 8.7 is that's where someone has abused the internet system or something.
Yes,
so that's why it's, because that wouldn't be open. I haven't done anything with the internet system, so
no.
Can I assume 8.7 isn't an option? I don't need to worry about things like that.
I think you can assume quite a lot of these are not an option.
Okay.
So
what are options before I decide?
All 8 options are printed. 8.3 is a possibility, but probably the panel aren't minded to go along that route, but I can't say. 8.4 would not apply because you're not on the executive. 8.6, I would have thought, bearing in mind this is a minor breach, would probably be off the radar.
I'm sorry, there aren't any out.
And 8.7 and 8.8 would be the same, off the radar. So the only ones that we could realistically look at, I would suggest, are 8.1, 8.2, possibly 8.3, but unlikely, and 8.5. So if you'd like to address us on, I think 8.1 and 8.2 are foregone conclusions. Training, do you think that would be, do you have any objection to training?
Chairman, no. I mean, I thought that it would be an absolutely great idea. In fact, if you recall, my case has been that I thought that all members should have some training in the, particularly in the legal aspects. I'm happy to undergo training for the areas where I'm lacking, but only if it's going to happen universally, I think. I mean, I don't think...
No, we're not here to decide what the other 56 members of the council should do. We're here to decide what you should do.
Yes, indeed we are, Chairman, but nevertheless, I mean, we still have to make sure there's no point in only having one person who's acting correctly in the chamber, is there? With the fact that nobody else is up in front of you for, in this issue for their behaviour is because I haven't made complaints of the way they acted against me. Well, I understand, and I understand your decision. And
the only
we knew what it was
power
going to
we
be.
have is dealing with actions against you. This panel has not got the power to order sanctions against anybody else. So, 8.5...
well, are you asking me to just open my diary to you
no,
and let
I'm
you
not.
decide?
I'm just saying you are entitled to make representations to us about what actions would be appropriate.
I suppose we have to look at it from a matter of public perception, and they look at the list here, and I don't know that it's a shopping list any of them would think that there was anything on there suitable, really.
Okay.
I don't know, Chairman. I mean, obviously it's your decision, but I mean, this has been the difficulty throughout, that I haven't known what the outcome or consequences are likely to be, and it's very difficult to decide what you want to do if you've no idea what the outcome could be.
Well, I told you what the outcome could be. I mean, I've told you that 8.1 and 8.2 will be.
And can you tell me my other option then? Is that if I want to think about this, because I don't really understand. It looks to me like there's. If you end up in a situation here where you've spent a day doing something, there's nothing you can do about it anyway in the end. Well, the question whether we've just wasted our time. But are you going to, if you're going to force me to have some sort of training so that you can say I've been trained, I'm not entirely sure that that would be a satisfactory outcome in terms of residents' perception.
That's your view, and the panel have got to decide whether the way you have behaved would indicate that training would be beneficial to you. Is the consideration we have to make.
But that's up to you. I mean, how would I know whether?
Yeah, okay.
But I have no idea what this is. But I mean, I want to know what if you said that I can put something in writing, and I'm not sure whether it's worth doing it. I don't even know what I'm being invited to put in writing at the moment. So I'd like to find that out because.
Well, it's just printed on page 49 if you want to read it, which is the all part of the arrangements for hearings and complaints handling. We're just following the procedure. Mr. Taylor.
If it's helpful, Councillor Hyman, it's really some of what you've already been doing in this discussion. For example, you referred to some of the things listed there in paragraph 8, which you felt weren't relevant at all in this case, because they would be for other situations, and I think the chair of the panel agreed with that. It's exactly that sort of thing. It's looking at that list and giving a view as the subject member on which of those you think might be appropriate and which you think might not be appropriate.
Well, no, I mean, I'm looking through the list and I'm thinking that, the obvious option here, if Councillor Ward considers that I'm not suitable to be on the Joint Planning Committee, then, maybe I should be thrown off the Joint Planning. I don't know if he had somebody else who wants to do the job.
Well,
there are various options, and I wouldn't really want to, but I don't know whether I should discuss it with him or not, first of all, frankly, because it's pointless me putting him in a position which puts him in a difficult position.
Well, Councillor Ward will be part of the decision process on the panel. So if he puts himself in that invidious position, it'll be partly of his making. But as I'm saying, I don't think we've necessarily decided that we're going to do that at all. But if you say, look, I would resist the panel, I would not be happy with the panel removing me from any of the committees of the council, because I don't think that the breaches that have occurred were so grave as to cause that to
I think
be
I've
necessary.
made that perfectly clear. I think it's ridiculous. so
okay.
if you're more than welcome to. Obviously, it's your decision, and what I think actually, makes absolutely no difference whatsoever. Obviously, so.
Okay.
What I'd want, and I've made it clear all along, is that if sanctions are being made against me and my behaviour is in question, then we have to look at what everybody else was doing at the time and see whether their behaviour is appropriate and what residents should do about this situation.
Not in our brief. Sorry.
Nothing's in our remit, is it? No.
No. Okay. We'll
if I'm having training chairman, then I'd expect other people to be trained similarly.
Okay. So we'll consider what we want to do. The panel have carefully considered what actions should be taken as a result of its findings of fact and have concluded that the following should occur. 8.1, publish its findings in respect of the member's conduct. 8.2, report its findings to council, that's Waverley Borough Council. And 8.5, instruct the monitoring officer to arrange training on member officer protocols and working relationships on the basis, for the member, that's for Councillor Hyman, on the basis that such training is carried out within 42 days. And clearly the monitoring officer will make suitable arrangements for that to happen. Thank you very much indeed for everybody attending. Thank you, Mr. Hodgson, who's come all the way from Hampshire and is now got to get through the snow to get back again, and to everybody else present, and in particular the independent person, where you've had a very long day. Thank you very much indeed. Thank you.
Hampshire's nearer than Farnham.